that here in a second. Yeah, so there's that. Sorry, guys, bumped the button. Sorry about that.
Why do sirens always come when I'm recording or
Right?
streaming?
I don't have the screen either from you.
Oh, I'm so sorry.
I just
I
like
mean, this is no
I
this is no
began my
di-
introduction with like, I don't know what we're doing because there's no screen. I don't know yet.
It's not my fault. And whenever I stream, I always forget something. Usually involves like being muted, but I
It's all
mean,
good. We're good.
but we're good now.
We
Yes,
got
we are
this.
very good. Okay. So, I I had a video on our because even though he doesn't contribute to the playlist, it is our playlist.
I do not,
Um,
but yes.
I'm not trying to throw you under the bus. It's just that we have
Hey,
like, well, we're making improvements. I have not been adding stuff like I did in the
hey.
past. So we're down to 69. 69 is a good number.
We have 69 more videos.
Anyway, um, but
Come
we
on,
had a
folks. We love this,
video.
right? Come on. We love this.
You're weird. We had a video. This is erratic woman creates chaos and delays in 4 court cases with 2 different men.
What?
And then I had put my mouse over it and saw that it was like a part 1. So I had to literally go dumpster diving for the
Dumpster
second
diving.
video.
Yay.
Well, it was dumpster diving. I mean, this right here, and
Oh,
stop, you know, stop fucking around,
I
right?
don't know what that was about. Hold on.
This is about to be 4.5 hours.
Oh, yay.
So yeah, we might not even get to other videos with this at this rate, because
Yeah, we might not today, guys.
or
But we'll
if we do,
see.
I'll squeeze something in. I do have a racist Karen who got what they deserve. That's directly after one of the videos. So.
Hey, check that out. We might have some fun. That might actually be
Well,
a lot of fun. Who knows?
well we can close out on that one maybe because it's right underneath. All right, so we're gonna start with part 1, and I'm probably gonna just let it roll into part 2. I don't even know if we know the judges or anything in this one, but it's also like the YouTuber that we like. So I see pauses in our future.
Yay.
Actually, I wish all the ads were this quiet. That would make my life so much easier. All right, here it goes.
3 moments.
Oh, this is a parenting plan.
Welcome to Looking at Legal Stuff. Today we have 6 hearings in part 1 of a case with a woman who has 4 different court cases going on with 2 separate men. First case is with her ex-husband, who is asking the court for a restraining order to keep Mum from seeing the children due to her erratic behavior and suspected drug use. Mom rants and raves in court and spends most of her time complaining about her other cases, while she accuses Dad of conspiring with her recent ex to try and ruin her life. What does the judge think of Mum's behavior? Let's find out. Make sure to stick around for part 2, where we'll cover 3 more cases with the same woman and her recent ex. I'll link it for you down below.
All right. Any other quick matters, strikes, or
I'm sorry not to be funny, but we already know the judge, at least starting off, because we've noticed that these judges don't stay. But it looks like that attorney, the attorney I just saw in the screen, is attorney we know. So we're starting to come across like these people are starting to look familiar,
Right.
like a little too familiar. And I should not know your name.
setovers.
Your Honor, on number 2, this was a return hearing for restraining order. I didn't receive anything from the opposing party. I don't see her present on Zoom. I don't know if she's present in the courtroom, but I just wanted to let you know I didn't receive.
I'm so sorry. I can't help myself. There's the attorney Baldwin's husband.
Mm-hmm.
We've never seen
Dun
him.
dun dun.
We've never seen him. Well, I saw him briefly on another. He wasn't talking. He was just, I think, probably transitioning off of from a docket. But we've never heard him before.
No, we have not.
So, okay, I'm sorry. I'm trying to be. I'll be.
So I don't know what the posture will be today. So
I didn't see a response. I did have a quick conversation with Commissioner Carmi. I reviewed the rulings and reviewed.
This first hearing in the case with the ex-husband since 2022, but they have a long history of high conflict going back to 2016. So I'm assuming what Jesse is the husband? Maybe Jesse is the only man that's here. Maybe Jesse. I don't know. Any thoughts yet? He muted.
You might be. I don't know. My brain is not here with me yet. Give me just a second.
I'll let it play. I just get excited because we're recognizing people and trying to get brain situated.
Yep, I gotta get my brain moving. Sorry, guys. We'll get there in a moment.
The proposed orders I have don't have any signatures on them, and I don't know if that was because of how they got to me, but they.
I've only listened to a tiny bit of the hearings with this woman, and all I remember is a lot of yelling.
Oh boy. Brace yourselves. This might be a loud one. If you need to adjust your speakers, please do so now. Heads up. Speakers may need to be adjusted. The only warning you will receive.
I like the smiley.
Appear to comply with Commissioner Carmi's ruling, so I was prepared to enter those today, having received no objections.
We're not on for entry of orders today. We're just on for the reissuance of the restraining order.
Oh, and is this not Enerson and Anderson?
No, this is number 2. I'm sorry.
Oh, sorry. Mine are all jumbled in here. I apologize. I was. Is it Gronitz and Gronitz?
Correct.
Sorry. Okay. 16300483-5. The only, okay, so strike everything I said. The note I have here is, I didn't see anything in the file regarding service.
She was served on the 13th, and that was filed with the court. I can tell you here. I'd have to thumb through my book here, but I can tell you. So she was served on the 13th. The proof of service was filed on
The 24th. So it came in yesterday. It must come in after I reviewed for today. So
Yep.
I do see that. Okay. Is there,
At Amazon, skills training and apprenticeships can move hourly employees into higher paying roles, like robotics. And that's a win you can count on.
You're on. Come on! Oh.
I don't have anything from you, so I'll have to draft that post after the docket unless you provided something.
I didn't. What I was thinking is we're already set for temporary orders and adequate cause in this case on August 8th. So what I was going to propose to the court is that if you could just fill out the reissuance form, the carbon copy form until the 8th, I think that makes most sense for efficiency and whatnot right now. So if your honor is willing to do that, I don't need to submit a form. I would be fine with that order.
And reissuance of a protection order to August 8th. Let me just make a note for myself. And that's on, that's already on the docket for the 1 o'clock docket.
Correct, for temporary orders and adequate cause, yeah.
All right, I will grab one of those forms and fill that out and file it after court.
Gotcha, and just to be clear, it's just a restraining order reissuance within the family law, case, not a DVPO, I just want to be clear on that, so.
I will mirror, because it looks as though,
I can also have my staff just draft a new one of what we filed and email it to your JA, if that would be more helpful, I'm happy to do that.
if you want to do that, that would be perfect.
Yeah, we can do that right this afternoon, so.
And then I'll just, once I receive it, I'll get my signature on it and get it to the clerk's office.
Perfect.
All right, thank you very much. We'll see you on the 8th.
Thank you, Your Honor. Your Honor, I think my matter is number 1 through 4, if I saw correctly, it's the Gronich case. I didn't receive a response, none was filed, and I don't know if Ms. Gronich is either present on Zoom or in the courtroom.
I think I got an email that she was gonna be appearing from our lobby here. So, Ms. Grant,
I can, yes, I am here in the Zoom office at the courthouse.
all right. So this is cause number 16300483-5.
Looks irritated.
Several issues, a restraining order, motion for adequate cause, and temporary restraining order along with a temporary order were all filed. I noticed service was affected on the 13th of July, and then there was an amended service for the 24th of July. Ms. Gronitz, there was no response from you in the file. What is your position?
I came to court Monday to put in a notice of appearance, went home to find out that my email had been spammed, and I shut my computer down. And I spent last week recalibrating. I'm here with documents to submit, but I haven't had a chance to submit because I have 3 other court cases I got hit with at the exact same time. So I have filed a protection order against abusive litigation, which is what this is part of. Case number 23200764008. I haven't heard back from that.
I don't know what she's talking about. Today's case is with Jesse Granitz, her ex-husband.
Oops.
No info there.
That's a problem.
No,
You
she's just
don't
confused.
know why you're there? Come on.
Well, no, the YouTuber says they don't know what she's talking about, and she's saying that she was hit with 3 other cases. So I don't know what that has to do with anything.
Disillusion of
But,
marriage with children? Interesting.
Yeah, they're getting divorced,
Oh,
and his kids involved.
gotcha.
Yeah.
I left an abusive relationship. I found refuge. I was sought out by the law by my ex-husband.
Okay, so now this one, the protection order case is against a different man. Okay, so oh,
Interesting.
it says against a different man, but it says his name versus her. So did he do it? Because this is in May,
Yeah.
but this court now is in August, so I don't know.
Now Jesse is jumping onto that lawsuit with this plan. So I intend to fight this in full. However,
Okay, and then she did it says we will cover the 3 cases she has with this other man in part 2. I don't know what CIR stands for. Oh, committed intimate relationship. Okay. I don't know what that means. But
It's the
she did
same
something
as-
against
isn't-
him.
Isn't it the same as cheating?
Hold on. No. What?
Curious.
Hopefully this won't be this bad going forward. So we gotta do these stops to figure out what the hell something is. Let's figure it out. Committed, intimate
Hold, please.
relationship. All right. A committed intimate relationship in Washington. Okay, so it's a Washington thing. Is a legal concept that grants some marriage-like rights to unmarried, long-term couples living together. While Washington does not recognize common law marriage, it uses the CIR doctrine to allow for equitable division of property and debts upon separation, similar to a divorce. Courts evaluate factors like the duration of cohabitation, pooling of resources, and the intent and stability of the relationship to determine if a CIR exists.
Oh.
Okay, so basically, this is Washington's version of a common law marriage.
Right.
Okay, so look, we learned something new, even though none of us live in Washington. Well, we don't live in Washington, so it's kind of irrelevant to us, but we learned something new. So that's why she has all these cases. And she's been divorced, apparently. I'm assuming the divorce. I don't know. That's weird. They said that they've been going back and forth since 2016. So, what is that? 7 years?
Yeah, kind of
How did
interesting.
I don't hopefully we get a little bit more. I don't know. I don't think Game is interested in this stuff, but I like background information. I like to know everything.
I mean, I don't mind.
I think
That's
I
why
think it's
you
a
would make a
therapist
good
in me.
lawyer. There, I said it.
Well, it's a
And
therapist in me too. Like
I mean, I've never
I like
done either one of those. So
the therapist in me likes the sort of like the needing to know the information to make a decision, right? Because I can't make an educated decision without having the history. And with a patient, you have to
true.
know their history. It's not always necessarily what they're presenting to you in the moment. You have to know how they got there. So I think that's part of it. And then yeah, the legal secretary, assistant, whatever you want to call me, in me also likes the details. I like to know the facts. So it's yeah,
Makes sense.
can't help it. Look, and the therapist in me is also analytical, right? So I can't help but like want to like have the information to analyze. It makes my brain hurt more often than not, but I mean, I
Right.
can't help it. Even when I don't want to know something, I still have to know. It's just one of those things.
About 3 months behind their little litigation strategy game, and I am recalibrating as quickly as possible.
Did you say
So I
retaliating?
am at the courthouse. I need to go to the copy machine, submit about 200 documents
Oof.
of previous CPS reports from 2016, about 6 to 7 different protection orders, and an entire decade of attempts by Jesse to remove my children from my care, always at inopportune moments when he should be helping me, and instead he's unhelping me. I left an abusive relationship.
That's a word,
I'm living
unhelping.
in my own house with my own money. He's claiming meth. I've never done meth, and he knows I'm anti-pharmaceutical because I won contempt of court in 2018, and he still owes me for that. I'm anti-stimulant, and he's claiming meth orders, even though I got drug tested on 6/21/2023 because my previous guy was trying to claim meth.
There is nothing about meth, but she has a 2017 DUI and 3 charges in 2023, including 2 violations of a protection order. Okay, so I think
Oof,
I
that's
like that
not
they
good.
give us. I like that this person gives the date.
Yeah.
So this is August 8th. And um, I just wanted to make note of the fact that this is the second hearing and it is August 8th, because this YouTuber is showing us stuff that's after even this hearing date. So,
Correct, but that's what she's talking about at the moment.
I know, but no, but she's not, because this stuff didn't happen yet. Some of like what's this stuff about the protection order stuff, this didn't happen yet. She did this shit after this hearing. The hearing was August 8th. She violated the protection order
Wait.
on August 15th. And then came back to came back to court. Oh wait, no, excuse me, I take that back. She violated on August 10th, so she violated 2 days after this hearing, and then she violated on the 15th. That's crazy. And she had just violated prior to in April. Oh no, I take that back. I'm sorry. So this was an obstruct law enforcement officer. So that's separate. But she still violated the order after this hearing, which to me is crazy.
My brain's
'Cause
like,
what
huh?
happened? You went to court on the 8th. You got riled up and upset, and then plotted plotted something to go after, whoever, because it's not showing us who she, what protection order she violated. But I'm sorry, that's hilarious.
That is
Nothing
pretty
like
funny.
someone claiming that they don't, nothing like someone claiming they don't do things just to show that they did it after. They claim they didn't do it. They don't do stuff like that.
I didn't do it. I don't know what you're talking about.
She's delusion. She's delulu. Okay.
Just a little bit.
So I haven't had a chance to get caught up, Your Honor. I'm counterfiling. I will take your advice on the best approach. Otherwise, I can submit my whole package tomorrow after I hit the copy machine today and go pay for 500 copies.
Why do you need
Ms.
500
Rush?
copies?
Well, Your Honor, I mean, given that she's indicated that she's been able to file all these other actions I would submit in the last month, she should have been able to file a response to our petition. I mean, I don't know if you're on to review the record, but there's some really concerning issues going on here, which is why the court granted the ex parte restraining order. The declarations from third parties are not from my client, kind of corroborating her behavior and the concern about what's going on. I don't know anything about any protection order she's filed against my client. I know she has one against her right now with her last partner. My client, I mean, if we're gonna set the hearing over, I would just ask that everything remains status quo and the restraining order just get continued. We would prefer that the matter just move forward and adequate cause be found and our temporary parenting plan be found or be entered, because we did ask in our plan for her to be drug tested and have an evaluation. And so, I mean, that could move things along. If she's recently been drug tested, that would also be helpful to see, obviously, but that's the concern. The other concern is obviously, and we submitted this for the record, where she's living is not there's no water, there's no electric, there's no sewer, that kind of thing. And, the kids are not safe in her care right
That's
now.
not
So,
good.
I'll defer to Your Honor on whether you want to send it over or just move forward today.
So here's what I do. I'm gonna extend the restraining order. So Ms. Rush, if you want to submit one like we did last time, so I'll extend that, keep that status quo. I'm gonna give Ms. Gronitz until the 22nd. We'll set this over to August. Wait, do we have a space on the 22nd, Madam Clerk?
So you see, she violated the protection order after this.
Yes.
Okay, so we'll set this to 2 weeks to August 22nd. Ms. Gronitz, the only thing
Not good.
I can't give you any legal advice from the bench, but I will tell you everything that you file, you also need to make sure that you get a copy to Mr. Rush for her review as well.
Yes, Your Honor. Like I said, last week I had technical difficulties. I got here in time on Friday to submit the protection order. I was here yesterday for court. I attempted to do the summons and complaint for dissolvement of the committed intimate relationship, which is my way of securing the $200,000 that Nathan Jeff Bob owes me, and
Oh
is
my
using
God.
legal measures to try to prevent payments. So I have secured
This has nothing.
protection for
You
my
see the
children and
attorney's
myself.
face?
Yeah.
I am
This
submitting
has nothing
paperwork
to do with this
get me
case.
paid. And the funny thing is
There's too much
I left
information
an
here.
abusive relationship,
Mm-hmm.
and I'm on my own property that I own outright, zero mortgage. I don't have any debt. I have money in savings to fall back on. I mean,
Sorry, guys. I'm gonna finish up my lunch, and I'll be back in a
I'm
second.
working on
With
that
camera.
battle. That battle, unfortunately, is completely tied to this. Jesse has been helping Nathan cover his affair with another woman, trying to strip me of my house,
Oh my
the money
God.
that I'm owed for my contributions in my place for 5 years, and now he's attempting to strip me of my children. I accept the extension because I would like the chance to get caught up on paperwork because they've had 3 months ahead of me. I would like to request that Jesse be in charge of all of the children's school supplies and all of their uniforms and everything that they need to get ready for summer or for school this year because, well, quite frankly, I believe it's his responsibility as the parent who's taking care of them. Generally, I do that for them. I won't be doing that this year, and I would like him to. And I can be back at court on the 22nd. What was the time?
1:00 PM.
1 o'clock. Is that Zoom or in person?
It is Zoom.
Okay, because I thought today was Zoom. I was prepared at home, came to the courthouse. After I looked at my paperwork and it said in court, I'm still new to this lawyering. I have a PhD in business management contracting. The code
Oh
law
my
has
God.
changed. I am working as diligently as I can. I have
My
completely
head
shut down
hurts.
my entire contracting business for summer.
She talks
Give
too damn
this
much.
Case 100%
That's
of
what I
my
mean, my head
dedication. I let
hurts.
the thing with my ex.
Okay.
This has 100% of my dedication right now, Your Honor.
All right, well then I expect to have everything filed in a timely manner and we'll be able to proceed on the 22nd.
Thank you, ma'am.
All right, thank you.
All right, thank you, Your Honor.
I mean, I think we've gotten to the point where we can tell when people are like under the influence now.
That's the essence of driving. Lawfin.
Yeah, pretty much.
That's okay. I'm glad you were able to make it back. So we're here on 3 different
Hearing
issues: a temporary order,
3.
adequate cause, and a restraining order. I set this over from the 8th to today for you to be able to file a response. We did receive, I think this is where we got cut off. I received about 110 pages of medical records and about 20 pages that were
I'm sorry.
some information
Pages of
that
what?
Dr. Harg wrote, as well
Medical
as
records.
some
Oh my
aromatherapy
God.
information. So we're ready to proceed today on these 3 motions, and because the petitioner in this case is the one who filed this motion, we'll start with Ms. Rush. So thank you for your patience.
Thank you, Your Honor. So I would, again, as I mentioned earlier, normally because of the timeliness.
I can't help myself. I'm so sorry. This attorney, she looks like you know the movie Inside Out with the one who
Yeah. Yes.
the emotional one, the one that's always sad.
Mm-hmm.
The glasses is just
Yeah. Yeah. Exactly.
and he looks like something I can't think of what it what is that character that has like the slicked hair? I can't think of the name. I don't know the name of that one. But I'm sorry. I have to amuse myself, so I apologize.
Of her filings, I would have filed a request to strike, but I don't think they're entirely relevant, quite frankly. And my client and I were concerned about kind of the filings are a bit erratic and not on topic. And so it just goes in with kind of our general concern that she's not in a place where she's exercising clear mind or good judgment, especially when it comes down to the kids. So that would just be kind of my preliminary comment. I will also note that there's currently a permanent DVPO against Ms. Gronitz with a former partner. It's my understanding that there's a warrant coming out for her arrest or multiple for violations of that. So just bring that to the court's attention, obviously, because that affects where she's going to possibly be. So just going back on this, we have Eden, 11, Leo, and 9. My client is primary parent under the existing parenting plan, and mom has 5 nights every 2 weeks. We filed for modification and received the initial restraining order on July 10th. Ms. Gronitz was served with the initial paperwork on July 13th. So at this point, we are, over basically almost exactly 5 or so weeks after this was all filed and served. So there's been plenty of time for people to get their ducks in a row. At the last hearing, because Your Honor agreed to kind of set over the restraining order and just continue it, we did agree to continue everything, to today. So what we are asking for is we're asking for what it amounts to a major modification, but it's not a custody change essentially. What we are asking for is that the kids just remain solely in my client's care. He's had them, obviously, been primary parent, had them solely at least since this restraining order was granted. And we are asking for 191 factors against mother, or that those at least be reserved pending multiple evaluations.
Okay, so I'm glad that because this is the second time we've heard of 191, but it wasn't explained last time.
No.
So examples of 191 factors is physical, sexual, or emotional abuse of a child, a history of domestic violence, substance abuse or addiction, willful abandonment of the child, mental health issue that pose a risk to the child, lack of emotional ties with the child, a pattern of anger or conflict that negatively impacts the child, certain sex offense conviction. So now that also makes some stuff clear about the last case that we saw where they were mentioning the 191.
Correct.
That's a lot of factors, but all these factors are things that should not even happen.
Right.
When it comes to a parent and their child.
We did ask for a drug and alcohol evaluation with collaterals in our initial materials. Given some of the behavior that I've seen from mother, I would add that I think the court could benefit from some sort of psychiatric evaluation. So I would just kind of note that for the court. I'm not sure, based on the comments that we've received from multiple people, and I'll comment in just a minute. One of them was from a good friend of mother's. The comments that we've received about her behavior, I don't know if that's attributable to substances. I don't know if it's attributable to a hard, her going through a hard mental health time. I don't know. And so I just think that we owe it to these boys to get that all sussed out. Basically, what led up to this and culminated in us obtaining the restraining order was kind of a couple of years of escalating behavior. And I'll point out to the court some of the issues my client raised in his declaration. Ms. Grunitz does have past substance abuse issues. Those have been acknowledged. Those were addressed in the prior case. In addition, her parenting has just kind of gone downhill since the last parenting plan was entered. We basically, we filed information from the kids' pediatricians that Eden, ADHD, mom refuses to medicate him. He's on the autistic spectrum. Eden also has allergies. Mom refuses to take him to his appointments, brings cats around him, and doesn't require regular nightly showers. I know these things sound little and almost petty when taken one by one, but I think what I'll sum up for now and what I'll say in the end is all of these things, in addition to her current behavior when taken in aggregate, are what leads to adequate cause and entitles my client to a modification. She refuses to take the kids to appointments on her scheduled days. We provided documentation showing excessive tardiness and absences on mom's days. She just stopped doing schoolwork with the boys, period. She knowingly exposed the kids to COVID and didn't tell my client until after the fact. My client and a couple other declarants indicated that she showed up on what appeared to be high after or at Leo's birthday party, brought a stranger who people also commented appeared to be high. To avoid service on the protection order with her most recent significant other, and this is in the police file, this is the police reports, mom had the boys hide out in the woods so she could avoid service. When she needed materials from her prior partner's house, she had the boys climb in through a doggy door at his house, and this is all while the police were trying to serve her with a restraining order. There's been multiple times where she doesn't pick up the kids from school on time. She refuses to exchange at the courthouse, which is required by the parenting plan, and which my client has asked for to just provide kind of an equal playing field. My client was kind of satisfied that she seemed to be getting a little better with her last boyfriend, who provided some help and stability, but now that they've broken up, it appears she's kind of spiraled again. We indicated to the court that she does own a property, but by all intents and purposes, it's a shed. There's no electric, water, there's sewer leaking outside the property, apparently. This is the Mount Brinion property. She certainly has no appropriate place to house these children right now. That's not an appropriate place to house these children. My client indicated that in recent months, the boys have regressed to some bedwetting and to some pant wetting, which is also concerning. And he will have them, he will continue them with their regular doctors and seek any other additional help that they might need to deal with the current situation. So we did file a declaration from my client's mom about a specific incident where Ms. Brown came to the house and multiple people approached her or observed her impaired on something. The words used were nonsensical and that she was creating a scene. There was 911 called at that incident, and 911 police also provided a standby at school later that week. I think what's also telling is that we did provide a declaration from Patricia Peterson, who participates in the cabaret follies with Ms. Gronitz and has done so since 2016. She ostensibly is a friend or at least an acquaintance of Ms. Gronitz and voluntarily wrote this for my client because her observation of the last couple of months or her recent interaction with Ms. Bronitz has been, she's been erratic, they've smelled alcohol in her breath practices, she's been disruptive, spinning out of control and out of sorts. Those were her words used to describe Ms. Bronitz. So I think what my client's asking for here is that, and I think it's appropriate that she receives some evaluations to determine what's going on. You know, like I said, and I'm not trying to hammer her, she's going through a tough time right now, but I think her appearance and kind of her demeanor at the last hearing, I think combined with what she has filed in this case, where she's really fixating on her ex-boyfriend and I guess the CIR that she's filed against him, you know, she's just not tracking. You know, if my kids were taken away from me because of allegations like this, you'd think you'd see things like, here's a lease on a new apartment.
She seems to think she has a $200K payday coming from the other case. Okay.
Here's a recent hair and nail test.
I mean,
you know what I mean? All
sounds
those
like
kind
a
of
good
things
payday
that
to
we
me.
would see.
It probably doesn't exist.
She's a business
It
owner,
doesn't.
that she has a high level of education. So when we don't see these come back in the file, that adds additional concern. So we are asking that the kids continue to reside primarily with my client with no contact with mom, that there be adequate cause found.
Sorry for the spin. I dropped something on the device recording.
Where to undergo some of these evaluations that we've talked about so we can find out what's going on. My client, Eden and Leo need their mom, but they need her when she's safe and healthy. And I just think it's very clear that right now she's not.
That's just it's your look, your rules. Disney Lily forever. Inspired by Stitch. What's your dream style?
Continue to open those arms out to the sides and back down to your hips. Beautiful.
I don't understand that commercial, but okay.
Thank you. Ms. Bronitz, any response?
Right.
Oh yes, I sure do. Would you like me to start with my original or the response to what I just heard?
How about a response to what you just heard?
Okay, that's
Right.
probably the easiest.
And Your Honor, just at the outset, I, for the record, I have to object on anything that wasn't filed with the court. I know you're giving her leeway in responding today, but just had to make that objection for the record.
I'll note that. Thank you. All right, go ahead, Ms.
Yes,
Bronitz.
and to comment on that specific objection, I will illustrate that I am currently in 5 court cases, all of which are proposed to me in a couple of weeks. I'm not a lawyer. I'm an accountant and a business manager, and I have thousands of documents to spread out between 5 different court cases, which is why the petition with Mr. Bopp was approved, because the wrong attachments were in the wrong case file, because I have 5 different little boxes. I have to put 1,000 different documents in. That's what's going on in the court system. I have an update about what I'm doing to manage that, but just to respond to Ms., who am I speaking with, Rush? Doesn't matter. Whoever was just speaking.
That was rude.
The first thing that I recognize in every single document, I've read over 300 submittals given to me in the last couple of weeks, and there, I don't see any concrete evidence to support one single thing. I see about 8 different people claiming meth. Of course, I got that taken care of right away when Aaron Winkles called the sheriff after I left court in a Zoom box the day I left the hospital visiting a friend who was just beat up. Yeah, I probably was a little erratic that day.
Right.
But I didn't have custody of the kids, and I wasn't on meth. I was at the courthouse getting records, which is how I know Winkles called, and I went 2 days later and got a drug test. Because that's not the issue at hand. The issue at hand is my committed intimate partner went rogue and found somebody else to adorn his affections on, and I am now the victim of breach of contract in numerous ways. So today's issue is, number one, Mr. Grant piggybacking off of Bob's effort to hide his affair. I don't even care about the affair. I just want paid out of my relationship to go live my life with my children.
Wow.
I do better on my own without the men arguing in my life. I don't need a man. I don't want a man, but I'm owed half of $1.5 million portfolio, which I still have to assemble. That was in priority place over this court case. Okay. They knew I already had 2 court cases when they submitted it. This is already abusive just to submit this amount of paperwork for me to have to respond to. I had to shut down my entire business this summer. And I've done nothing but attend to dozens of documents. And if I've had the capacity to email them to you, you'd have had them 3 weeks ago. I'd buy a new printer. I've gone through 8 reams of paper.
Lady, this is way too much information.
1,000 pages on you. I have to get them organized, labeled, submitted to the right
It's gonna be a
court, 5 different
long
courts,
case.
the right attachment. That's what I'm working on. So to respond to what evidence do they have, I don't see any actual concrete evidence. Everything I'm going to be supplying is medical reports from doctors. I have 200 pages of CPS and sheriff's reports from Desi Poland and stuff for the last 10 years.
Okay, so 817, aromatherapy brochure and article by Dr. Steven. You sent in an aromatherapy brochure as evidence, just saying.
Great narration story of this whole rinse and repeat
What?
cycle, Your Honor. I saw it coming.
It's not
And I
evidence.
have all the text messages to let you know I forecasted it. I was a victim of domestic violence with Jesse. I went through all of the abuse training courses, and when Jess became violent, I recognized the symptoms in him. I vacated my residence. And you know what I did? I vacated my primary residence to my secondary residence. When I divorced Jesse, I left him a business that was operating in the six figures every year and a house that we owned free and clear that he sold for $380,000. He doesn't own the business anymore, and he lives with his parents. To me, he was never the driving force of our success. I took my success with me. I left him a good package to work with, and he's crippled it. And he's living with his parents. And I'm grateful that he's living with his parents, because at least Eden and Leo are getting the care that they need when they're with Tim and Leanne, when they are not being coerced by Jesse to spank them because he told them to. Leanne's statement, Leanne knows for a fact that this entire situation, my emotional duress, how many psychologist reports did you read where every single one of them is because my partner was instigating emotional duress deliberately by not respecting me as a human being and a partner in my relationship, and that's what happened with Jess. I don't need a partner to disrespect me. I'm better off on my own. I own my property free and clear. I have money in the bank. I'm camping out this summer because I didn't get a paycheck from my partner.
I'm not sure what the blank pages
I have the
are.
money to rebuild.
I don't know.
Jesse has no idea what my condition of my residence is. He's not supposed to be snooping around my property. So he doesn't get to lay claim at what condition it is, because he shouldn't know. I've had it for 5 years. I'm a custom builder. You don't think I've made improvements? Come on. I've been operating as my business location for 5 years. Yeah, I had to add a kitchen. Well, I just added a sink and a stove, which I already had on site.
I can't believe this,
And I
that they're
told
just
him
letting
all
her
this
talk.
summer. I let him know what I was doing. The fact that he's taking advantage of my situation, or attempting to, the only thing he's trying to take advantage of is the fact that I had my residence storage. I had to pull him out, and now I have to submit him to you guys in your fashion, which is not my fashion. My fashion is integrated where everything connects and everybody knows the whole picture. They're specifically using the court system's little polls. Oh, you can only have these attachments in this file, if these attachments aren't in the right file, and we're going to motion to continue. Well, I'm sorry, Your Honor, I don't have all my attachments in this file. So, if that's the only basis that you can go off of, well, then you'll have to go off of them again like the judge did before, because he doesn't have the capacity to make the actual decision that he knows is true. He has to go off of the limited paperwork submission. I don't have that limitation in my business. I look at the whole picture every time, every element involved, on every element decision I make.
Oh my God.
It's all important.
This is painful. I feel it for her.
Yeah, two
Yep,
of my
it's gonna be a
ex-husbands
minute.
fully engrossed in the court system. Not one single mention of Michelle. I submitted documentation. She exists. I don't care she exists. I just want paid for my relationship. I'm glad Jeff had somebody to take care of him, because I was just nothing more than a nurse last year.
True.
I thought Jeff was dying for 6 months.
Fits well.
Oh,
The movie.
wow. Ooh. That I would love to see. Paid for your relationship. I don't think you're in that sort of business. Huh.
I've been upset about it.
Oh God. Uh-oh. Now we got the crying.
Had I known he'd been taken care of, I would have been gone. This winter, when he changed, I thought he was
Oh
sick.
boy,
He's
here
not
it
sick.
comes.
He's just fine. He's just distracted. He just doesn't want to pay me for the effort I put in. He's still there. Am I just... Did I get connected? I'm kind of...
Nope,
You're just rambling, lady.
Okay, I'm sorry. Let's see. So yeah, the substance abuse has nothing to... My erratic behavior has nothing to do with
All right.
substance
I
abuse.
will be right back.
Well,
I'm here, but you know what I mean.
You think his dying starts attacking you. You're giving nothing but your best to him. It's upsetting. And that's viable for anybody who experiences it, in my opinion.
Now, for the record, guys,
According to many
most judges
professionals
won't
who I've been
allow
speaking to
this
about
much
the
talking.
situation.
I'm surprised this is actually occurring.
And have record I submitted to you, I dealt with this Jesse. The petitioner. Okay, as far as Eden goes, I don't care what Jesse has to say about Eden's allergies. I have the same allergies. I know when Eden is allergic. I know how to remedy him because I've been doing it his whole life. I use essential oils. I use aromatherapy. I use menthol, peppermint. And this is a conversation I had with PJ. Tinctures. I turned half the people onto them, and they were thankful for it because it opens the airways. It allows you to breathe. And when you're exercising for 3 hours a day, I was exercising 8 for Cabaret. I did 14 numbers out of a 22-number show. PJ did 2 because she lacks the capability to do what I do. She can't hear. She can't follow the music. I don't hold it against her. I'm not making reports against her. But she certainly doesn't get to judge me for anything because she can't keep up. So yes, I tend to Eaton's allergies because I suffer the same allergies. It's not fun. It clogs our nose. We can't breathe. I have low blood pressure to boot. I have to clear my airway. I've found through my doctors several alternate medications to pharmaceuticals because I'm not a pharmaceutical person because when I got pregnant with Eden, it made me throw up and then he threw him up. It doesn't work for our bodies, so I go with it. I didn't make it up. I was fine with it before it didn't work for me. It doesn't work for me now. I have alternate solutions. They're over-the-counter solutions I can buy anywhere. They're not prescription-based. I don't have to go see a doctor. And they're like $10. It works. I don't understand the problem and why I'm being scrutinized for essential oils. Doctor's appointment. Yeah, that one is a fun one. The day they submitted, I didn't take Eden to his dentist appointment he shouldn't have been at. He had a pre-scheduled counseling appointment at Tam O'Shanter Park with Liz, his ABA counselor. And Jesse, just decides to schedule a dental appointment and then criticize me for not attending. What I do? I was going to cancel the appointment with Liz, but no, that was the day she could do it. So, okay, well, take the boys to the dentist appointment. I'll go meet with Liz, and then you bring the boys to me when they're done. Jesse refused to bring the boys to me after their dental appointment, and I was sitting at the park with the counselor. So he doesn't get to pretend like I wasn't making my appointment. I was at my appointment, the first appointment that's scheduled a month ago. So I'm sorry, but that doesn't work. Knowingly giving my children COVID, I'm not even going to respond. Woods, doggy door. Okay. Yeah, so I asked Jeff for payment on Mother's Day, and he started yelling and screaming at me, so I left the house with my Eden. I avoided going back Sunday night. We went to my mom's, and I dropped the kids off. Sent Jeff several messages to pack up the kids' stuff because they have school uniforms that they have to wear. Mass uniforms on Thursday. It's a specific outfit, and I only have a couple. I didn't think to grab them on Sunday. I thought I was going back Monday to move out amicably with Mr. Bob, both Monday and Tuesday. That was the schedule. I have it recorded via email like 2 or 3 times. He's the one who went rogue and tried to use Chloe on his protection order just to not have to split stuff. So when he refused to get my stuff, I made contacts to try to coordinate and then decided it didn't work out. I asked the boys if they were fine with getting their stuff, and they said, yeah. I'm friends with the neighbors. I parked at the neighbor's house. The boys were supposed to go in the back door. Leo likes to climb in the doggy door. I didn't tell him to do that. It's a habit. We put the cat door in, and he just likes it. He's a little kid. So I'm not going to take responsibility for him crawling through the doggy door, but I take responsibility for the fact that I had to take my children to a house after asking Mr. Bob to pack up my stuff. I didn't want to be there to begin with. Yeah, it seems that they have a lot of people making statements. If you'll notice, there's a specific trend in all of their comments. I know the court system operates off of if you use drugs, if you use weapons, if you use, there's a couple other things. The red flag systems in the court system. And then they have their symptoms, the black eyes, this, that. My counselor notes in my sessions I have an eye condition. So them making comments about my sunglasses, I've been wearing sunglasses since I was 10, every single day of my life. It's not going to change, no matter how much they criticize me in the court system about it. But it doesn't mean I'm high on drugs. It means I have an eye sensitivity. Guess what? Eden does too. He doesn't like to be in the sun either. You're going to say he's high on drugs? Certainly hope no, but not. But he is high on stimulants. Jesse's in contempt of the court right now.
Oh my God.
I'm turning it out to 28 pages of our
We're
case
still talking.
court thing. And there's at least 2 to 3 times I've taken him back, and he hasn't even paid. He hasn't even bothered to pay me the previous time he's taken me to court. But here he is ruining my entire summer. Plan with my kids to do it again. And he's not even fighting himself. He's having his friends and family doing it like he always does. Hide behind them. Okay. I don't know, bedwetting. I have having problems with bedwetting, but according to Mr. Maher, child abuse statement, it is a symptom of abuse. So if Mr. Garnis is experiencing that in his home, he should look in the mirror and figure out what he's doing wrong. Because I don't have a problem with bedwetting. The kids love it here. They have their own space. I have 2.5 acres for 2 children to do nothing but help me build a house for 10 years. That's the whole plan. Mr. Garnis doesn't want me to have that opportunity. He's been trying for 15 years to strip me of my property, strip me of everything I've earned. I walked away and handed him everything he could possibly ask for. I just went and rebuilt. I was willing to do it with Mr. Bob until he's chasing me down the court system. Now I have to submit all this paperwork. I have better things to do than play court, Your Honor. This is not, I can do it, and I'm doing it. Patricia Peterson, yeah, we had a whole, it's not this Patricia show, it's the Jamie Donovan show, because she physically assaulted me after practice, threw me in the hallway and tried to chew me out for
Lord.
helping a couple of friends who were having an issue with the sewing room.
Sorry, guys.
One gal was coming down with COVID, the other gal was leaving. I offered to just make a list.
They're just letting her go.
Solutions for everything. Oh, what do we need to do? Let's
She's
make a list.
responding
And
to
everyone
the
can pick out what they want
100
to do,
and
whatever's
something
left over, well,
pages.
But look at his attorney's face.
Yeah.
the girl who needs to leave.
Both
that's
attorneys are like,
charged
good
to leave
Lord.
Oh no, that's the ex-husband.
I let her know straight up she doesn't get to dictate my relationship.
That's the husband.
Yeah, might be.
That's my rule. I manage.
No, I'm telling you, that's the
Jesse
husband.
wanted to think he could manage my relationship. Mr. Bob started thinking.
There's
he
only
could
one
manage my
attorney
relationship,
here,
and he
and that's
started
his
interfering with
attorney.
My relationship with Chloe. I
She's
bought
like,
her flooring against
good
her
God,
wishes.
why?
How dare I buy his daughter flooring? when
And
he
but
told
they're
me not
just
to? She picked it out. She bargain shopped for it. She paid $1 a square foot instead of $5. She had friends show up and clean up
She
the
is
room.
and I think
responding
the
to
judges,
everything,
the
though.
judges like
Because
probably
I
sitting there
decided
reading
it
something
was
else or doing
in the
something
last
else
year, it's been-
and just letting her talk.
Struggling to find finance
That's
and
the
accounting.
case with most
that's-
judges.
Growing number of
That's what's
companies
happening. The
embracing
judge is
outsourced
looking at
finance and
something
accounting.
else.
Mhm.
She's multitasking.
Yeah.
Textual. But he also had all these doctor's appointments, so I thought it was related. Apparently not.
This is gonna be the longest like
whoever
55
the,
minutes I've ever been in.
Petition party mentioned where they don't want to hammer me with court cases, then why are they filing this right now? It's strategic, Your Honor. I just accepted service to 2 other packets served to me in the same packet, so I'm assuming
See,
they're together.
with me,
I show up to court.
I wouldn't
blatantly
care
for
because
this.
I'm getting paid
I've had to do
anyway.
so much research to get caught up on what these guys have had months to prepare for, and they're working with 2 different lawyers who are in the
Yeah, but the judge has other things to do.
Yeah.
It's not
You know
about
the
what she's
judge
getting
is
paid
doing
for.
getting my
multiple
attachments
stuff.
in.
Yeah, but they have other cases.
Yeah.
They can't just sit and let somebody ramble and just keep going and going and going.
I get it.
Yes, the husband now is paying for this rambling if it goes, past a certain amount of time. But nobody has time for and she's talking about, she's not even necessarily focused specifically on her ex-husband. She's sitting there talking about the other man too, and she's just going on a tangent.
But the clerks are really annoyed by me because I keep bugging them about how to do it. My business reporting doesn't look like the court reporting, and I have to modify my system to adapt to yours. And it takes some more time, and I'm making it. But everything about this case only indicates the abuse that I had to deal with Mr. Grant, and the abuse that he's blatantly supporting Mr. Bob putting me through for himself when there doesn't need to be. I just want paid and left alone. They're chasing me down. They're terrorizing my business yard, my mom's house. She doesn't even live there anymore. Can we all put it on the record? My mom doesn't live there. Please don't go bug the people who live in my mom's house. I spent the entire month of June and July moving out of. And I'm with my parents out of 20-year house while getting chased down by these 2. I'm supposed to be building my sister a house.
Oh, now it's
now.
whiny.
I have other things to do than fight for the money I already earned and the kids I made and the kids that I love, and he has no right to even keep doing it. So I'm not sure what the final answer is today, Your Honor. I don't know what limitations you have per this court system. But as far as I'm concerned, there is no concrete evidence here to support anything they've said. Everything they've said is nothing but abusive, and I've supplied the one and only statement that means anything. I'm not on meth. I'm not on drugs. I'm on an independence kick to get out of an abusive relationship, and I have all the means and devotion and tools at my hands to make it happen. I will make this happen. If it doesn't happen today, I'll find a way to make it happen in a different court. I don't know your limitations, I'm sorry. That I couldn't get my paperwork to you to make a better decision.
All right, thank you, Ms. Gronitz. Any response, Ms. Rush?
No, Your Honor, I just know that a lot of the allegations she brought up kind of insinuating against my client were predate the existing parenting plan that was entered in 2020. So there's no one, anyone restrictions against him or either of them, quite frankly. And as my client noted, as I summarized, you know, he didn't go after her until things started getting really, really bad. And so that's where we're at. And I think that if it's a result of the breakdown of her relationship, okay, we need to identify that and figure out how to make that, how to fix that. If it's a result of something else, we just need to get to the bottom of it, because I think that, like I said, her behavior, her speech pattern, everything is, you know, when there's something going on. And I mean, I've been doing this long enough, I know Your Honor has too, that it's just not safe for the kids to be with her right now. Luckily, my client is a protected party. You know, CPS has not gotten involved. There's been nothing dramatic like that because he has the kids, and he will continue to make sure they get to school and everything else that he's been doing since he's had them in his sole care for the last, you know, almost month and a half. So, like I said, we haven't had a chance to respond to a lot of the allegations that she made. I don't know how much that matters, because a lot of them do either predate the existing parenting plan or kind of have to do with her relationship with this other gentleman. I would just note, you know, kind of finally for the court, I heard about 90% of that about her having to fight for what she's owed from her ex and what she's owed from, you know, his estate or whatnot. And I heard about 10% of that about Leo and Eden. And so I just think that mom's focus at a bare minimum is elsewhere right now. I think there's, you know, there's things going on, and we would just ask that, number one, the restraining order be continued. Number two, the court find adequate cause and enter the subsequent order, and then the court enter our proposed temporary parenting plan, which does have basically no visitation pending some eval. So that's what we're asking the court today to grant.
All right, based on all the information that I have received, there's a pretty substantial amount of evidence that has been set forward and filed by, of course, my Odyssey just froze. The petitioner in this case. I do have some concerns. That's, I think, the reason why the restraining order was entered in the first place. There is a motion for adequate cause in this case, as well as the continued restraining order, and just to enter a temporary order based on those two requests. I am going to make a finding of adequate cause. There's something is a little bit amiss here, and I think we need to figure out what that is. So I will make that finding. Additionally, I'm gonna do something a little bit different than what's being requested, but I will have the restraining order. I'll keep that in place. Make a finding of adequate cause. I'm gonna allow mom to have visitation, supervised visitation, and professionally supervised visitation until, and that's, I'm gonna give up to 4 hours a week. And then order the evaluations as requested. Once those are completed, then we will start looking at everything all over again.
So just to be clear, so the professional supervision, is that at mom's cost?
Yes.
And then the substance abuse evaluation and the mental health evaluation, those are with collaterals, and are those at her cost as well?
Yes.
Okay.
This is gonna be an awesome game, guys. I still can't believe you also bought a new Shell Brothers home. After seeing yours, how could I not?
What was that part? Evaluation?
Ms. Gronitz, it was just clarifying that some of these services, the court is ordering that you will be paying for those, but my office will draft orders that specifically encompass the judge's ruling and send them to you so you can review those.
The word was the last phrase you said was what? I'm making notes.
Collateral
Can you just
input.
repeat those?
Collateral input.
Collateral.
Okay.
Collateral input. Okay, thank you.
And then in order for you to get those orders drafted, make sure that Ms. Gronitz has had an opportunity to review those. Which would be a good presentation date?
I would normally say 2 weeks, but I think I'm out of town because it's the Tuesday after Labor Day, so maybe 3 weeks.
All right, we'll set a review for presentation on the 12th of September at 1 p.m.
Do I have a chance to add additional attachments at this time, Your Honor? I've only given you like 1 out of like 20 packets.
If there's anything that you feel that you need to file as part of this case, I am not, I have no say in that. You can file whatever you want to file, whether.
Well, I guess okay, I had a packet ready to submit today as a submission. Is that still appropriate, or do I need to file a whole different packet now?
Unfortunately, I can't give you any legal advice about what that is. I don't know what information you're trying to submit, but if you feel it's important to the case, you're free to submit that to the clerks as part of the court file.
Okay, I have thousands of packets to paper submit to the clerks that I am trying to get there. I'm running out of time on this because they jumped on me. I've had like 2 weeks to catch up, or what, 2 to 3 weeks to catch up here on paper. They're winning because I can't get my attachments in. If I have to file new forms or whatever, I'll do that. But I just need to know, can I still just submit attachments for this case, or do I have to file a new? Okay, I'll look it up. I guess I'll get the, you know that there's like 28 pages of this going on in your court system. This has been going on for 10 years. Every 6 months, Jesse files with you, and I have to deal with it. I'll go look it up. Is there anything else that we need to review?
Your Honor, real quickly, did you want her to undergo a drug test too, or wait to see the outcome of the evaluation?
Just the evaluation at this point, and then.
I already did the drug test.
Well, if you have a results of the drug test, you can file that and give a copy to Ms. Rush.
I did. You have it.
Your Honor, I think that was a blood or urine test, which obviously doesn't go back as far as we're looking at. So I think she did take one in recent months that I saw come through, but.
Okay.
I took a meth test 2 days after Erin Winkles called me in on meth in the courthouse.
All right.
Oh, see, I knew I saw her name.
That's okay. That's fine.
And I'm not.
That attorney, Erin Winkles, is in this one too. I knew I saw her face. So she's you know, the thing is, she's getting probably I want to say bombarded, but I don't mean it like in her defense. But she's probably getting thrown a lot of shit at her for the other kid and the other partner that she was with. So she's, and I don't think one has to do with the other, but we won't know that until we see what judge is on that one too, right? But she's being asked to probably do the same things in both cases.
But I don't have access to all your other court cases in this docket on this case.
It's in your, it should be in this file. I gave it to them last week.
If it's there, that's fine. I'm not ordering a drug test. I'm ordering an evaluation.
Okay, I'm sorry, Your Honor, it's so frustrating.
No, and I understand you're frustrated, and I'm trying to be patient with you. There's going to be
I apologize.
No, you're fine. Miss Rush is going to complete an order, send it to you so you can review it and ensure that you understand everything that's in it. And then on the 12th of September, we will come back and enter that order. And if there's any questions you have about that order, you can raise those at that time. Okay?
Can I ask about the emails? I'm not in Cowlitz County.
Ms. Rush, do you have an email address for Ms. Kronitz?
We've communicated with her via email. I think she refused to accept email service. So we've had to be having her serve with everything. So, I mean, I'd agree to reciprocal email service if she would agree to it, but.
Are you willing?
What happened is I opened an email, during court. I was receiving emails and it shut down my entire electronic system. So I had to, revamp my entire electronic system. I have a new email. Do you have that on file? Cause I submitted it. The Mandy Granite thing. Right. That was part of my issues with getting all of the documentation in. I was out of electronics for almost a week.
Okay, well, we'll update that one in our records, and that's what we use to communicate with you. So, and then, Your Honor, I think I can probably from your ruling, are you reserving on 191 factors at this time?
Yes.
Okay.
Pending the.
What are 191 factors? Do I have to look that up too? Okay.
It's part of yes, it's part of the statute. It'll be in the order. Essentially, it's a determination if there's any limiting factors on a parent's ability to parent. That's the shortest version of it, I think. Okay.
Yeah, I went through this now. Okay.
All right. So September 12th at 1 p.m. All right. September 12th at 1 p.m. 1
Thank
o'clock.
you. I really appreciate it. I apologize for the communication issues. I'll just call in next time because thank you.
Thank you.
All right, thank you, Your Honor.
Okay. Gronitz and Gronitz, 16300483 on for presentation of order.
Yes, Your Honor, I'm present for Mr. Gronitz.
Oh, she changed her hair.
I don't have an order. Did you submit one?
We did, yeah, we submitted, I believe, last week. I can resubmit them. We did send them to her, right after the hearing, so she's had them for a couple of weeks and we've not heard anything about these orders. I understand she's filed separate, documents about something else, but we received no response to the form of orders.
I have not seen any either. Madam Clerk, do you have any knowledge? I only got 3 orders for today's.
Uh-oh. I can have my
We
staff.
didn't
Go ahead.
receive any paper orders.
I apologize, Your Honor. I thought, like I said, I thought my staff sent them last week. Would it be acceptable to email them over shortly after the hearing, or what would Your Honor prefer?
Well, they've already, I do show proof of service. If you want to just resubmit them, the same way you submitted them last time, and then those can be sent back ex parte. There's been no, the only response that's been filed by the respondent in this case has nothing to do with the order that we're entering today. So, I think we can, I feel comfortable, and there's proof of service in the file that we can enter those ex parte at this point.
Okay, great. I will have my staff submit those. Thank you.
All right, thank you. 3 continuances.
Yes, Your Honor. My name is Amanda Hartman. I'm appearing on behalf of Deanna Rush for number 2, the Gronitz versus Gronitz motion.
Right, 16300483-5.
Yes, we've received an email from her indicating she wanted to set this over to next week.
Is Miss Mandy Gronitz present?
I'm not sure if she's on or not.
Yes, can you hear me?
I can, yes.
Oh, okay. Yes, Your Honor, I'm present. This is Mandy Gronitz.
Okay, and you are requesting a set over at this point, is that correct?
Actually, I just reviewed the file, and I could just make a quick change on my request, and we could settle the matter. Or we can set it over next week.
Okay.
But we are in communication. I have received new information, and we are communicating about that new information that does affect this case.
I'm so confused.
Addiction gets between you and what you love. Once monthly Sublocade.
Okay.
My request
My
is
brain
that
hurts.
instead of advancing me lawyer fees, that the petitioner pay the upcoming litigation expenses for the GAL.
Yeah.
That's my request.
Wait, when did the GAL come into contact?
I'm going to have to object to that. There's no motion for a GAL right now.
Well, in this case, they're requesting that I be denied to put in further motions, and I ask that request be denied because I should maintain the ability to defend myself. I haven't even showed up to court on this case yet, and so I would like to retain the ability to show up to court. I am preparing motions. I do, however, have a really heavy caseload for pro se litigant and 4 different dockets. I have 4 different court dates just this week. I've been in 18 court dates in 9 weeks, and I have 200 different line items to process for those 4 dockets. So I'm handling a lot of information. They're all interconnected, and it keeps stalling. But the specific request for my litigation and my attorney fees, I can rescind that request. We can deal with this a different way, or we can set this over. I'm not sure the appropriate course of action. But I don't really want them to pay me. I want them to pay the litigation expenses coming up specifically, because that's what my request is kind of preparing for.
Okay, so.
They have put in a motion to move,
Okay,
and I will be.
ma'am, when I start talking, you keep talking, and we need to not do that. So hold on a second. So today, the only thing that's on your cause number is a motion for advanced lawyer fees and costs. And so that's the only thing that's on for today. So my understanding, I'm talking still. So my understanding is that you're not wanting for advanced lawyer fees, you're just wanting to move forward on the request for costs as in if there's a GAL or something else upcoming. Is that correct?
Yes.
Okay. And I don't know, Ms. Hartman, if you are stepping in for Ms. Rush this afternoon and you expected it to be a set over, if you're able to deal with that, or if you would be still requesting a continuance.
So we're still going to request the continuance for next week. We had a written request, so we expected this to be a set over, and that's what I was prepared for. I believe Deanna would like to participate in this next week.
Okay, so next week unfortunately isn't gonna work because well, long story short, we don't have enough judicial officers to handle all the dockets. I have a doctor's appointment that's been scheduled for 2.5 months. That's next Tuesday at 2 p.m. So I shut the docket down at 6 matters, and I can't set it to next week. The week after that is already closed because we're maxed out at like 24 cases. So the next available date would be the 31st. Does that work for everyone at 1 p.m.?
That would work.
Ms. Kronitz, does that work for you?
I'm sorry, I was grabbing my calendar. November 30th?
No, October 31st, so 3 weeks from today.
Oh, sorry, okay. Wrong month. So Halloween?
Yes, at 1 p.m.
Is there a penalty if I just rescind this and readdress it when we do the motion to move? I'm not sure how that works, but well, actually, that'll probably work over because we'll probably be dealing with the motion to move at the same time, so I can coordinate my paperwork to match that.
Well, and it sounds like if you're in communication with Ms. Rush, that's something that maybe you can discuss with her between now and the 31st. So I'll set it for review. I'll set it for review of your motion for attorney's fees for the 31st at 1. If you file another motion, it can get added to the 31st, great. And we'll see what we have to work with on the 31st at 1 p.m.
Thank you.
All right, thank you.
Thank you, Your Honor.
Gronitz and Gronitz, 16300483-5.
Sure.
And this is on for review.
No.
And Ms. Hartman, any updates?
I believe this is just on the respondent's motion for attorney fees.
Mandy Gronitz present, can you hear me?
Yes, ma'am, we can hear you.
Which makes no sense because she doesn't have an attorney.
My understanding was that when we were here on the 10th of October, she was withdrawing that request. Is that in this cause number? Is that correct, Ms. Gronitz?
Yes, I'm
Okay, unfortunately, you just cut out, Ms. Gronitz. I don't know. Could you state that again? You just muted and then unmuted. Yeah, if you want to try again.
Can you hear me now?
Yes.
Motion to strike lawyer fees, strike that. My situation has dramatically changed.
Okay. I have, so when we were here on
the move today.
She didn't ask you.
What was that again? I'm sorry.
They put in a motion to move with the children. Is that getting discussed today?
No, my understanding is that has been noted on for.
Dad and the children are moving?
I mean, he was living with his parents. Maybe he had his own place.
Fast across the street.
I don't know that a date has been set for that yet. Do you see, Ms. Hartman, a date set for
Interesting.
that?
No,
I believe all we've done is
She said that he's living with it. She said he was living with his parents. So what would be wouldn't he eventually maybe move? Right?
Depending if the parents move, I guess. But yeah.
I mean, he wasn't gonna live with his parents and raise his kids for the rest of his life. So, I mean, now she didn't say where he was moving to.
True.
But inevitably, he would eventually have moved.
Sorry, guys. Excuse me.
While we haven't set a date yet.
Okay. So Ms. Gronitz, no, that's not being addressed today. That is yet to be noted up for hearing by the moving party. And then they would have to serve that
I was
date
just
upon
going to
you.
comment, my life is in imminent danger, and I approve the move because I can't see my children until I'm not in danger anymore.
Oh my God, lady.
How to find the right car for you.
Oh my God.
Cars.com.
So she's not even like going against the move. But I'm noticing everything about her. Everything is about her.
Poor me. Poor
Everything
me.
gets.
Poor...
But not even a poor me. It's just a like she's saying. Like he's putting in he's planning on moving, but my life is in danger, so I'm okay with it.
Right.
What the fuck does him moving have to do with your life in danger? Oh.
Well, I'm sorry to hear that. I don't. I hope you know who to contact.
I don't want to sound dismissive, but this sounds more like a mental health crisis than is a physical one.
If you are in imminent danger, that there are resources available to you, and 911 is always an option if there's imminent danger. So please use that if it's necessary. If you do find yourself in a situation where you can contact Ms. Rush's office and you are in agreement with the move, you can contact them to let them know that. At this point, it's not before the court. So I'm not exactly sure. It just says a review hearing today, and I don't know that we have anything to review. So please, Ms. Gronitz, take care of yourself. And then I guess Ms. Hartman, I'm assuming you or Ms. Rush will get that noted up in the near future if it's not agreed upon by the parties.
Yes, we will.
All right. Thank you very much.
Thank you.
Oh, so I think that puts an end to that.
Heinzman and DeGruber Evans. This is 21-300-60408.
That was the last time this couple was in court. Mom did not object to Dad moving with the children, and there haven't been any new filings in the case. As far as I can tell, she isn't seeing the children at this time, but I think that's probably for the best until she gets some sort of treatment. She seems obsessed with her other 3 cases with her current ex-boyfriend, and she spent a lot of time in this case talking about how the 2 of them are ganging up on her. So come and watch her other cases in part 2 to see how far she takes this. The link will be in the description box below.
So I wonder, who does Ms. Winkles represent? Does she represent her, or does she represent the father? Because you know what I've noticed, and I'm sorry, guys, I'm letting this play out because the next video is our next video. What I'm kind of curious about is, or not curious, but I know because we've seen the Attorney Bliss before,
It's your look, your
and we
rules.
saw
Disney Illy
Attorney
Forever, inspired
Winkles
by Minnie
before.
Mouse. What's your dream style?
Restless partner keeping you awake?
We've seen them represent the mothers,
Our sleep experts can match
and
you
we've
with a better
also
mattress.
seen them sort of leave a case for a mother. And it's kind of like not really clear why. We never found out why she lost her attorneys, though we do find out that, you know, I don't know. I don't know what happened. We don't know what happened. Well, she claimed she couldn't afford attorneys, but whatever, right? So it will be interesting to see them in this case representing a dad, because I don't think that that's her attorney, because she didn't have an attorney for the other one. And I'm also kind of curious. I'm gonna just look real quick before we even get started. what the dates of this one is. So these dates sort of intertwine with the other ones up until November. So like these first 3 hearings were somewhat in between the other case.
Okay.
But everything else is after.
Okay.
And there's 14 hearings. So she had a lot more shit going on with this common law relationship than she did with her own husband. Which, you know, in itself is slightly hilarious, but let's see how this goes.
Welcome to Looking at Legal Stuff. Today we have part 2 of this saga, with 13 hearings covering 3 different cases, all with the same ex-boyfriend. Her ex has made 2 motions, one for a protection order and another to compel the return of his belongings, while the woman is suing to try and establish that she is owed money because they were in a committed intimate relationship, which is like a common law marriage. The woman has constant meltdowns in court and refuses to participate in the discovery process by repeatedly making false claims that she can't send them any information until she finds time to create spreadsheets for her auditor, despite no auditor being involved in the case. And besides, how is she supposed to find time when she has so many cases? What does the judge think of her crazy excuses? Let's find out. Don't miss part 1, which covers the first case in this saga where Mom is in court with her ex-husband. I'll link it for you down below. This video will switch between hearings for separate cases. I have labeled each hearing type at the top so you can follow along. Mr. Bopp has 2 cases before the court. The first is a protection order, but those are not streamed. I will share the details of that case with you at the end in screenshots. The second is called a writ of replevin, and this is the type of motion you file in civil court. If you want to be able to return with the sheriff to collect personal belongings that the court decides are yours. You need a motion like this when the other party is refusing to cooperate.
Okay.
On the flip side, Mandy is suing her ex for money, claiming that they were in a CIR, a committed intimate relationship, and she also claims that he was her employer and is refusing to compensate her for services in remodeling the kitchen. You can check the label at the top if you're unsure whose motion it is.
Oh, so this is not even a child custody or anything.
Bopp and Gronitz, do we have everybody here on that?
Okay, so
23-2,
the streamer label.
53908.
That matter's ready, Your Honor.
Can you hear me?
I can, thank you. Is it Ms. Gronitz?
Yes, this is Ms. Mandy Gronitz.
Okay. First question, Ms. Gronitz, did you have any objection to what's being requested?
Okay, so this is the second hearing in the case, but nothing happened at the first one. It's a show cause. And it says takes no action, counsel to renote. I don't know what that means.
I have objections to everything.
Okay, so a replevin, return of personal property. A replevin is a court action to recover the possession of personal property. Personal property is any property that is not land or buildings. It allows a person to request an order for the immediate delivery of their property after a hearing. A judge can decide who the rightful owner is and then issue an order, sometimes called a writ of replevin or an order awarding possession. That allows the sheriff to go to the place where the items are and take the items. The replevin process is complicated and can be expensive. So that's kind of crazy because there's like 13 hearings, or give or take, because there's a protection order situation, but there's 13 hearings just over getting property. I mean, I'm assuming this must be really important property that you'd want to go through this amount of hearings with this clearly unhinged person when you could just probably replace the stuff. But we'll see, right? Maybe some of his stuff is not replaceable.
Like a marriage
I have
certificate.
objections to the entire case. Did you receive my declaration response? Do you have that?
I do.
I submitted it.
Right, I have that. My question is what the request being made today is for the court to handle these 2 cases together as opposed to 2 separate cases, since they're interrelated. That's the only decision in front of me today.
Today is regarding the Let me pull it up real fast. Order for consolidation.
Correct.
That's today's. Okay. Yes, I object for the order of consolidation. The purpose of filing the committed intimate relationship is it's a family law issue. We're currently in civil law defending, well, they're this, so they're separate cases, Your Honor, and they need to be deemed separate cases. As far as judicial efficiency goes, I have a degree in efficiency, and it would not be efficient to consolidate these cases because of the elements that have not yet been successfully submitted for your review regarding what they have submitted.
What the fuck?
Grip.
That just made no sense.
Precision.
My brain
Essence
hurts.
of driving. Lawfin.
What you have done here
If a judge gives you,
will never be forgotten.
orders to return personal
We
property,
need to fight for what's
return the
ours.
damn thing.
Well, we don't even know if it got to that yet.
Yes, Your Honor. Actually, all areas of family law are under civil law. Family law is just a separator that comes between them, but everything that is a family law case is a civil law case. Committed intimate relationships are obviously judicial born. There's no legislation. We're talking about pure case law. These are black and white issues, especially when there are no children involved, as there are no children here. The reason, the purpose behind family law court is really because you have so many of these hearings and they have to get into details with guardian ad litems and parents and children. We don't have any of this. We have a purely financial case that also has the extra added on issue of whether or not there was a contract for the purposes of a remodel of a home. So we have three issues. The first one is replevin. Who has better possessory interest in the chattel home, the items? The second one, was there a contract for the construction or renovation of a home? And if so, has that been breached? And number three, is there a CIR? All of these three questions have to completely independent. You can't have one you can't have one and then the others have them as well. We have to figure out all these three together to figure out which is actually the issue in the case. And really the only place that that's going to happen is on the civil docket, because you have issues with contract and you have issues with whether or not there is the need for a replevin or conversion. Really the only other minor issue that tends to go to the CIR, which is really a fact question, was there an intimate relationship? Everything else about the entire case would come under a civil law docket. It makes sense to not have three separate cases. It makes sense for the purpose of the parties to get this done once, to make the decisions, to have one judicial officer go, through the case until trial, and then to finish it. If I were to go for a replevin right now with a CIR, the question then becomes, my client does have better possessory interest, so he should get it all back, bearing the outcome of the CIR. But that doesn't make any sense. It seems that it all needs to go together. That's why we put it here. That's why we requested it. We're going to have three different judicial officers assigned. It doesn't make any sense. So we'd ask that it continue on the civil docket, that it be heard all together, that any future filings that have to do the same chattel, the same personal property, that all falls under this case. Thank you.
Well, it seems to me this is the case, you got to figure out the CIR before you can do anything in the replevin case.
But there's also then, she made the claim that she had a contract for the construction of the house, which would negate a CIR claim. So really that one should come first, which is the reason I said it should go on the civil docket. Because if there was a contract for renovation of a home and she's getting paid as a contractor, that means there's no quote unquote marital community in a way. So that's the problem.
That's just evidence of that. It doesn't prove anything. It's evidence towards the proof. So, I mean, it seems, well, there's a couple of problems. First off, from a fundamental standpoint, I've talked with the clerk's office, and actually consolidating two different types of cases like this creates a whole bunch of technical problems within Odyssey. And so what she can do is relate two cases so they're kind of tied together, but they're not actually the same case. It seems to me, again, I've reviewed through both of the basic pleadings, and we only have two cases, not three. And it seems this probably belongs on the family law docket to be dealt with under the committed intimate relationship case.
Do we need to be filing the same pleadings in all the cases then? That was one of the reasons I tried to consolidate them.
Well, if you think they're appropriate for both cases, then you would.
Okay. My other issue is I don't know what's been filed by Ms. Gronis because she's not serving me. So I don't know if there was a response that made it seem very, very family oriented. To me, it was a question of money. So I had real property, but I will take a look at that. So if we, I guess I can always bring the motion to consolidate afterwards.
Yeah, that's fine. But my thought would be at this juncture, after talking to Stacy, would be to have the clerk's office relate these cases together so we don't lose track of them. Those who are aware, there's two cases that are kind of interrelated. And then, again, like I said, my first reading through this, I didn't spend hours reviewing both cases, but it seemed like the CIR kind of was the piece that needed to be addressed, and then the other pieces would fall into place.
Okay, we'll do that then. Thank you, Your Honor.
Okay, so I'm not going to sign the order of consolidation, but I'll have the clerk relate the two cases so they're tied together in Odyssey, so we know there's two matters. Whoever's looking at one case will have access to both easily.
Perfect. That's all we want. Thank you, Your Honor.
Okay.
The judge should have cleaned his desk.
That's all you gotta say. Just the desk?
The judge.
You probably
Yes, the judge needs to clean his desk off, or at least make it presentable for court.
There's another
That just means he's got too much work to do.
Granite and Bach, cause number 23-3-00344-08.
That matter's ready.
Right.
I'm sorry, is this the... Oh, it's an admin. Like, why is a judge wearing a hoodie? Like, what just happened? But it's not a judge, I guess.
Yeah, admin.
I guess I'm just trying to, my question on this one was, maybe I'm missing something because I know there's motion set this afternoon.
It's a motion to end their committed relationship. I'm so done.
Motion for partial summary judgment. There's been obviously a CIR claim in the replevin. This is looking at just anything owned prior to 2018. Since it's a CIR, obviously not everything's on the table, only the things during the relationship. So this is, we might come to an agreement. I've been talking with, I'm not sure if she's in the courtroom. We're kind of working that out, but in the meantime, I just want to get it set. It's looking at just the property prior to 2018 as they agree on the date of the date the relationship started. They don't agree on whether or not it was a CIR, but they do agree on the date.
Mandy is not present.
I was talking to her until around 9 a.m. this morning. She did say that she wants, hold on, she wants a considerable amount of time before it's set.
Would probably need to be in November, just a timeline, at least.
She wants at least 2 weeks to get everything together before she can even answer, and I'm happy to do that because, like I said, it does seem like we're working on a settlement agreement on at least this issue. If we can put it out, normally it's 28 days. If we can just add 10 days onto that, I think that would be sufficient for her to get an answer unless we settle.
So I'm thinking, just looking at my calendar, it's probably the week of the 5th of November that we have something available.
I'm in trial, but I think I could probably, are we doing these on Mondays, Fridays? Is it just open? I don't mind doing the trial and this in the same week if I have to.
This is a 2-hour set?
Yes. And I doubt it'll take that long. Again, this is a very small issue. It's just to focus on just a certain time period.
It can be set anywhere between a Monday, Thursday, Friday, and a Tuesday, Wednesday if we don't have trials set on those days.
And that's fine. I think I can handle both.
I mean, the alternative is if it's not over half an hour, if you don't expect that, that can just go on a regular family law docket as well.
Unfortunately, I think my argument would be probably around 20 minutes, but given that we've had a number of motions that seem to go way longer than they should, I think it would be better for Ms. Grondins to have a little bit more time to argue. And so I think probably 2 hours would be reasonable.
So are we looking at week of November 6th?
And that works for me.
Okay, that Friday is a holiday, but I can do a 2-hour set week of November 6th.
Okay. That works. And that's at least 28 days from now?
Well, it's 28 days from filing, at least.
Yeah, I just want to give her a little bit more time. I think that'll be fine though, and I can speak to her as well. If we have a problem, we can come back.
Okay, very good.
All right, readiness will be October 31st at 11:30.
All right, that works for me. Thank you.
Thank you.
Give me just 1 second. I want to make sure I think I'm down to the
October 11th.
Boff and Grondins matter.
Back to the ref 11.
We handled everything else, did we not?
I believe that she was in the other case the same
I
day.
just want to make sure I didn't move things.
Can't remember.
So,
I believe so.
let's see, we have Ms. Grondins, we have Ms. Winkle, excuse me. So this is on for a couple of motions. One is a motion for advance fees, one is a motion to compel.
And there's also a motion for sanctions for a deposition.
Correct.
Which one do you want to take first, Your Honor?
I'm gonna take the fee one first, since that I believe was the one that was filed first in time. So Ms. Grondins, if you want to get anything you'd like to say about your motion for advance fees?
I extended the date on that till next week. I have it inaccurately represented as lawyer fees. It should be production costs for discovery. So I have to amend some paperwork for that, so that's not ready for today.
So you're
I'm not here, that I put in a docket notice chain.
hold on a second here. Well, there is one for the 18th of October. Looks like that's what that one is.
I anticipated this case getting set over, so I set that date in advance to secure a slot.
I have not been served with that. Is that on its way in the mail, maybe?
I believe it was sent email the same day it got submitted to the court. I'll double check that and I can resend it.
Okay, that'd be great. Thank you.
Yeah, it looks like it was filed on the 6th.
Okay, it might just have been lost. We've had a lot of emails.
Just an amended docket notice, so.
Oh, I can look that up. No need to reserve.
Okay, so I will, I don't see any amended motion. I just see an amended docket notice. Okay, so moving to the motion to compel and the motion for deposition costs.
And
Yes,
Your
sure.
I'm sorry to interrupt. Would you mind just muting the iPad? I'm just getting some feedback.
Sorry?
I'm just getting some feedback on that iPad. Will you mute it?
The iPad one, let me see.
Yeah.
A second here.
I'm sorry, Ms. Winkles.
Oh, you're fine.
I'm gonna remove both of those. It looks like those are both still, everybody in them.
Thank you.
That's just it's your look, your rules. Disney Illy forever. Inspired by Stitch. What's your dream style?
It's Camping World's model year in liquidation. Take advantage of massive discounts on new 2025 RVs with
We get some feedback. So there we go. That'll help things.
Oh, my side.
I see a Kalisha Baker trying to log in. Is that somebody involved in this case?
Not on our side, Your Honor.
Not a familiar name for the matter. All right, go ahead.
Yes, Your Honor. I hate to come to the court with this because it's a problem and it's costing my client a lot of money. And the delays are, it's extremely problematic. So I'll start with the motion to compel. Normally I would bring on these motions and I feel absolutely no regard for either side, and I would just bring them and we try to get the discovery. In this case, I'm very concerned with some of the responses and some of the actions. Trying to, how to put this. And I'm concerned that I'm going to essentially be wasting my client's money and attempting to get these orders, and it's just going to be this procedure over and over again, but I'll never actually get them. So I just wanted to state that to the court. So the discovery we submitted to, we just served on the defendant on August 8th. We had a CR26I, and I asked her how much time did she need. She said 2 weeks. That was fine. I would have given her longer if she'd asked. It went by and we received nothing. That was September 25th. I normally would do another CR26I with a pro se person just because they're not aware of the rules. However, I've received emails stating, I'm not giving you the discovery. I'm not doing this. And that's my concern, is that my client is now in 3 different cases with the defendant. And it's getting to be the most expensive case I've ever had in this short period of time. It can't go on. It's going to bankrupt my client, and the stuff that he's trying to get back and she's trying to get, it's never going to come out to how much the legal fees are. I ask Your Honor to compel her and to do an order of attorney fees, but frankly, I think she's judgment proof anyway, and I'm not sure it will serve a purpose. However, maybe I guess if we go down the sanctions route and keep coming back, it's just so expensive for everybody. And my concern is that things keep getting more erratic. But in any event, we've done everything we should do. The discovery is long because it obviously has some elements of the relationship in there and her affirmative defenses. I was happy to give her extra time, but we're now at October 11th and we've not received anything concerning. I can't even justify a settlement without knowing what the basis is for her affirmative defenses. If we go into the deposition, we scheduled a deposition. We sent a notice of deposition. We gave plenty of time for her to respond. I assumed she was going to be there. The court reporter was there. I was there. Mr. Bob was there. 20 minutes beforehand, she called and canceled and said she was in Seaside and her car was broken down. Normally, if your car is broken down, I wouldn't have a problem, and we'd talk about the money for the court reporter. However, the problem is why you would be in Seaside and only give notice 20 minutes beforehand. If your car's broken, you would have had to have left Seaside an hour and a half, 2 hours before. That's when you could have called or you could have emailed. I work at 6 a.m. every morning, even the night before. We could have tried to figure out some Zoom or something like that. In any event, again, it's just cost my client money. So every email, and there's hundreds of them, but with no discovery, every time I come to court, every time we submit a declaration, every time we respond to a frivolous motion, it's just costing money. And frankly, it's not worth it for my client. And I feel bad doing it. Unfortunately, I'm also sitting here and I've got to pay my staff, but I'm not sure what to do at this point. I'll ask for sanctions. I guess I'll ask for the interrogatories to be attorney fees, and I'll ask for the deposition to be, I guess, additional attorney fees with some stricter sanction other than attorney fees, which might get this rolling. I'm more than happy. The argument is I haven't submitted mine to her, and she hasn't followed the procedure, but given that she's pro se, I will submit that. But I'd like to actually receive something to make this end, because I'm going to be in front of Your Honor probably every week at this point, and my client just can't do it. And at this point, normally I don't argue like this. I just go after them and like a bulldog, but I want to be compassionate here and try to find some sort of resolution. And I'm hoping that the court will assist us today in coming up with a way to move these 3 cases forward. They're all intertwined, and we're going to be here on another motion to compel and another motion to compel a deposition in 2 weeks' time. And it's just too expensive. Thank you.
He does give bulldog vibes. I got that from the last case.
You don't need to wear boots. Presenting
we didn't agree with what she was saying,
100%.
but it was, you remember, you didn't like the things that she was saying either.
I didn't care for her.
Yeah, but she gave bulldog vibes in that case. So
and
it's
she
kind
lost.
of funny. But she didn't lose. She removed herself or was removed. But, I mean, at least you can say if you hire this firm that, you know, even if you're wrong, they'll still be strong for you, right? Wrong and strong. But even in this sense, but even in this, like, sense, it seems like she's trying to, you know,
She's saying, look, we need to condense this down so we can save some money.
Well, yeah, because every time that he has to come to court, that's probably a couple of $100 an hour, and that's not including the time that it's taking them to file paperwork or review paperwork, and like that shit costs money.
Costs a lot of money.
But I don't blame them, because when you do like when you do personal injury, the attorney puts out money with the hopes of it getting returned when the case settles or goes to trial and there's a settlement. But you know, for these attorneys, they bill you by the hour. I think I chose the wrong profession. I need to look into law school.
Just so I understand the status right now, you've currently got a deposition scheduled for day after tomorrow.
We actually canceled that because I got an email about 2 days ago that said I'm absolutely not coming, and in which case I'm not going to pay the court reporter to drive down from wherever she comes. I don't think she lives in this area.
Look, I can be a PhD and a JD. There are people I think that have both.
I know nothing.
Thank you. Ms. Konitz, any comments or response you have?
Look at this. Too late.
Yes, Your Honor, I would like to start with the identification that I have vacated Cowlitz County as of May, and any requests for personal appearance are absolutely unnecessary because any information that needs communicated can be done via electronically. Where I stand on this case specifically, this is the Replicant case, right? Sanctions for lack of discovery, is that correct?
There's two motions. One to compel the interrogatory answers. The second one is some sanctions for not showing up in the deposition. Those are the two things that are really important.
Both are discovery related, correct?
Correct.
Okay. As counsel suggested, I am pro se. I am not an attorney. I'm an accountant and a business systems analyst. So I operate with true, accurate numbers and data. I am in 3 court cases, all of which have conflicting information brought forth by opposing counsel. We are really close to having this done. In fact, today you actually have permission to dismiss this case because I have found alternate remedy for every problem that opposing counsel has brought forth.
You are the defendant in this particular case. You don't have the power to ask for a dismissal. Actually, you can ask for something to be dismissed, whether you're the plaintiff or the defendant. You just have to have a reason for why you want it to be dismissed.
Let's just review what did she just say. Lawyer fees, that's amended till next week. Compel and responses. I would like to bring light that the only reason I missed the discovery meeting was my car overheated. It was broke down in Rainier. I was without a phone and in a car for 3 days. I had to have a friend go pick that car up and then another friend go pick it up on the 22nd. I had to find a different friend with a phone. I exerted extreme effort to make discovery, or at least to contact opposing counsel about discovery. I do admit that I missed it, and I was late, so the $75 fee appropriately could be assigned to me because it wasn't a forecasted intentional miss, but I did miss it. As far as discovery goes, we have 2 different cases. This specific case is about theft of items,
Hi, Big Mama.
from a, what is she calling? Oh, short duration relationship who waited till I was moved out of the house, broke in and stole a bunch of stuff. Okay, that's the position of opposing party on this specific case. They're claiming I stole
Ma'am, let me, Ms. Grace, let me,
to return those.
let me stop you for just a second. So I'm not looking at the details of the underlying case today. What I'm looking at today is a request to have you file the written deposition or written interrogatory answers. That's one issue. And the second is whether or not I impose some sort of sanctions, whether it's fees and costs on this missed deposition. Those are really the two issues that I need to focus on. And I'll have some more questions once I hear your position on those two things. But I don't need to hear about all the underlying case. I understand what the cases are about because I've dealt with them at some level.
I think also too, when it comes to, I don't know if it's the same in this situation, but I think like with personal injury, when you schedule a deposition, it's being scheduled with like a third party, usually like a court report, like a
court
like a court reporting like company that you can. It's either done in either attorney's office or it's done in a court reporting office. And so when a person cancels 20 minutes before the deposition is supposed to start, she's not just inconveniencing the Mr. Bob and his attorney, who his attorney is still going to bill him.
Yeah.
But she's also inconveniencing the court reporter, who I believe, if I'm not mistaken, they get paid regardless, I think, of whether the deposition takes place or not.
Right.
So this fellow here and his attorney are putting out money for something that ends up not happening.
Right.
And that's why they're requesting that she pay those costs. Because everybody else who was involved in that situation got paid, but there was no product, basically. So just in case people didn't like understand like how depositions and stuff work, at least for them, you know, there's only really the one attorney involved.
Right.
I've prepped clients for depositions, which is kind of fun, by the way. But I've also participated in 2 depositions. I participated in a motor vehicle accident deposition, because when I was a kid I was in an accident. And I've also participated in a medical malpractice deposition, which was for my dad in the bed situation. And the deposition that I had to do for my dad was crazy. Because keep in mind, my dad was already dead at this point.
Yeah.
And so, it wasn't just me and my mother and my attorney and a stenographer, you know, the court reporter.
Right.
It was 3 other attorneys, because there was 3 defendants in our case. So they all had to ask me questions. It was a day-long thing, like a whole day.
I believe it.
So, you know, stuff like that costs money.
Yes.
Just plain and simple. And that's not including the transcript that you get from the court reporter. And if it's a long transcript, when it comes time to get copies of that, you have to pay for the copies.
Yeah.
And per page, and it's a lot. And you have to have it served or like mailed to, like, you know, whoever gets the transcripts has to send it to the other parties.
Right.
There's a lot of cost involved in there.
Yeah.
This lady, I don't know. I'm not trying to be funny, but he doesn't look like he's a millionaire.
No.
So, I mean, like right now his face looks kind of sucked in, like she's sucking the life and the money out of him.
I mean, he probably makes decent money. I'm just gonna be honest here, but he probably doesn't not make millions of dollars or nothing.
No, well, I mean, what she said that she was remodeling a kitchen for him.
Or something
So
like
maybe
that.
he's some type of contractor or whatever, but either way, and if he and said that he was her employer. So
Yeah.
that means that he has employees to pay. So he's putting, and this is why the attorney's concerned, he's putting in all this money with delay tactic. Because
Yeah.
they said that this is, oop, I'm clicked the wrong button. They said this was August 11th, right? So his attorney is, actually there's 2 hearings for the 11th. I don't know why. Or maybe that's a missed date. Either way, there's been 3 hearings so far, and the attorney is already concerned.
Right.
That's scary. I could understand if she was concerned by the time they got to the 8th hearing. But if she's already seeing like that there's going to be a problem and they're only in hearing 3, that definitely is cause for concern.
Right.
Oh.
So.
Drunk teacher shows up to school. Sorry, y'all. Adding to the list. Can't help myself. Oh, we got to get the dumb
64.
DUI. Wait, look. We're removing what? We're removing 2 or 3 videos today. And look, and we're adding 3. We found another one here that involves a gal. I apologize. I can't help myself. This is why the list never goes down. Epic fails of the... Oh.
Folks, this is the list that never ends. Literally.
Oh, wait. And we got to get the Karens that ruin their lives. Because they say stupid shit.
Hurry up.
Gotta love it. Okay, I'm gonna stop. I'm sorry. It's not my fault. It happens.
Up to this point. But what we're here today about is purely the interrogatory answers and the not showing up for the deposition. Those are the 2 things I need to have you focus on.
Good luck with that, Judge.
The not showing up to the deposition was unintentional due to my car breaking down. I did make extensive effort to notify opposing counsel as soon as I could about it. Interrogatories. I've been hit with 400 pages of information. I would like to counter-propose to opposing party a streamlined solution. I have 50,000 records to go through and create a spreadsheet to
You want them to wait for you to make a spreadsheet?
of my contribution. It is only
Yeah,
to
you
my
kinda-
benefit to
yep,
provide discovery.
pretty much.
So the idea that I am opposing providing discovery counteracts my entire argument that my entire case is based off of the discovery I can provide. So I am extremely motivated to provide this discovery. However, I've had 20 court cases in 21 weeks amongst 1,500 different paperwork things. I'm in 4 different dockets, 5 different cases, 200 line items into this case. So I would like the chance and the break to actually provide the discovery, which is going to take me 60 to 80 hours to compile, compute.
So she's using the same excuse she used in the protection order one.
The opposing party a spreadsheet to match my spreadsheet. So when we come to court, all the court has to do is match comparable spreadsheets of contributions into the relationship in the CIR, and we can divide assets per ratio of contribution effort. I just needed time to make the spreadsheet. We have a readiness hearing October 31st. I can provide my information by then. As long as I'm not distracted with the 400 pages of information I got last week. This entire case today is procrastinating me from accomplishing the goal. Every single motion on this case has been a distraction from me accomplishing the goal. Because 60 to 80 hours in June, I could have had this done, but I've been in court every week on other things, but getting discovery submitted.
Oh, cry me a river.
This case sits where it lacks evidence to even make the claim. It's the wrong venue because the assets are either being disputed in the protection order, which I just negotiated a agreement between parties to exchange personal property from the relationship. So we can finally, after 6 months of it being in a holding pattern, exchange property. I don't want his stuff any more than he wants my stuff. We're trying to give it back and forth, but the protection order blocked access for me getting rid of his stuff and him returning my stuff. But I satisfied that Monday with Judge Carmen. The rest of it is a vehicle, some trailers, and things that are in the will. And a will is a contract by law, so that's disputed in the submitted intimate relationship. This case, Your Honor, from an accountant perspective, I'm looking at the numbers. What I read on their submittal is that the assets that they are contesting equate to $27,000. Of those assets, I could rightfully contest committed intimate relationship $10,000. I would only get half of that. That's $5,000. This case is $5,000 worth of property value. Her bill is $25,000. I don't understand how she warrants a $25,000 attorney bill to fight for $5,000 worth of stuff when all I had to do was ask the judge in the protection order docket to allow us the chance to exchange it via third-party person, which I asked him to do in May. He could have resolved this in May, just allowing us to move our stuff without this entire litigation process. Every part of this process has been his own expense, his own choice, simply because he didn't want to be cooperative in May. So I would like to give him his stuff back. I would like a chance to submit my discovery without them harassing me via the court system with all this additional paperwork that is completely unnecessary. Thank you.
Is Pilates for you? Well, this is Club Pilates, and we think it's for everybody.
How many pages?
Ms. Winkle.
Would you like to write 8 novels, please?
We don't have a settlement. You know, it's always hopeful. The cost is, and I've written off quite a lot of my bill. We just can't go on like this. We've done everything right. I've tried to be friendlier than I've ever been in any case. I am concerned here. I've asked for the discovery. I keep getting pushed off for everything. You'll get, you know, I'll gladly give you a hand, you know, it's like just wait till Tuesday, or I'll have it on Tuesday, and Tuesday comes and it never happens. There has to be some sort of, she has to be held to the same standard as a lawyer. That's what the law states. And is it fair? Well, I have my own thoughts on that, but the fact is that's the law. And I've tried to be really, really malleable here and allow more time. But the fact is we need this to move forward. My client can't continue. It's more than $27,000 worth of stuff. Literally, the knobs to heaters were taken. I mean, like one sock from every sock type of pair. That's the type of stuff that was taken, but it was everything, minus her stuff. And so we sit at a place where we can't move forward, but we're going to keep coming on motions. Motion for attorney's fees, which is now turning into, because that was denied in the protection order, a similar one. Now it's turning into a motion to produce documents. This is what's going to keep happening, and it's going to bankrupt my.
They don't stream the protection order hearings, so I only have Odyssey to go by for that case, but I will share the details in screenshots at the end. Okay.
Client, and I think it's going to make Ms. Gronick, more erratic. Right, it's not going to help anyone. So I would ask that we follow the letter of the law here, that Your Honor compels her to produce them. That's fine, give her 2 weeks, give her 3 weeks, but does some sort of sanction so we can be sure that we're not going to be back here. Again, I highly doubt an award of attorney fees, as much as she does own personal property, or she does own real property. I can attach it, a judgment to a real property, and maybe in 30 years time my client can get paid back. That's fine. I don't think it's going to work. But I'm willing to go through any step, the deposition as well. We're asking that because of the October 12th being canceled as well, we might be able to resolve this on a summary judgment as the story keeps waffling and changing if the person that's giving the story is held to penalty under perjury. And I'd ask that Your Honor compel her to be at a date certain for a deposition. I will clear my schedule that day. I'll make it happen as long as it's not a trial. And that she be sanctioned, even if it's just $75. But we move forward in the level of sanctions as it is indicated in the court rules.
You gotta appreciate where an attorney wants to get paid, but doesn't want to have their doesn't want their client to be screwed.
That gives me a whole different perspective of her.
First off, you're still wanting to do a deposition. Is that right?
Yeah, I mean, you gotta. I think attorneys are the way they are, right?
Yeah.
And regardless of who they represent, they're probably always going to be the same. But it also, I think, depends on who they're representing.
Right.
If they're representing someone that we are unfortunately making a judgment on based on what's coming out of their mouth and their behavior, and we don't like what that content, then yeah, we're not going to like the attorney, especially if the attorney seems to be greenlighting it and condoning the things that are being said or the behavior.
True.
And then, but when you see them with a different, like we're seeing her now with, not to say that other woman wasn't quiet, because she was quiet, right, throughout her hearings, but the things that she was alleging were, or the things that she was doing were just, off the wall.
Right.
And the attorney was representing that. Whereas in this case, he's not even, there's no allegations. There's nothing. He just wants his stuff back. He's not saying anything. The attorney's not saying anything even negative about this woman.
No.
Just that she's, creating some expensive delay tactic.
Right.
So that, I mean, and that's the thing too, why sometimes you can judge a situation based off of what you're hearing and seeing, but I try really, really hard to not judge the person, especially a person that's in the capacity of their job or their profession. Because I say the same when it comes to musicians and actors and actresses. You can appreciate their craft even if you don't necessarily like them as a person.
Right.
Right? But we're only 3 hearings into 13, so
we got a long way to go.
3.5 hours. Yeah, this is gonna be a doozy. We're only a half hour in.
I do, and I'm wondering if I can get some of these. My concern is that I'm not going to get some of the more technical questions. How much are you saying you're owed? Some of the technical things, I think I'm going to need the production of documents. But some of the other questions we can probably satisfy. Just when did you start a relationship? When did this happen? We can probably satisfy that in a deposition. So the deposition, I would say, would come first. The production of documents is important because it's obviously the claim for the liquidated amount, the ascertainable amount. But they both need to come. But I don't need to ask for interrogatories necessarily. I can do that in the deposition. It would just be a request for production at that point.
So, Ms. Gronitz, you indicated you're no longer in Cowles County. Is that what I heard you say? You're muted. I can't hear you.
And just so you're aware, Your Honor, we'll do Zoom. We can do a Zoom deposition, no problem.
Ms. Gronitz, can you hear me?
I apologize, Your Honor. I lost connectivity there for a few minutes, so I've been out of the meeting for since Ms. Winkles began. I vacated Cowles County, and so Mother's Day things got contextual. The same day my parents got offered for property, the sale of their property. So I'm in lieu of helping my family move, rebuild. I got 3 different house construction projects in Lewis County. Then this month I have scheduled some travel arrangements. I've exhausted Calhoun County, Park County, and Lewis County legal sources and seeking all resources across the state.
Well, my question
I
is,
know visit some friends who know a lot more about it than I do, and it really help me.
okay, we've got a really
Is there a
bad,
reason we can't just exchange spreadsheets, Your Honor?
Grip.
What the fuck is she? Like, what's with the spreadsheet shit?
Essence of driving. Lawfin.
What the fuck is she talking about?
I used to have this cloud hanging over my head about not investing. Did I wait too long?
well,
My service is
let me finish, ma'am. So let me ask a couple more questions. So are you unwilling to do a deposition? Is that was somehow
I
really,
believe that deposition provides very little information for the time and energy exerted. Plus, you mentioned on one of her papers it's $3,500. I just need some time left alone to spreadsheet. So no, I don't want to do a deposition because all that does is distract me from actually accomplishing the goal.
You don't have a choice.
The time and costs exerted into the product of the relationship.
Remind me.
60 to 8 hours. So after 80.
When is it like?
What's the deposition?
A deposition is basically an opportunity for both parties to be asked questions.
Okay.
And it puts information on record. So like I said, I can talk more about it from like a personal injury standpoint. So as an example, if you're in a motor vehicle accident, you know, usually in a motor vehicle accident it's kind of like a he said, she said type situation, right?
Right.
So they, ask you basic stuff like, your name, your address, where you work, what you do, blah, blah, blah. And then they start asking you for like very detailed questions about the incident.
Right.
So, the date of the accident, the type of car you had, where you were that day, where you were coming from, like how the accident happened. In the case of my dad, I was being asked questions like, when he go into the hospital, when did this incident happen, when did that incident happen? Right. I took a lot of pictures of my dad over the years, and when he died, my mom had to take pictures of his body in the funeral home.
Okay.
I had never even looked at the funeral picture. I never looked at his deceased body pictures until the deposition.
Wow.
When the deposition happened, I want to say inundated with all pictures. So, and mind you, most of them, they're all pictures that we provided, but I had to be asked about every single picture that was provided through my attorney. Every single picture. I had to tell them what it was a picture of, where it was, like what location he was at. I had to identify if he was at the hospital, if he was at the nursing home, like everything about the picture. Because those things are also, part of evidence. So that's kind of where deposition comes from. Plus, too, with a deposition, like I said, it's testimony. So when a case does go to trial, they can refer back to what you said in your transcript, especially if it's different than what you're saying at trial. So it's an accountability thing, I think, in a sense too. But in this particular case, it seems like a deposition would be necessary to get a clearer understanding of dates, the times, the start of the relationship, the assets that were obtained during the relationship, so they can decide how to divide that type of stuff.
Right.
And it's probably an opportunity to ask questions about specific things that he wants returned. So, her
Me-
thinking that it's a waste of time is ridiculous because depositions are literally part of the discovery process.
Yeah.
And it actually would be a disservice to her to not participate because then the deposition then becomes maybe potentially one-sided.
Okay.
If and a court can compel you to do your deposition. Like for a defendant, it's actually really poor if you don't show up for those type of things.
Right.
And then a judge can enter especially if an attorney files a what's called a summary judgment. What is the summary judgment called? It's a motion for summary judgment. Okay. I can give an example of what that is too. So let's say that we're just gonna try to make this up here. So let's say the plaintiff, which is this man, right? Let's say his attorney says that that they've requested information and that information hasn't been received. If a person, let me see how I can put this better. I'm going to try to simplify it. Let's say you have a motion for summary judgment and you have a plaintiff and a defendant.
Right.
And the plaintiff is asking for a number of things. And that the day to hear the motion comes and the plaintiff shows up and the defendant doesn't. The judge can grant the summary judgment. And that means that whatever the things that the plaintiff asked for are granted because the defendant did not show up or provide a rebuttal. It's kind of the same thing too, like I think with let's say you're getting sued by a credit card company, right?
Right.
For for the balance of your credit card, and you don't show up. The judge can enter a summary judgment in favor of the credit card company that orders you to pay. Like stuff like that. Like I think that's the best way to explain it. Because I think it's different cases have different results. So let me see here. So summary judgment is a court order where a judge decides a case without a trial based on the argument that there are no genuine disputes over material facts and one party is entitled to judgment as a matter of law. This pretrial motion is used to save time and resources by resolving cases where the facts are clear or one party's claim is indisputable.
Okay.
To grant the motion, the court will view the evidence in light most favorable to the non-moving party.
Okay.
So a party files a motion for summary judgment arguing there is no dispute over key facts and they should win the case based on the law. Evidence such as affidavits, depositions, or admissions is submitted to support the motion. The opposing party then has the opportunity to respond, arguing that there are indeed triable issues of fact that require a trial. The court considers the evidence and legal arguments from both sides. The court can grant the motion, meaning a trial is unnecessary, and the case is decided, or deny it, allowing the case to proceed to trial. I just know that usually when there's like a motion for summary judgment, if one of those parties doesn't show up, it usually doesn't go in their it can not go in their favor.
Right.
Because they weren't there to argue. But that's basically where she's screwing herself, though.
Right.
Because by not doing the deposition, she's, not providing evidence for herself.
Right.
And so what is happening is the less that she does, the better it looks for him.
Right.
And if she keeps playing this game, they could literally just come to the conclusion of, well, if she's not doing the discovery, I'm going to just grant that the plaintiff receive all the items that he's identified back.
Okay. Yeah.
That's how she's screwing herself, basically.
Gotcha.
She's not putting herself in a position to dispute what he's saying.
Okay.
So if she doesn't dispute it, then they're gonna just take what he says as
face value.
As the fact.
Which makes sense.
If I had not computed
Sorry guys, I just wanted the little lesson there.
information-
Sorry about that.
It's not. I mean, these things can be kind of confusing, especially because of the types of cases.
Mm-hmm.
Like, and that's why I've always kind of like, especially like when it comes to personal injury, the documents have the same name, but how I think that they're interpreted or used might be different based on the court you're in.
True.
Because, for instance, with all these like family court stuff, I'm hearing discovery, but I've never heard them use the word bill of particulars. And bill of particulars is a very important piece of discovery in a personal injury case. That's the document that's used to provide everything about an accident, including the medical records, insurance information, pictures, and other types of like exhibits and things.
Okay.
I did hear them say I think she said summons a complaint. A summons a complaint is what you file when you're filing a lawsuit. Regardless of what that lawsuit is for, whether it's, in my case, like a motor vehicle accident or the med malpractice or whatever.
Makes sense.
But the bill of particulars is part of the discovery process. I haven't heard them use that word yet, and I'm guessing maybe because it's legalese. Maybe not everybody's gonna know what a bill of particulars is, as it relates to like discovery stuff. Whereas they have to use the word motion because that's what the court is working off of. A bill of particulars is what's worked off of between attorneys or between the parties. It's not necessarily, though the court does get copies of all those things too.
Right.
And that's what a lot of these pro se people don't realize. Anything that you want to present, the court has to have a copy of it. If they don't have a copy of it, it doesn't exist.
Right.
A lot of them I'm noticing make that mistake. You can't talk about stuff that they can't put their hands on.
Nope.
Then she can go off. But I've been in court every week. I've not had a chance to just sit and compute the information. I've collected it all. It's waiting for me to data entry and push off.
That sounds like a personal problem.
Format. It'd be nice for him to have the same spreadsheet so it's side-by-side comparables. I do accounting, and when you're working with comparable numbers side-by-side, it's easy to make a decision. So that would be nice
damn
for
spreadsheet.
them.
It doesn't need to, yeah, that is a control tactic by her in my opinion. Yeah, I don't know what the whole point of the spreadsheet is, unless it's supposed to be her way of itemizing some type of, like, maybe her exhibits or something, or... But it takes a long time to create a spreadsheet if there's a lot of information that has to be included on it. It's a lot different if you're adding stuff as you go. But this is not an add-as-you-go situation.
No, creating a spreadsheet takes a long time.
Discovery to me while they're trying to file sanctions that I'm defiant against them. They should provide me the same thing they're asking me before we meet again, or before they ask for a deposition. They haven't offered his deposition. What does a deposition offer? This is just about the numbers, and the numbers mean I need time to get the information on a spreadsheet so that you can review it. Anything else is a distraction from the goal. The goal is, what did he contribute? What did I contribute? Anything else is a distraction. So no, the deposition is unnecessary until we get the spreadsheet with evidence to support the claims. It's a waste. I'm sorry. I just don't understand the value it offers. So it's not a defiant maneuver. It's the lack of understanding why
Connection's terrible.
Oh, the truth.
I just realized this attorney looks like somebody I went to Catholic school with.
So,
And I don't get paid to
Well,
litigate.
she
I
looks
just
like
get to
many
problem
people
solve.
that I've known in my life. Many people.
It's something with her face, but
And they're all
Like,
equally
they don't-
as smart. It's hilarious.
It's your look, your rules. Disney Illy Forever, inspired by Minnie Mouse. What's your dream style?
okay, so one question for Ms. Winkles. How many pages discovery is this? I mean, it was indicated as 400 pages.
Oh, no, it's nowhere near that. I also, just so your honor's aware, I knew that she was pro se, so I left plenty of room for her to write. The questions were far spaced. I can tell you in 2 seconds how long it was. I usually put 3 questions on the page.
300 questions.
Yeah, so it'll be 60 pages with 2 to 3 questions on each page. So it'll be about 120 to 180 questions. Some of the questions are, what's your name? Who helped you?
Pages of discovery?
Well,
It's
I don't do compound questions, so to pro se people, so one question will be, when did you meet? And then the next question, how did you meet? And then, were you ever engaged? Did he ever buy you a wedding ring? What did you take from the
Oh
house?
my God.
Yeah.
It just seems like an unbelievable amount of discovery. But
If you saw it, it's not. It's just I've been objected to because of compound questions, so now I just piece them out. It just seems like it works better.
okay, so
and plus they sound like easy to answer questions.
You know what?
It's not your decision as to whether a
180
particular
and
form of
pause this
discovery
for a
is
sec, will you?
good, bad, or useful.
My whole thing is they made it simplistic for her. Let's not put, a paragraph that has 4 questions in it and give you the opportunity to, to write your whole fucking story.
I mean, yeah.
To
I mean,
answer a question that it was, the questions are more are specific. Like,
yeah.
I mean,
Makes
there
sense.
aren't there personality assessments with more questions?
No, but yeah.
No, there are. There are personality assessments that have more than that. My licensure test for has more than 180 questions. Like, come on now, lady. And then some of them questions might not even be applicable to her.
Yeah.
It's not like she has to answer all of them. Look, the judge. Look at his face.
He's like,
He's
seriously?
No, he's more like he's looking at a calendar from the corner of his eye to see if he's at the age for retirement yet. That's what he's doing.
No kidding.
If either side wishes to do that, and they follow the court rules to do that, they can do that, and you have to cooperate. So, you can do those via Zoom. You can also do them in person.
Zoom's fine. I can do Zoom, Your Honor.
Okay. The
We're
problem.
doing Zoom right now, right?
Well, just listen to me for a second. Part of the problem with Zoom is the problem we're having right now. Your connection is really dicey. You're kind of breaking up now and again. So that's a potential problem with a Zoom deposition. If you've got real good internet, then that usually works pretty well. So that's a possibility. It sounds like that's agreeable to do that.
Even if you have crappy internet, Zoom runs fairly well.
Do one of those if they request it.
I can also go to Lewis County, Your Honor. I used to work there, and I'm sure my old firm would allow me to use a room if that would be easier for her.
So, you guys can work that out how you want to do that. But if they want to do a deposition, they can do a deposition. There's all kinds of reasons that those are done. Sometimes, and it sounds like this may be a case like that, some of the discovery questions that you're working through could be dealt with in that fashion as opposed to having to put it all in discovery. So, I guess a couple concerns I have. We set a summary judgment motion in this case, and I forget the date we set that. I don't have it in front of me here.
I believe it's November 5th. I did.
Translation, get off your high horse.
Already emailed Ms. Gronitz and tell her that as soon as I got the scheduling order, I'd send it to her. That's a very small question. I mean, it's just a question of anything before they met.
Okay, so that'll be a separate issue. Some of that may be even agreeable, but that being the case, first off, when these things are set up and people, coordinate things and they get the reporter lined up and everything, there are expenses involved in doing that. I understand your issue on this particular one. It's a bit concerning that it was so late canceled. That very well may be appropriate given what you described as what happened. And then I guess it concerns me that there was some email that may or may not have happened where you said you weren't going to do a deposition, but it sounds like we're past that. So you're agreeable to do one as long as it's in Lewis County or via Zoom. Is that what I'm hearing?
Via Zoom, and it's never been an opposition of doing it. It's been an opposition of understanding the value versus getting our spreadsheets matched first. I just want to get my information together first. I can't give a deposition without having information collected and processed. So
Okay.
That's not their problem.
Before they even consider to do the deposition, and before they hit me with the packages 400 pages.
I can assure you it doesn't work that way.
We have
Yeah,
I didn't have my information set by then without a deposition. And then after that, what I provide.
I know it doesn't work that way.
A deposition can be done and discovery can still be provided after the fact.
We're supposed to make a schedule that works for both parties, and they have not done that. They're trying to. Their purpose for requesting discovery, I don't believe, is honorable. Your Honor, I have to get my information together first. It's just how it is mathematically. I need to know what I'm depositing about.
Can't read it.
I don't have information filed.
She's not.
So I can't give them the information until I get it ready. That's all it's about.
The court doesn't care about that.
Yeah, exactly.
Okay, well, are you currently working, ma'am?
I am working 100% pro se, 5 lawsuit cases in 4 different dockets for free. No, I have not worked since May 15th when plaintiff refused my wage claim.
I think part of...
I keep losing my damn mouse. Sheesh.
Okay.
I think part of what she's suing him for is that he supposedly agreed to pay her a wage to renovate a kitchen.
Well,
I mean, possible. Yeah. Very possible.
I don't have the interrogatories in front of me, so I can't make a really independent assessment as to how much time is involved there. I don't know what, I don't have the information in front of me, so.
And Your Honor, if she does the deposition, the interrogatories can go away. I would just need a request for production. I believe there's 21 of those. If she does the deposition, I just ask her the questions. Because they, they're just normal questions about the relationship and things like that. The request for production, 3 weeks is, she's had since August, but I don't mind waiting 3 more weeks as long as I can depose her on the other things so we can, move on.
But you need those documents for them.
Her request for needing time to get her stuff together, that has nothing. I mean, I think if this was like attorney against attorney, it's a little bit different. But even in that sense, an attorney is only going to give you another attorney but so much time to get discovery to them. And then that's where these motion to compels come into play.
Was it like 30 to 60 days or something like that?
I mean, it can be, but like, think of it from this perspective, right? So if an attorney files a summary, a summons a complaint, that, is like sort of like initiates the court to start preparing for this particular case.
Right.
And they'll start off with doing like a preliminary conference. And in that preliminary conference, they'll set like a date for they'll set like for the bill of particulars to be done, for discovery to be exchanged. They'll set for a date for the and it's actually they're called EBTs also. Examination before trial is also what another word for deposition. So they'll set like a date for that to be done by and then they'll also like put on a calendar for a compliance conference. And usually the attorneys can like agree on when that date will be, or the court will just put that date on. So when they have that, then that's you wait for the defendants to send you the bill of their request for discovery, because that's how that actually starts with a personal injury. The defendant will send what information that they're asking for, and that's the discovery. And then that's where the bill of particulars is created in response to what they've asked for. And if you have more than one defendant, then you do more than one bill of particulars. And then you have to provide those bills of particulars to all parties too, which is crazy. It's a lot of paperwork. And then usually after that's done, if you miss information or if they want something else, then they may like request additional discovery. When you do depositions, depending on information that comes out in the deposition, might also prompt the other party to make further requests for discovery because of something that you've said. And then when they have like a compliance conference, the compliance conference is to check to see if all the things that all the parties have been asked to do have been done. If they haven't been done, then then they set to do that as well. And then there's never a chance when everything is done. That never happens. There's always somebody who's lacking something. But that's kind of like sort of like the course of
Okay, makes sense.
how it makes it through. And then like I said, but when you get these like motions to compel, a motion to compel is asking the court to make the other party comply with something that they were asked to do. Which, if I'm not mistaken, this is what this is. Like, she's asking the court, tell her she has to do this deposition. Tell her that she needs to give this discovery. And if she doesn't, do that, that's kind of where that summary judgment part comes in at. Because now you're just asking the judge, hey, we've done all of this. We've asked for this. It's not been done. Just grant our motion, grant in our favor. And that's why I said by not doing the deposition and not doing this discovery stuff, she's the one that runs the risk of losing stuff and not even being able to argue against it.
Right.
Because she's not doing what she's supposed to do.
Okay.
It's to a person's detriment if they don't follow what they're supposed to do and in a timely manner.
Makes sense.
I think 30 to 60 days is here and there. Like I said, in personal injury it's a little bit different because the attorney is not getting paid by the hour. They only get paid when they receive a settlement.
Right.
So it doesn't matter if the case goes for 6 months or 10 years. But in this type of circumstance where you're paying hourly and he can't not pay his attorney. He can't say, oh, well, let's wait until, she pays my attorney's fees.
Right.
It doesn't work that way. It's you pay your attorney, and when that person pays the attorney fee, you get reimbursed.
Right.
So that's why she says something about putting something on her assets. It might take him 30 years to get his money back, but, At least he would get it back or get something back.
Deposition, correct.
No, the deposition is about the CIR. That's just facts of them. Sorry, my cat's meowing. That's just the facts of their relationship. The documents that support that, she can have, she'll come in for the deposition, then we can have the request for production 3 weeks from now, deposition next week. We'd be done. And then she can supplement her spreadsheet. I don't mind that. What she's using to generate that spreadsheet is what, just give me a copy. You don't even have to give me a copy, come to the office and I'll make the copy. Anything like that, or tell me where I can subpoena to get the copy.
Okay. All right, so Ms. Gunn, here's where we're at. They want to do a deposition, they're entitled to do a deposition, so I'm going to require that you do that. What I am going to do and there's a whole number of parts to this decision, so I want you to listen carefully. One of the things I'm going to do is to make sure things are following through. I'm going to put this on for review next Wednesday. That will be in front of Commissioner Carmi, who sounds like she's somewhat familiar with your case. And that's to make sure that we've got a deposition set up or completed, or to make sure that that's all understood and everybody's on the same page and we're moving that forward. As far as the interrogatories, or the request for production, let's focus on that. When did we schedule the summary judgment?
I believe it's November 5th.
November 5th. Okay. So if we required all those documents to be turned over,
That's the first time I've seen him move his mouth.
maybe by the
Yeah, he hasn't said much.
November 5th, a week.
Oh, it's November 6th. Mr. Bob held up his hand. It's the 6th. Sorry, it's that Monday.
Okay. Yeah, I was looking at the calendar.
He did say
That wasn't
26.
Working right. So here's my thought, is that the request for production part of that interrogatories package that you got, I'm going to order that you have all of those documents, copies of those, provided no later than noon on the 25th. No, excuse me, yeah, noon on the 1st. That's 3 weeks out from today. If you have a challenge on getting a particular document, you need to indicate in writing where that can be found or why it can't be found. And what we're going to do on the 1st at 2 o'clock, that'll be again Commissioner Carmi at this point, make sure that those have been received by Ms. Winkle's office. And if they haven't been resolved, I mean, there's 2 dates. There's one next week on the 18th and one in 3 weeks on the 1st. On the 18th, Ms. Winkles, if you want to strike that, if you've got everything in order for the deposition, I'm happy to do that. Just let us know. Really the same on the 1st. If everything is in order, we don't need to have that. That can be stricken. But Ms. Granitz, I'm requiring that you appear for those 2 hearings, one on the 18th, one on the 1st, at 2 o'clock, so that we kind of see where we're at on this thing and make sure you're following through.
And Your Honor, my only question is, can we have a drop dead date to schedule the debt? So I guess, if she called me tomorrow and said I can do it in 2025, that's going to be a problem. Can we have a date where we have to schedule it somehow before then? And I'd even do it on a weekend. I don't know if the court reporters will do it, but I'm really flexible here for her.
You need it before the summary judgment.
No, because that's really questions of when their relationship began. As long as she's willing to answer that, I think we're in agreement anyway from some of her pleadings. But I would like it before, definitely before the 1st.
So
I guess I can do it for the 1st. I mean, if we could do before November 1st, that would be wonderful.
And that seems reasonable to me. And that's what we'll take a look at next Wednesday to make sure we've got it scheduled, everybody's in agreement. And you can, so did you get all those dates, ma'am?
Yes, Your Honor, may I request the opposing party provide their interrogatories as well, so we have balanced packages to look at, because they have not provided me any discovery while they're motioning for sanctions for my lack of discovery.
And
So I want
absolutely,
discovery at the same time as well, please.
I will provide that to her before the 18th.
Okay, so that's before next Wednesday, you'll have that.
Yeah. And I have it done. I'm just waiting on a few documents, but I'll let her know which documents I'm waiting on, so she knows how long it will take.
Okay? So, you've got basically 3 weeks to get all of the documents that you've been requested to provide. You're gonna have to participate in the deposition sometime before the end of the month, basically. So you got about 3 weeks. So you work with Ms. Winkles to get that scheduled. And then we're gonna review it next Wednesday on the 18th and 3 weeks on the 1st to make sure everything's going the way it's supposed to go. And I'm gonna give you a gigantic carrot, ma'am, and that is, I'm not going to impose anything other than, as of today, I'm gonna impose the cost for the reporter. If you don't follow through on these 2 requests, when you come back on the 1st, I think there's a request for about $6,000 or something like that, and whatever that number is, I'm gonna award that amount of money. So that'll be either paid by you or come out of whatever ultimate settlement there is. I'm not gonna order that today. So I'm gonna give you an opportunity. I'm not saying I'm not gonna order it at all, because there may be some fees that are adjusted as this thing moves forward, but what I'm telling you is if you do all the stuff you're supposed to do, I'm not gonna order that immediately. I'm not gonna promise it won't get ordered, but I'm not gonna do it by that date. Does that make sense?
What I hear you say is if I appropriately get my financial report showing my last 5 years of intimate committed relationship.
That's not what he said, but whatever.
Contribution investment in, it will save me $6,000 in fees. So I am motivated to get my report in aside from the fees, and that just adds to my motivation. I will get my report in, Your Honor. And it will incorporate the elements of the interrogatories that may match the format.
And Your Honor, again, just so I can stress, only those questions that say request for production, she needs to answer, because anything that says interrogatory, she doesn't need to answer, because I'll ask her that in over Zoom. It's just the ones that say request for production, and there's very few of those. That's all I need from her in written format.
So let's do this. You have those, I assume, in a document that could be.
I will email it to her.
You could email just the questions specifically that she needs to answer, so there's no question.
See, that's the type of shit that I don't
So
like.
Ms. Grunitz, you're gonna receive an email that
I
has
don't make me do extra work because you're not capable.
before we come back on the 1st.
What do
I
you
don't
mean?
want you to spend any time on the other questions, just the ones.
So the attorneys decided that there are questions that are in this interrogatory that she can just ask at the deposition, which is true. She only wants this woman to respond to questions, I think, that maybe require an attachment. So the attorney is now offering, because the judge requested it, basically, to just send her those questions that require an attachment. To me, that's giving me extra fucking work to do. Why can't she just hear the directive, don't answer the interrogatory, only answer these, and then leave it at that? Why do I have to now go into a document and delete everything that she doesn't have to answer? I don't understand. And even if she could be asked these questions in the deposition, just have her fill out the fucking document. Like, I get this, that they're trying to make things easy for her because she's pro se, but she's pro se. That's not my problem. Like, and I get that, regular people don't know legalese, don't know the, ins and outs, the rights and wrongs of litigation, but I mean, come on now.
Right.
I mean, do you want to hold her hand and give her a lollipop when she gets an answer right? Like, what is the problem? And this is not like this is a person who's feigning that they're dumb, you know, or they don't get it. She's at any chances she's had, she's spewed her intelligence and her capabilities with things. So are you not capable of reading a question and skipping it?
Right.
I have an irritation of when people need things to be simplified for them, when it's like things to be simplified at the expense of me, and then completely, to me, unnecessary.
Right.
But then again, too, if the attorney knew that she could ask these questions in the deposition, then why the fuck did you include them in the first place?
Yeah, true.
Just ask them in the deposition. I mean, half the time, it's repetitive anyway. The same stuff that goes into a bill of particulars gets asked in a deposition. But you still put it in writing.
Right.
That you have to get answered so we can keep your case moving forward, okay?
Thank you.
All right.
I appreciate that, Your Honor.
I didn't catch that, but that's probably okay.
I just said thank you.
Oh,
I
welcome.
will answer those specific questions before anything else.
Work
Okay.
on those, and then you got to participate in the deposition, work with Ms. Winkles, because we're going to come back next Wednesday. If it isn't scheduled, then I'll instruct Commissioner Carmi to simply schedule it, and you'll be expected to show up. So,
Can we schedule that now? I'm looking at my calendar. I have court on the 31st. Is there a chance to schedule it sometime after that? I have documents. I have 4 different cases in 4 different dockets.
Nobody cares.
I have a huge trial coming up on the 31st, and I think this ties with that. So if I can just start after that time, if I don't have everything else satisfied by then, because I'm looking at closing this case by then.
hold on just a second.
So the whole everyone will be unnecessary.
All right, Ms. Grimes, the connection is not real good, so I'm going to have you and Ms. Winkles schedule that by phone call offline, just so we don't get any misunderstandings. Okay?
Translation, I don't want to hear anymore.
She wants to do November 2nd, because it sounds like she has a trial on the 31st in a different case. I'm fine with that. I would just need from, let's say 9 a.m. to noon, and that's it. And I can give her the link, and we can do by Zoom, and if connection's bad, I'll direct her.
All right, I'm going to have you guys schedule that.
Yeah, the judge asked you to leave. And
Next Wednesday, we'll review it. I'll talk with Commissioner.
I'm gonna be
Carmi so
funny
he's
and
up
say,
to speed
now
on
get
what's
out.
you ain't gotta go home, but you gotta get the
Thank
fuck
you.
out of my courtroom.
Thank you.
You're welcome. Have a good afternoon.
Wow. Wow.
Clearly he was tired of hearing the static. He was like, and then the attorney still had to finish her. No, he said to go. He said you need to leave.
There was a review hearing on October 18th and another on November 1st that I don't have copies of. But Odyssey says that Commissioner Carmi ruled on the deposition date and she reserved on attorney's fees. She also struck a motion by Mandy, who was trying to get advanced lawyer fees and costs.
Okay, let's go to the Groundnets and Boff matter. I have 232-0053-908. Ms. Groundnets is with.
I'm not trying to be funny, but if the both of them were not in this like screenshot, you would think that they were related too. I don't know what is it. The glasses,
Oh,
the head
yeah.
shape, the hair color. Like, is that your mom?
Ouch. Stop being
I mean, it's not
judgmental. Stop it.
It's not an insult. I'm just saying they have they look alike.
Stop it.
Huh?
Stop it.
Is that being judgmental to say that they look alike? I'm listening.
What do you think, chat? I say no, but
They look like they could be related. I'm starting to wonder now about Washington. Looks like there's a lot of, you know,
I don't ask.
multi-relationships going on here.
I don't ask.
Thus, Ms. Winkles is present representing Mr. Bopp. I have this both on a motion to compel and a review hearing on attorney fees. Let me jump into the digital file quickly.
And I'm sorry if you can hear my dog snoring behind me. He's very old and it's very loud.
I can't hear it, but.
Oh, good. It's very loud. I was concerned. He's 15, so he's a loud old man.
Okay, so when we were together last, there was a deposition that was going to take place the next day on 11/2. So I reserved ruling on attorney fees to see if Ms. Grounitz appeared for the deposition. So we set that on for today. I said I would consider a motion for partial attorney fees, even if Ms. Grounitz did appear for the deposition, based on the amount of time it took to get her to a deposition. So let's start with that issue. What happened with a deposition occurring?
The deposition went through. Quite happy about that. That was absolutely fine. Concerning the motion to compel, based on the interrogatories and request for production, we kicked out the interrogatories completely, and we only requested the request for production that was under Judge Basher. We've now been requesting the same things on, I believe this is the third one we've been in front of. Your Honor twice and Judge Basher once, or Judge Basher twice and you twice. We still have only received bank statements. We've received nothing else. On the deposition, quite happy about it. But the fact is that she has a duty to respond to the request for admissions. We cut down our questions significantly. We tried to make every accommodation. We've had, and this is just in the Replevin, obviously the CIR is something completely different, and we have a Sierra 26I going on in that. But the fact is I don't have everything I requested. I don't even have a third. I don't even have maybe an eighth. I probably have an eighth what I requested. I don't necessarily want the attorney fees. I would ask that we've already done attorney fees. I would ask that at this point, if she doesn't get them to me within the next 10 days, that you strike her pleadings. Because this is a case that is paperwork intensive. It's necessary to put on a defense. It's cost my client probably more than the property's worth at this point. She has turned over to my client about half of the property, not the vehicle and things like that. But it doesn't matter because we need the discovery. And so rather than attorney fees, since we've already done that and it doesn't seem to be doing the job, I'd ask that her pleadings, she have 10 days to materially answer the request for production and deliver them to my office. And if she doesn't, that Your Honor will strike her pleadings. And hopefully that will get us the documents we want.
Ms. Grounitz, I'm going to come to you in just a second. I'm just reading from Judge Basher's, I believe, October order, where he heard this issue initially. He did specifically order that if documents were not submitted by October 25th, 2023 at noon, the pleadings would be stricken.
That's correct.
So essentially what's being offered at this point is an additional 10 days before that remedy kicks in. Ms. Winkles, what documents are still outstanding? Or I think you said some had been responded to, is that correct?
Everything but the bank statements. So there were, I believe, 30 different documents we are seeking, 30 groups of documents. Only one of them was the bank statements. So we are missing 95, 97% of the rest of the documents.
250 years ago, a promise was made to connect families and friends near and far. How we delivered.
Oh.
All right, Ms. Grounitz, let me turn it over to you. Let's focus right now our discussion on the documents that you need to get to Ms. Winkles that Judge Basher already ordered you to get to Ms. Winkles. What can you tell me?
That was My intent with the first notice of unavailability, I gave myself adequate time to provide discovery. Council has brought forth 10 hearings, which equates to 20 hours apiece for me. And mathematically, if I need 80 hours to provide discovery, she's brought forth 10 hearings, that's 200 hours that just got in my way of providing the discovery. Hence the second notice of unavailability to block out further hearings, preventing me from getting this discovery in. I'm quite anxious and excited to provide this discovery, but I can't provide discovery every time I get issued another hearing. So the discovery is in wait, it's just waiting to be labeled. I have 200 pages of interrogatory requests on two cases. So obviously today is an example of going from a family law matter to a civil suit. The civil suit was inappropriately filed, and I would ask the court to assist counsel in narrowing down her ability to focus on one task at a time, which is the CIR, the only appropriate court.
Okay, so Ms. Brownitz, what I'm going to do right now is assist you in focusing on the issue at hand on this docket. We had to do that on the last docket. What I'm asking, Ms. Brownitz,
and I am getting into her, and I promise her those by Friday.
Ms. Brownitz, I'm going to ask you some very specific questions. Those should just be short and sweet answers, okay? So as it pertains to this issue, can you get those documents to Ms. Winkles within 10 days?
I notified Winkles I would be delivering a package for the CIR, which has the exact same questions as this, by Friday. And I actually promised them, I started last Monday, but every time, yes.
They are a different case.
The interrogatories for the CIR will be brought forth, and this case needs to be dismissed.
Okay, so my question, it sounds like your answer is yes. I want to confirm, you do believe that you can get the documents to Ms. Winkles within 10 days from today?
If I have no further delays from the opposition, yes.
Okay, I'm going to take that as a yes. So I am going to issue, Ms. Winkles, if you want to draft an order similar to the October order, indicating that Ms. Winkles has 10 days from November 15th to serve the answers to all interrogatories and requests for production.
Ms. Gronitz.
Gronitz, thank you. And hold on. And that this is a extension of the court's prior October 19, 2023 order. And that failure to do so will result in the court striking the pleadings of Ms. Grounitz in this matter.
What pleadings? What pleadings are we discussing? I haven't cited anything on this case.
All of your documents.
In other words, they'll be deleted.
Okay. So it is very, very important, ma'am, that you file your responses to Ms. Winkles. This is your second chance. The Judge Basher already ordered this remedy, but I'm giving you 10 additional days because Ms. Winkles and her client are offering that.
Wow.
Okay?
That's being generous too, folks.
And then Ms. Winkles,
I wouldn't offer her shit.
Wanting to hold over your request for attorney fees at this time, or are you moving forward on that today?
No, I'd like to hold over until the next, again, I want the discovery more than we want the money at this point.
Okay, so then let's set you for November 29th, which would be a 14-day review of how this went. Ms. Brown, can you be back on this docket November 29th? 2 o'clock.
Likely.
Okay.
Let me check. Yes.
Okay. And then we'll go ahead on the attorney fee review. We will continue that to November 29th.
Thank you, Your Honor.
I missed the time.
2 o'clock.
1 o'clock.
2 o'clock. 2.
2 o'clock. May I request that council stop issuing subpoenas and quit monitoring, stalking me via process server so that I can have a moment to release. My property's been surveyed, I've been stalked, and it's not helping the discovery process.
I'm denying that request. If you have a motion with evidence that you want to bring forward, please do so. Okay.
I will do that. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Grip, stability.
Is that what she was referring to about her life being in danger in the last case?
Build a website you love with Wix.
So she's being like stalked or something?
For your words?
Yeah, I don't know.
You all are free to log out.
All right, so we're hearing the matter of Mandy
Oh man, not this
Roberts
man.
and Nathan Bob, cause number 233-34408. It's scheduled today for a motion for summary judgment.
This is a no
I
nonsense
noted
guy.
from the clerk.
Look, it's Judge Evans, but he's not wearing my favorite snazzy bow tie today.
That Mr. Bob and Ms. Granitz are also scheduled for 9 a.m.
You know, the thing is just he's just very dry.
So-
They are.
So maybe we could just touch base first on that. So I'm assuming Ms. Granitz would like to be present. So would it be wise
But it's
to
also a
pause and maybe just get an
no-nonsense.
idea where they're at as far as their dockets before we proceed, or any thoughts you may have?
Well, I'm going last on that docket, so I've already explained to Commissioner Carmy that I'm on this docket as well. Let her know that if we could go last on that docket, and she said that was fine. I'm not sure if Miss Granitz, I don't see her. Unless she's in the courtroom, she's not on the Zoom for that, because I'm on both.
Right, and I'll double check with the court clerk. I poked my head into the courtroom too, where it's scheduled and it's noted to be today. I didn't see anybody in the courtroom, so I'll double check with Madam Clerk. Do you see anybody in the courtroom 2?
There is no one in courtroom 2, but people are allowed to go into the courtroom in the protection order docket, so she may be in that courtroom.
Okay.
I don't, I mean, there are about 10 people in there. I don't see her amongst the people. I do know she's returned about half of the items, so I doubt she'll be here today. It's just the remaining half that she hasn't. And she hasn't put in anything into the court file.
Right.
So I would doubt she'll show up for this part because it's a very specific partial summary judgment. It's only on items purchased before 2018 that we're talking about.
Right. So Ms. Winkles, you indicated that you're looking at courtroom or the protection order docket right now. You're looking at the individuals.
Yes.
And
I'm looking at it.
do you see her name listed as one of the?
The husband's not there either.
She is not listed, and
I don't think he needed to be.
in the courtroom either.
And that's not the husband, his
So
ex-boyfriend.
You have a visual on the actual courtroom.
Yes, I do. I have a visual in the courtroom as well.
Get it correct.
Do you know which courtroom it is?
Courtroom
Junkie
one.
needs to get it together. Yeah, I know.
I think what I may do, I may ask one of my assistants to just make an announcement in courtroom 1 for Mandy. How do you pronounce the last name?
Granitz.
Granitz. Okay. So Mandy Granitz, I'll ask if she's present, and then I'll have them report back.
Okay.
And would you mind waiting just a moment while I verify that?
Nope, not at all. And Commissioner Carmy is explaining protection orders right now, so this might be a great time.
Good. I'll hustle over there. I'll stop my video and be right back. All right, Madam Clerk, let's go.
Oh wow, they
on the
stopped
record.
videos.
Ms. Granitz and Mr. Bob are here. Ms. Granitz is joining, although it's slow.
We are on the record.
Okay, we're reconvening in the Mandy Granitz and Nathan Bob matter 233-34408. Ms. Winkles is present. Mr. Bob is present. And it shows Mandy Granitz is trying to join, but has not yet joined as of yet. So I confirmed with my assistant. She went to Commissioner Carmy's docket, did not see Ms. Granitz in the courtroom, and Ms. Granitz was also not on the Zoom call. I returned to my courtroom here, and I see that Mr. Bob was here, Ms. Winkles was here, and that Ms. Granitz is still in the process.
I just want to get something.
Joining. You know, when it says that a person is in the waiting room, and then you admit them, and then they're in process of joining And at this point, the joining has not been successful. So I'm not sure what to do about that, other than I'm wondering if I can send a chat to her. No, it doesn't let me do that until she's actually part of the join.
I can email her real quick.
Okay.
What would you like me to say?
Oh, looks like she's in.
Oh, never mind.
Right, so she's in now. It's connecting to audio.
Let me know
so
when you come
maybe
back.
another pause as we wait for that. Okay. All right, we're here in the matter of Mandy Gronitz and Nathan Bopp. The cause number is 233-34408. We have Ms. Winkles present representing Mr. Bopp. Mr. Bopp is here. And I see Mandy Gronitz is present also. Ms. Gronitz, can you hear me? Let's see.
Gronitz, can you hear me?
Yes, I can, Ms. Gronitz. Can you hear me okay?
Yes, I apologize. I'm having some connection issues. I was trying to call in to get better clarity. I don't have the right meeting password, so if this works, I'll just go with this.
Okay, that sounds fine. We're here today for a motion for summary judgment brought by Ms. Winkles on behalf of Mr. Bopp. Ms. Winkles filed on behalf of her client, she filed a motion for partial summary judgment, also a memorandum of law, which is just one document, and then she filed a number of supporting documents. And it looks like those are served upon Ms. Gronitz. And then Ms. Gronitz, I didn't receive anything from you. Did you file anything in response to the request made by Mr. Bopp? Ms. Gronitz?
I don't believe you have submissions for this particular issue.
I'm here.
Okay, so the only thing I heard, you may have been speaking for a little bit, the only thing I heard was this particular issue, just that phrasing. So if you said something before that, if you could repeat it, please.
I believe you're going to run into connection issues. Is there a way to call in and get a better reception?
There is. If you...
I'm missing the meeting passcode. The passcode I have has...
Game, did you hear me? Uh-oh. Game. I think he abandoned us. I see your mic blinking, but I don't hear anything. He might have stepped away.
Initials, and it's saying it's the wrong one when I call in. I have 821820JC2020.
Yeah, I have. Yeah, so again, meeting ID 863-043-0413. And then
yes, it's the passcode.
1820 J as in John, C as in Charlie, 2020.
And when I enter that, as I call in, it won't accept it in the call. I've been trying for 10 minutes.
Okay, I'm just going to experiment and make the call using my phone and see what happens.
Your Honor.
Yes.
The passcode at the bottom of the screen, it says 348531.
Oh, yeah, that may be. It looks like there's a passcode for the Zoom apparently, if you for the video and audio. And at the bottom, following the listing of various phone numbers, there's a passcode of 348531. Thank you, Madam Clerk. So maybe, do you want to give that a shot, Ms. Gronitz, and call one of those phone numbers, use the same meeting ID, and then just use that different passcode, which is 348531.
Yes.
Okay. Well, I'll just wait for a bit, and then you can do that, and then let us know how it goes. All right, let's go back on the record.
I'm here, Your Honor.
Okay, very good. Thank you, Ms. Gronitz. So I'll just get the clear from the clerk that we're on the record, and then we'll commence. Okay, great. Thank you. Okay, so let's just start afresh. Again, this is Mandy Gronitz v. Nathan Bopp, cause 23300344408.
I kind of feeling that was a sneaker commercial.
Ms. Winkles is present, representing Mr. Bob. He is also present. Ms. Gronitz is here. And just confirming, Ms. Gronitz, you can hear me okay with the phone?
Welcome back.
Yes.
Very good.
Barry.
All right, so we're here today on a motion for summary judgment brought by Mr. Bob via Ms. Winkles. I reviewed
I have a
the motion
transmission
for partial
issue.
summary judgment and also accompanying supportive documents. And I wanted to check with Ms. Bob, did you file anything? Because I didn't see anything that had been filed in opposition.
My filings have not been submitted to the court on this case. I've been working with the other cases and trying to work with the attorney separately. The issue at hand is separate property that she's arising. That's not technically the issue that we're facing on this case, but what I'm reading is that she's trying to identify Mr. Bob's separate property prior to the CIR, and then he's had an issue of exchanging property. I've had his stuff, he's had my stuff. I've coordinated a third party to make exchanges for the separate property. So this motion for summary judgment is premature and not really relevant to what we're trying to solve on the case. But as far as property before the CIR, I haven't argued that.
Nope.
I have no idea what she's rambling about. I think that his attorney is just trying to finalize something to keep things moving, and that's where the summary judgment comes in at.
I think, to me, and I'm just gonna say this, attorneys have the right to talk with judges, right? If there's nothing being done, I'm just gonna say this: if nothing is being done on one party, she needs to be held in contempt.
Well,
Sorry.
that's what the sanctions and the attorney's fees kind of come in at. But does a judge discuss a case with an attorney without the other party present? Not necessary. Like, I don't think they're really supposed to do that.
No, I don't mean discuss the case necessarily. I'm talking about if the paperwork isn't completed the way that they need it completed, they can't move forward.
Mm-hmm.
So what is with all these hearings with no resurrection?
Well, but that's what the summary judgment is basically like I said, like it's asking for a decision to be made with the information and that they have now, which would help start putting some closure to what to all these cases that are all these cases that this lady has. They're trying to knock out whatever the easiest thing is for them to knock out. And I'm guessing that's the ending their committed relationship. I think this lady needs to take some type of relationship course or do some soul searching.
Oh.
Because
I feel bad for this guy.
I think it's normal. Like, it might happen to be in like one bad relationship, but like if you got two people, more or less it seems back to back, having to take out a protection order against you, that's concerning.
Might be something wrong.
Pretty
Just
much.
saying.
Oh, we still got 2 hours and 15 minutes to
We
go.
just haven't identified what is and isn't separate property yet.
Okay, so at this point, what I have before me, Ms. Gronitz, is that I have Mr. Bob's version of events, and that the rule CR 56, Civil Rule 56, indicates that there has to be specific pleadings or affidavits that set forth specific facts showing that there's no genuine issue for trial. And that's kind of the standard we use. So if there's not a response, it says if the adverse party here, you're the responding party here. If you don't respond, it says summary judgment, if appropriate, shall be entered against that adverse party. And so without any pleadings on your end, Ms. Winkles is entitled to judgment. Can you tell me?
However, this is a notice of unavailability. I put in a notice of unavailability 3 weeks ago. I've asked for a continuance 5 times so that she and I can get on board with each other about this. So the fact that there's trial today, it goes against my notice of unavailability.
And so, once again, that's where the summary judgment comes into play. She's not providing anything, just make a judgment in our favor.
Well, let me just read it to you, and because I had a question about that. When I read over I did notice your notice of unavailability that you did file. You filed 2 of them. I'll take a look at the most recent one, which was filed on October 20th. It states, please take notice that commencing October 12th and continuing through November 13th, Ms. Gronitz will be out of the local area and unable to attend in-person conferences, court dates, or the like. Petitioner, Ms. Gronitz, will maintain accessible and responsive to court matters via phone or internet. Petitioner will continue to actively work on case file resolution options during this period. So what that tells me is that you're not available for in-person. Like if we were to meet here at the Hall of Justice, you're telling me you can't do that. And then you're also telling me that you will continue to actively work on the case file and you will maintain accessible and responsive to court matters via phone and internet. So by your presence here today, I'm assuming that that notice of unavailability as filed applies because you're not here physically, but you're here electronically or via phone. So help me understand your position on that.
My position is I'm working remote. I have 80 hours of discovery to get to counsel. I've had a handful of court dates thrown at me and a handful of basically what I call red herrings, preventing me from getting her the discovery that I need to get to her. So in the last 2 weeks, I've had to field 100 hours of work to overcome the 80 hours of discovery. So everything that's happened in court, which is a handful of motions and gestures on opposing parties' part, knowing I'm not available, pressing for discovery, and not allowing the discovery process to take place. So I put in the notice of unavailability with the intention of working with counsel to get the discovery information to her that she needs to support her case. Because she doesn't have the right support data yet in her possession, and I need to get it to her. And every time I have to come to court over a different motion, which has been a handful of times the last couple of weeks, it stalls this process of discovery. My priority is discovery. Her priority is pressing forward and not allowing it to happen. So I am requesting to have the discovery and have the cases actually match up because her information is not true, not accurate. I have the true and accurate information, and I think that if she had the information, she could better position herself and her client.
All right, thank you, Ms. Gronitz. One question. It looks like on September 29th, there was a docket notice sent to you indicating everyone would be joining together on October 11th to choose a date for the summary judgment motion. On October 11th, Mr. Bopp was present, Ms. Winkles was present. You weren't here, so the court went ahead and set the summary judgment for this week. And then on October 31st, we met again after having the case be heard back on that date. Mr. Bopp was here, Ms. Gronitz you were here, and we set it for today, confirmed that would happen today. So at that time,
this is the first time I've actually been able to log on. So I was present at both those other meetings, but I wasn't able to actually have a voice in those meetings. And it's been communicated several times to get a continuance both with Ms. Winkles and to the court office because I was not able to get on. Because I am unavailable, I'm working remote, and I don't have good service, and I don't have availability or a way to get to where I can until the 13th. So everything, all these court dates needed to be postponed until the time I could actually get reception to make it to the hearing and have a voice in the hearing. Because it's frustrating to hear you guys make these judgments and not be able to actually say anything when I'm sitting there watching it. I was there the last meeting, I couldn't unmute, and so they pressed forward and pressed forward. So we can continue to press forward, but it's not in Mr. Bob's best interest to do that. And I'm trying to make it clear to his counsel that her pushing her agenda is not helping her client. Now, if she wants to push her agenda and make the summary judgment, I have to take repercussions measures.
She's pushing her agenda to move her client forward.
The efforts that she's
Dummy.
putting forward, to push this forward. And that doesn't look good for her client. So I'm in a position where I'm trying to help her client more than I feel like she's helping her client. And I'm about ready to check out because I'm done everything on my part to be cooperative and to be assistive in this. And I'm getting nothing but cussing and resistance and a drive. They're wanting to drive this case. This case has 30 line items. The writ of Replevin, which is consumed the majority of the time, has 80 line items, and then the protection order docket has about 60 to 80 line items. So out of the 3 dockets that involve Mr. Bott, this case has been the most neglected and now getting pressed forward above the other ones so that she can motion for separate property with the full intention of having me arrested for the property that I'm possessing of Mr. Bott that I just unloaded at his house. So I'm looking for fair and reasonable outcome. They're looking to have me arrested so Mr. Bott doesn't have to have a divorce or pay me the 1099 he's outstanding from last year. I have a federal tax evasion issue I've been trying to resolve. I have to let the IRS know, are they taking measures or am I fixing this here?
Ms. Gronitz, do you mind if I just interrupt you shortly? I'm
done.
No, it's okay. We were talking about your presence at a couple of different hearings. On October 11th, there was no showing that you were present. On October 31, there was a comment by the clerk that you were present, but not responding, and that could have been due to internet connectivity issues. So I just wanted to make that clear. So we've heard from Ms. Gronitz. I'll hear from Ms. Winkles, please.
In other words, she never showed up.
Yes, Your Honor. The issue I have, even if she were present or even if she weren't present, the fact is that she has to submit something. You don't just get to go to court and say whatever, because then it's not properly before the court. So her duty, unfortunately, if you have a lawyer, if you don't have a lawyer, is to read the court rules. And CR 56 is written in such a way that it's pretty understandable. It's deadline oriented. It's you have to file a declaration or an affidavit confirming your side. That is what she needed to do. Even if she didn't show up today, if that were here, I wouldn't just get what my client's asking for, because then you have something before the court. You can make the determination based on the facts before the court. Her argument about she didn't know, she hasn't been able to argue, it's problematic because there's nothing before the court. We have nothing to go on. And I gave Ms. Gronitz a lot longer than the 28 days, which is the minimum. So she's had since September to put in something, and she's put in nothing. I, in fact, didn't think that there was a problem with this particular issue, which is why I kept pressing forward saying, this is such a small issue. This is the 2018 and before stuff. And I'm not asking for it to be returned. Obviously, this is not an injunction or anything of that nature. This is purely determining that anything 2018 before separate property, not capable of being distributed under a CIR, it's a question of law. Anything that was purchased before then, and we have a list. Now, I did expect maybe she was going to put a list in of things that weren't purchased before 2018. She did not. We did put in receipts and the like. There's no question of fact. You have no declaration here. You have nothing here. The court rule is very clear. Even if she weren't here, it wouldn't matter. Even if she came on the 31st, it wouldn't matter because nothing's before the court. So I'd ask Your Honor for a judgment that anything prior to 2018 that's on the list on Exhibit F, that's listed as before 2018 is separate property, not capable of being distributed under a CIR, and therefore it's not an issue. Then I can, obviously, the Replevin, we can see what's actually been returned in that. Obviously, my client's stating that there's not a CIR. That is a question of fact that has to go before a fact finder that's going to trial. The questions about discovery and the like, that's a completely separate issue. I'm not sure, there was orders in the other cases on when to turn that in. They haven't been met in any event. We're waiting on that. But this is such a small issue. It's a very finite issue. Whether or not they both agree on the date they got together, whether or not anything before that date is capable of being distributed in a CIR. And if the answer is no, and according to case law, it isn't, it's not like a marriage and that you can set the properties on the table. It's only during the marriage or during the CIR. If that's the case, then anything he purchased of the things she took before 2018 are separate property, and he's entitled to a judgment that those are separate property and they belong to him. And then we go from there, whether or not they've already been returned. I'm not going to go for a replevin on them. If they haven't been returned, then I'll obviously talk to Miss Gronitz and Mr. Bach about that. But this is really just determining if separate property is capable of being distributed in a CIR. And if not, then that should belong to Mr. Bach, and that's it.
Thank you. So, Ms. Gronitz, what are your timeframes? What's the earliest timeframe you can have your material submitted?
Your Honor, I am not technically objecting to general property before 2018. However, there was a 5-year relationship and the ownership of set items, specifically a handful of tools, are up for question. I have been working to try to return Mr. Bach's personal property to him since June. So in my opinion, this entire case is unnecessary and just excessive litigation. Once I can return Mr. Bach's stuff, I don't know specifically on the list what would even be up for question, because as far as I'm concerned, Mr. Bach is missing a bunch of his personal and sentimental effects from the remodel that took place in March, and I've been working to return those. I know a good majority of those items were returned this weekend. I don't argue to keep anything associated with Mr. Bach specifically. I don't want any of his personal items. So as far as going for the summary judgment, like I said, the whole purpose was to press the summary judgment because I have his possessions so that she can chase after me with a writ of requiem to say I stole his possessions, although they were transferred during a legal remodel. I have legal possession of his items, but I don't want his items, and I'm trying to return them, and I've had counsel in the way of allowing me to return his separate property. So instead of working with me to give him his stuff back, she's pushing all of these legal issues, driving up his costs. He's already paid her more than the property that he's arguing for in this case. So as far as making a judgment on pre-2018 items, generally that would be fine. But there's a handful of tools that I don't know. There's a things on the list. So if we make the summary judgment today of pre-2018 items being his, that's fine. I don't want her chasing after me with the writ of requiem, saying that these items are stolen because they're trying to invade my property and have the sheriff go up and do a search on my property for some other purpose other than this. It's not about the personal property. I've been trying to get him back his stuff, and she's been blocking my way to press litigation. So my solution is let me give his stuff back, see what we're arguing about after the fact. But I've been stuck with his possessions in my spot, in my storage. My stuff is sitting out in the rain.
I don't think this discovery that she claims she has even exists. I think she's a liar.
All year because his stuff is in my prime storage so that it doesn't get ruined because it's the client project materials, and I take good care of any client possessions I assume ownership or responsibility for. So,
Can I ask a specific question, Ms. Gronitz?
When you want the cocktail, but not all the calories. The cookies without the compromise. When you want the brownies, without the frownies. When you want a glaze, without guilt.
I like
Sip
food.
without second guessing. When you want joy, not...
I already have Truvia.
Can I ask you a specific question? There's a allegation that there's a boathouse purchased by Mr. Bopp in 2017. Are you contesting that?
No.
Okay. There's a contention that there were tools purchased tools and property purchased prior to 2018. Are you contending that those do not belong to him, or they do or do not?
A handful of tools land in the gray area. I know some of his bigger tools got returned. The table saw that with all of his large items that were easily identifiable for the third party to take back have been returned in my belief, or that was what I was informed yesterday. So we had this table saw. I'd have to review the list, but as it is right now, his items are in my storage. I want them out, and I'm being blocked from returning them while also being chased after for theft. So I didn't steal anything. I'm not necessarily contesting pre-18. However, we did have a CIR. We worked together 5 years, and I have been using tools exclusively to run my business during that time. I don't necessarily want any fee. It's replacement value. We're arguing replacement value only, not the actual possession, or not the actual item.
Thank you, Ms. Gronitz. A follow-up question. You indicated that you'd need time to review the list of tools and property. How much time, this goes back to my initial question that I didn't hear a response to, of when do you think you would have your materials ready so we could have this hearing and make a determination, which may, if you get those materials in, may obviate or prevent the need for having the hearing. But I just need a general time frame when you feel you would have your response to the motion for summary judgment submitted.
The response can be submitted Wednesday. I have an agent available to take it to the courthouse. I have to email, because everything has to be paper submitted into court. It makes it challenging when I'm 2 hours away. So I can, Wednesday, I can have that paperwork in. Today, I have arrangements to go find good internet, to upload all the files, to give the Winkles, so that we know what we're actually arguing over.
So you think by Wednesday of this week you could have your materials shipped off and submitted to the court and the other party?
I would like to say yes. I know by November 13th, or whenever my unavailability takes place, I can make it back to the actual storage unit and finish getting the possessions that Mr. Bopp had. So if we set a date 2 weeks from now, we can have a much better standing on what we're actually contesting.
Okay. Ms. Winkles, so I'll just kind of tell you where I'm leaning. I'm leaning towards continuing the motion to a trial setting docket on the 8th of November at 1:30, choosing a new date for a summary judgment motion, which could be as heard as soon as, maybe the 20th or the 27th, I'm not sure, but I'm looking at that and just want to hear your thoughts.
Yes, Your Honor, I think my thoughts are going to be the same, just going off of the court rule. She had a certain amount of time. She's had that certain amount of time since, she had more time. She didn't do it. We keep giving her more time on everything. So if this had been the first time this had happened, I would say absolutely. And I'm very happy to give continuances. I'm personally not getting paid for this anymore, because she's absolutely right. By now it's gotten so much because of all these continuances that I can't charge Mr. Bopp anymore. But she's had continuances literally on everything for weeks and weeks. And so I'm just back in court every day. And so for me, I think the court rule should stand. She had a certain amount of time. She doesn't know if she contested or not. She could have looked at that property. She could look at it right now and tell Your Honor, this, no, this, yes, this, no. I mean, it's not a very long list on Exhibit F. The fact is that she's dragging her feet, and it's costing me money at this point and me time. and it's cost Mr. Bob money and time before that. So I'd ask that she doesn't get a continuance. Putting this back on the trial setting is just going to be the same thing. It's the same thing with the discovery. We've been put on, you know, she's gotten 3 continuances. We've been put on. I still don't have it. So now I have to go back to court on that. It just makes this really expensive. And I can't justify it to somebody who's looking for 25 grand worth of property to have a 25 grand bill. It just doesn't make any sense. So I'd ask that it not be discontinued. It's prejudicial to my client, really prejudicial. And because it costs them so much, and Miss Gronitz has the rule in the, I mean, you can Google it. And the fact is she could have put a declaration in that said, I don't agree. And these are the things I don't agree on. And these are the things I do. It could have been 1 page. And she didn't do that. So I'd ask that we go forward today. But if we have to set it over, we'll live with it.
Great, thank you. Well, I don't disagree with the notion that Ms. Gronitz could have filed something, could have filed a note that said, I disagree, or I agree with these certain aspects, I disagree with these certain aspects. But it's been crickets. We haven't heard anything. The paperwork clearly indicates that Ms. Gronitz needs to respond by a particular time frame. That time frame is passed. So I'm going to put a filing deadline that any responsive pleadings to the summary judgment must be filed no later than Monday, November 13th. That's the cutoff date. So Ms. Gronitz, make sure you have it filed by that time frame. We'll be back here on November 15th at 1:30 to choose a new date for the summary judgment motion. I am also assessing $500 of attorney fees that Ms. Gronitz will need to pay to Mr. Bob for the dilatory action or lack of action. So Ms. Gronitz, November 13th, they give me a little extra time. You said on the 8th you'd have it ready. So I'm going to give you until Monday the 13th, close of business. Everything will need to be filed and shared with the other side. We'll be here on November 15th at 1:30 for the trial setting docket, at which time we'll choose the summary judgment motion date and the $500 for attorney fees. So I think that's any clarification or questions on that issue?
No, Your Honor.
Ms. Gronitz?
May I request that they stop putting in frivolous motions? I offered relief to return his stuff, and he filed sanctions against me for discovery. So I'm trying to return the things that we're arguing about while she's trying to sanction me for not responding. So every part of her litigation has been counterproductive for her client, because all she had to do was allow me to return his items in June and not press all of the excessive litigation. So in this particular case, what you have in front of you is very little information. But on the other cases that she's been preoccupying my time with, she pulled in the protection order docket when it was supposed to be sitting idle, and I wasn't supposed to be attending to it. So I had to give 50 to 60 hours for that docket.
I apologize for interrupting. My question posed was, do you have any questions or clarifications related to the court's order today? Set of the deadline for filing, the date for coming back for the summary judgment motion, and the $500 attorney fees. Any questions or clarifications about that?
What I hear you say, Your Honor, is Monday the 13th, I need to have my response to the summary judgment.
It was a yes or no.
We meet again November 15th at 1:30, and I'm getting charged $500 attorney fees. Is that correct?
Yes.
Okay.
Right, hearing no questions, I'll conclude the hearing today. Thank you.
Thank you, Your Honor.
Are we still doing the protection order?
Yeah, the protection order, my understanding is that that it was arranged beforehand, and then that's still a go in the different courtroom.
Yeah, and I'll be moving over there now.
Do I log off? Do we log on to something else for that, or do we continue that?
You'll have to go to
docket, right?
Yeah, it's a different docket, so you'll have to go to the court website and find the protection order docket link and/or phone number, and scroll all the way down to the bottom to make sure you got the correct meeting ID and code.
Okay, they were just at the exact same time, so it was really poorly scheduled.
I think it was scheduled quickly, and then we have made accommodations for everybody to participate.
Number 13, Mandy Grounitz, Nathan Bopp. I believe I saw Ms. Grounitz log in, and Mr. Bopp is represented via Ms. Winkles. I have set for summary judgment.
That's correct, Your Honor. We already went in front of Judge Evans. He wanted to give Ms. Gronitz more time, and then he put us back on this docket to reset it. I'd ask that it be on his again, because he's probably read the pleadings already.
And how far out are you looking?
As soon as possible. And that's another issue. Ms. Gronitz put in a 60-day notice of unavailability, which I would ask that that be ignored. We have Zoom. A week or 2 weeks is adequate. 60 days at that point, you might as well put in 6 weeks.
Oh.
Hey, Ms.
I have never seen the name Danielle spelt that way.
No.
That is different.
Grounitz, can you hear the court?
Yes, can you hear me?
Yes, I can. So it seems like this is something that had already been in the works. And I'm hesitant to set this out 2 months. Wherever you will be, are you able to log in via Zoom?
If she's not, that's her problem. Shit. So she's told to provide discovery by the 13th, and on the 15th,
You know Wix.
she
Do
wants
you
a
really?
60-day unavailability.
First up,
Like,
we've
what
got
the fuck
Shake
is
Video
wrong with her?
Masks.
The Zoom isn't the issue, Your Honor. The issue is 36 court dates in 24 weeks is not allowed proper time for discovery development. And I require proper discovery development time in order to see the case. Today's issue is about separate property. We can address that today. But to go to trial for the CIR incompletion, I have new information that was brought up last week. And I have, there's several working parts on this case. And it's, unfortunately, I've had to contact alternate counsel, investigative.
She just sounds more and more ridiculous every time she comes to court.
And I'm gonna hold on.
Help to.
Okay, so, and I'm agreeing with this. I feel bad for this guy. He's getting more and more fees just to have the attorney show up and do all this. What a pain. I mean, I would not
Well,
be
it's
a
not
happy
even just.
guy right
It's
now.
not even. It's not even just about the attorney showing up. It's the paperwork
fees and-
that's the problem.
The court fees and everything, yeah. No.
I'm sure he didn't expect when he hired an attorney that the fees would end up exceeding the value of the property either.
Well, see,
You
that's
know, he just thought it would be an orderly way to work it out and get everything back.
See, my problem with this, and I'm, just my opinion, is that should apply. In other words, the person delaying needs to pay the fees. Sorry. You're not getting it done. You need to pay the fees.
Well, I think that's been where they... Remember, this attorney already was expressing her concern at hearing 3, and we're now at, like, what, hearing 6 or 7?
Yeah.
So, everybody's been put on notice that you're sucking up my time, and you're sucking up the money.
Yeah, I'd be pissed if it was me.
Better present the full dynamics of what's going on in the CIR to go to trial.
And as I understand,
Did you get the packet of information that was dropped off to court that isn't in the system yet?
I understand
I turned in
that.
a-
Okay, I'm looking at
Did
the
you get the
motion.
response?
I'm looking at the motion for summary judgment that was filed on September 29th. That is the motion that we're working on for trial setting, correct?
That's correct. And she has put it in response as well. There is a response now.
Does the judge have that because it's not in the court system and entered?
I think it just came to me today. Is that the response that you would have filed within the day or two?
Okay, it was submitted to court Monday, so it's, yes, if you just have it now, court, I believe, was closed on Friday. So it got submitted Monday, which kind of cut your time short to review it. I apologize.
Well, no, I'm not hearing it today. We're setting a date for it to be heard. So because the motion's been filed, there's been a response. I am going to go ahead and ask the court for, how much time did you want Ms. Winkles on the summary judgment?
An hour, not an hour would be reasonable. My argument will take 10 minutes.
Okay.
If that.
We'll set this for 1 hour with Judge Evans.
So I'm looking at the week of December 18th.
Is there anything earlier, like the week of November 27th, just for an hour?
No, we don't have Judge Evans available that day.
Ah, okay. I'm actually in trial the week of the 18th. You know, if it's possible to go in front of somebody else, the pleadings are short. I just don't want to put it out that far, considering there's so many other hearings in this case. I'd rather get this one over with, so we can put it on in front of any judge.
I still think we're looking at the 18th due to judicial availability.
Okay, I'll take it. I have a trial, but it's only an hour, so.
Okay, so week of December 18th, and then we'll do readiness on December 12th at 11:30.
Okay.
As a child, I was always so outgoing and was never afraid to share my feelings or express myself.
Okay, thank you.
So Ms. Groudis, that means the summary judgment will take place sometime the week of December 18. You need to log in for readiness. Danielle, did you say December 12th?
Yes, at 11:30.
Ms. Groudis, log in December 12th at 11:30 for readiness, and we will determine what specific date your summary judgment will be heard, okay?
May I information? I still have declarations to submit for the readiness.
Okay, that's fine. I'm not hearing any of that today. This is simply a trial setting document.
Awarded.
So file what you think you need to file.
Thank you.
I think that was for the $500.
They had another review hearing on the request for attorney fees, but I don't have that docket. However, we can see in Odyssey that Commissioner Carmy had enough of this messing around and ordered her to pay $4,395.
Oh, shit. Still in a breakout room.
Good.
So I do have a summary judgment motion. I'm going to put you all to the end of the docket since I know you'll be the kind of longer matter today. I have one other matter to take, Ms. Winkles. I believe that's with you, Mr. Boff, and Mandy Grounitz. I believe she might be the phone number that's logged in. The phone number.
Can you hear me?
Yes, Ms. Grounitz, I can hear you. This is Commissioner Jill Carmy. Let me just pull up your file. This is 232-0053908.
Back to the return of, okay. Jeez.
And Your Honor, just so you're aware, we tried to file with the court what we had received, so that, you know, there was some information backing us up, but the clerk would not take it, and I can understand why, and I can get to that, but just so you're aware, if Your Honor does want to see it, we tried.
Okay. Yeah, I'll just note we're on for a review hearing. We've had kind of a continuing question about Ms. Grounitz's full compliance with discovery requests. We've had multiple hearings. Essentially, I think the prior request that's continued through today is the entry of a default order for failure to comply as a sanction. We've talked about attorney fees, which are probably going to be granted no matter what we do, given the steps that Ms. Winkles and her client have had to go through to get to this place. But Ms. Winkles, I'll turn it over to you and see where we're at.
Okay, so, you know, we did file what we were asking for. And so just so Your Honor's aware, we cut down our discovery request a long time ago with the initial hearing with Judge Batchelor. They were only documents that we wanted produced. We did not ask for any answers, written out answers, just documentation. We have received answers to things we didn't ask. That's the only way I can explain it. We've received things about her mother, where her mother went to school, things about her college degree. We've received the photocopies of college books she's had, her syllabus from 1994. We've received the bank statements that we subpoenaed, gave to her, but with those changed, some of them pulled out. We've received no receipts. We've received copies of his work schedule, nothing about her. Essentially, the only stuff we've received is stuff that we gave to her and back, or stuff we never asked for. But what we haven't received are the bills, the W-2s, the 1099s, the agreements, the written joint agreements, the police reports, the pleadings, the Facebook account, which is interesting because she actually contacted us and asked how to do it. We informed her, my legal assistant walked her through, never received it. Any psychological opinions, and there have been a few, schedules for 2 years, income for 2 years, public assistance, EDD stuff, which we specifically asked about, photos, we got 5 photos, not the photos we asked for. We were told all of this existed by her, so, and on her answers, if she had said no, don't have any, fair enough, these all said reserve. And that's the whole point, is that she could have reserved them at the beginning and then tried to, come back and supplement it. No, you can't. Now is the time to answer, not to reserve. The things I need in order to put this case on, I don't have. So the only things I do have are the things that I'm able to subpoena. So I'm able to subpoena her bank statements. I have her bank statements now. I'm able to subpoena no taxes. The federal government won't let you. I'm able to subpoena none of her income, her jobs, because none of that. I can't subpoena Facebook. They won't allow you to. We tried. I can't subpoena the photos that are in her possession. The thing is, she makes statements under penalty of perjury that this is all stuff she has. What she submitted to me, I can only explain in that, for example, if I asked for a bank statement, she would send me back a spreadsheet in her own handwriting of what the bank, she's saying the bank would say, but not the original document. So I have 25 pages of writing of Ms. Gronitz to production, production. I don't need her stuff. That was the whole point. I have 10 pages of statements from spreadsheets that she claims are like the bank statements, but I wanted the bank statements. I have a lot of her own production. I have none of the original stuff. I have, what I can only explain is she wanted to submit something. She submitted over 20 emails to us. And of those 20 emails, none of them, well, no, one of them had at least our bank statements back in them. But of those, probably one had documents I requested, and the rest were documents nobody ever asked for. Things going really down a rabbit hole of like what she studied in college. We asked her for her degree, a copy of her degree, and we got everything that ever led her up to that degree, including all her class materials. So I'm still in the same place. They were initially due October 25th. They weren't received into our office until October 30th. Your Honor said, October 25th. October 30th is when we got what we got. And then we sent it out again. Then they were due again by the 17th. We granted an extension till December 4th. We've been in court so many times, and of the questions we asked, 38, she's produced approximately 11 of those, and of those 11, 8 of them were documents we got by subpoena and gave to her, and she just gave back. So really, she's answered 3 out of 38, and we're still in the same boat. I have no receipts, I have no proof of what people owned at the beginning. I have no proof of anything they engaged in together. I cannot answer, you can't get a replevin when you have a CIR. I can't answer the CIR because I have no information about it, aside from self-serving statements. I have no documentation whatsoever that didn't come from my client. So I'd ask for the same thing. I'd ask for default at this point. This is a default in the replevin. So this defaults the possession only. It doesn't say who is entitled to it in the end. It only says whose possession. Now, I do want to remind Your Honor that Ms. Gronitz has said repeatedly that she's going to drop these things off at my client's house. Everything. I don't know why we're here. I'm dropping these off next weekend. They aren't there. This would make them be there. It would be a default in the replevin, so these items would go back to my client with the police. And then at that point, we still have the CIR. she wouldn't be defaulted out now. We still have to argue who is entitled to either compensation for them or the overall ownership of them at that point. But at least the possession, I don't even know why to be honest, why we're here. If these things were supposed to come back so long ago, the replevin would have already been handled. So I'd ask for a default in this case. I'd ask that we get our order of replevin to have my client be able to go out with the police and get these items returned to him. The list has stayed the same since the beginning. This is a discovery sanction. She has another chance to fix this in the CIR. And I'm hopeful that she will, so that we can actually finish this once and for all. Thanks.
Thank you. Ms. Grounds, what can you tell me? I know we had a pretty pointed talk when we were all last together about how I needed you to comply with discovery. We've had since at least August CR 26 conferences followed by discovery motions, and it does seem as if the answer is always that you're working on it. Where are you at?
Well, good afternoon, Your Honor. I'd like to ask Your Honor's permission to listen to my position as I speak in the language I'm familiar with. I do business management, accounting, general contracting. That is the arena that I'm accustomed to, and I know it doesn't directly translate into legal.
Here we go.
However, in order to explain where I'm at in this case, I need to use the language I'm familiar with. If you can please just give me a second to brief you on what's been going on, then you can translate that to what position we get to take at the end. Because I'm in a dilemma where I'm caught in a catch-22. So I work on the numbers, and yes, counsel admits I took an exorbitant amount of time to download each and every transaction from my bank, compile them into a spreadsheet, separate them into a budget, and send that information to her, separated deposits that I've made on all my accounts, separated potential construction materials at question. I haven't matched every client. Customer deposit, yes, it's an activity that takes time. I haven't matched every receipt.
Yeah, it's sun in my eye.
She's gotten, but she has a complete list of every deposit I've made, every potential item for customer materials that could be in question for improvement of the home. That satisfies the bank statement. She has all the physical accounts of my bank, and she can quickly look at the deposit amount on the bank statement and verify it with the spreadsheet I sent her to notify or verify that the information on the bank statement matches exactly the information in my spreadsheet. There's a lot of information in that spreadsheet. She wants to actually take the time to review it instead of just questioning its authenticity, because the numbers should all match. She has all the bank accounts, all of the physical statements.
That's not.
Today, I present a conflict of litigation agenda. I am both in the issue of A, returning Mr. Bach's items to him, which takes now my personal attention since I notified counsel about a month ago that I was liquidating storage units at Mount Brinian. We were reallocating. I've had my family move out. I've had to hire people to swap storage capabilities between assets getting sold and assets intended for long-term storage. Assets intended to get sold have been removed from Mount Brinian, and at the time I offered to return Mr. Bach, I to him we were discussing how important it was for me to work on these reports. So my personal time has been spent on personal reports. Thus, everything from Parkview is now grouped into a storage unit for liquidation. I personally have to go through that stuff to discern what belongs to Mr. Bach versus what didn't. I submitted the list of items to the person in charge, but it's up to them now to look at the items and see what was his or not. So I can either satisfy counsel's request and continuing doing discovery, or do what I proposed to do last month, which was try to go through what he had or what was in storage from construction in May, and return what items I could. But we keep coming back to court, so I can't spend the time to give him back his stuff. In court. So do I write reports? Do I go spend time sorting through his items? I start a customer job next on the 22nd. I'm contracted to go do 8 weeks worth of work. I won't be touching Mr. Bob's items after that. So whatever the court decides, I don't have the capabilities of satisfying the court's request of returning his items after this weekend. This weekend is great, but I have court now Monday, so now I'm preparing for court Monday instead of trying to get his assets back to him. Which is the priority? Paying counsel to block him from getting his stuff back, or allowing me the time to return his stuff and just negotiating our wage claim. That's where I'm at. I don't know. But I have court Monday, so right now he doesn't get his stuff back because I have to litigate instead. I'm frustrated. I don't want it. He wants it, but here we are litigating. How does he solve it? I don't know. I need a solution. I believe he wants his stuff back. I don't see anything that he's gaining by paying to block himself from getting his stuff back. But here we are litigating, and it's cost me $60,000 in earnings potential this summer, and I'm done spending my personal time putting my clients on hold. My clients have now taken precedent. They want to give me money to go help them. I'm going to go help my clients. Because Mr. Bob obviously doesn't want my help. And I don't need to spend my time on somebody who doesn't want me helping them and isn't going to pay me. So, a third party can distinguish what he has on his list. I was going to offer whatever I could find, which would be a lot more on his list than whatever, because everything in our whole house got boxed up for construction in May. I don't even know what's in there. My stuff, his stuff, the kids' stuff, everybody's stuff's in storage. It's all jammed up. Nobody's benefiting from any of this litigation and keeping all this stuff jammed up. But I liquidated. My business structure is back up and operational. I'm not using our assets to block my business anymore because I have to go back to work. So my clients take precedent. Mr. Bob is choosing to litigate. That's what I'm at. I don't know.
Okay. All right.
What do you guys want to do about that?
Okay. No, I appreciate that input. Ms. Winkles, anything further?
Oh, hold on one second. There we go. Yes. Here's the thing, is that we've been told that this stuff is going to be returned for months. I mean, we've been here for months, and yet it never shows up. My client has been there waiting around on weekends where we're told it's going to come, it never comes. We're told we're going to get discovery, it never comes. All of these hearings could have been accomplished. It could have been, if she had sat down and got, taken the documents, rather than making a spreadsheet of what the document said, she had just given me the documents. I have AI, I could have stuck it in the AI and it pops it out itself, but nobody has to do anything, 10 minutes. The fact is that we still don't have anything. As much as I would love to, base everything on what people say and trust that the spreadsheet is correct, the fact is I can't do that. That's why we ask for the documents. We're here because she hasn't done what she needs to do. This is the same for everybody. It's the same for if you have a lawyer, it's the same for if you don't. It's the same, the amount of time we spent in court, she could have gone over to the bank and she could have gone and gotten her receipts and she could have gone, to Home Depot like my client did and asked for his, his account information from them. You don't have to subpoena them. There's so much that she could have done that she hasn't. So I still ask for the writ of replevin, the order for the writ of replevin and the default, mostly default first. Because here's the thing, we're going to be waiting for her to get these things over when the police will go over there with Mr. Bob. He'll take a trailer this weekend or within 10 days, and he'll get his stuff back because the police will allow him to. They'll have an ascertainable list in the form of the complaint. It says everything that's there. We know where it's at on the property. And that's the end of this. And it should have happened a long time ago, but we were hoping, that's why I wanted them consolidated, these cases. But we are where we are because of no fault of my clients. This is Miss Gronit's rate, making the bill go higher and higher and higher because she just doesn't want to answer. And so I'd ask Your Honor to do the default. It will have been almost somewhere around 7 times in court for discovery. And we are now, I think we served it on her months and months ago. So, it's just like, so we're in December. This is like 5-6 months waiting for receipts. It's frankly ridiculous. So I'd ask Your Honor to enter the default and then immediately thereafter, enter the order for the writ of replevin. And we can fight this out in the CIR, but at least that part will be done. Thank you.
Okay, so Ms. Grounitz, Ms. Winkles, here's my ruling, and it is fair to say that we have been here numerous times. I think this case was originally filed in June of 2023. I believe the amended complaint we're working off of is dated July 5th, 2023. There have been several show cause motions without really substantive responses, except a lot of the same things we're hearing today along the lines of there's just so much litigation that Ms. Grounitz can't possibly find the time to respond. I would note several CR26 conferences have been noted by Ms. Winkles, and then discovery motions filed in this court starting in, I believe, August of 2023. I will note that at some point in time, this court did enter an order requiring pre-filing restrictions on Ms. Grounitz, just simply because of the unrelated filings that were coming in, the unrelated responses. There have been numerous orders to compel. All of this to say that it is very clear to this court that no matter what we do, pre-filing restrictions, orders to compel, attorney fee sanctions, more likely than not, Mr. Bopp is not going to get any of the discovery or responses that he is requesting. I believe more likely than not, if I don't grant the request for default, essentially as a sanction for one blatant and ongoing discovery violations, but also based on a finding that Ms. Grounitz has not materially or practically been involved in this matter in any degree that advances this case, I think we'll just keep doing this for months and months and months. So I also take into account that the nature of this cause is for replevin. I think that, as Ms. Winkle states, that does leave room for Ms. Grounitz to pursue her arguments in the CIR matter if she chooses to do so. And frankly, I also take into account that Ms. Grounitz essentially numerous times to this court has agreed and admitted that many, if not all of the items requested in the complaint for writ of replevin are Mr. Bopp's. So for all of those reasons, I am going to grant the request for an order of default in this matter. And then once signed, Ms. Winkles certainly can decide to file for the writ of replevin should she choose to do so.
Mr. Bopp denied receiving any of his items to date, or is he going to contest that everything on this? I've returned almost everything, but like $4,000 worth of stuff, Your Honor. Do they not counting that? I'm also some are returning this stuff, not litigating over it.
Yep. So, ma'am.
Here, what?
What is the order of default?
No, I don't want to mess it up. It's basically I think she's granting her summary judgment. And I believe like the default is because this other person didn't comply.
Okay.
But I'm gonna confirm that. An order of default occurs when a defendant fails to respond to a lawsuit or court summons within the required time frame, resulting in the court ruling in favor of the plaintiff without the defendant's participation. The order is typically entered after the plaintiff proves to the court that the defendant was properly served with the court documents and did not file a response. This can lead to a default judgment, which is a legally binding court order that may require the defendant to pay damages, comply with other demands, or take specific actions. So that's basically I guess what I was trying to explain, that's the actual, like, name of it. So order of default judgment.
Okay. Sorry. Thank you. See, there are consequences if you don't do the things needed.
As stands, I am for the.
Hey, he's not going to find his stuff even if he goes to the storage unit. They lost that opportunity 2 weeks ago. It's not there anymore.
Ma'am, I'm going to go ahead and mute you if you don't let me finish. So my ruling.
Okay, well, he won't get his stuff back.
Okay. Ms. Grounitz, I have muted you. I am ending this hearing. I have made my decision. I will sign the order for default once received. Is there anything else that the parties need? I'm not, Ms. Grounitz, I will allow you to unmute, but I'm not taking further argument. I'm just asking if any party needs anything else from this court.
Not on our part, Your Honor.
Ms. Grounitz, anything else before we end this hearing?
The items are not where they would send the sheriff to get them. If they want the items back, they need my help to get them. So you can write the river plan, you can send the sheriff, but it's not going to help him get his stuff back. I'm sorry, I told her this 2 weeks ago. I'm trying to get his stuff back, but I need to go do it. So I can do it this weekend if they want to just stop court Monday. Or we'll do court Monday, but I won't have any more information to the court. I'm gone.
Okay.
The whole thing has been frustrating because I can't get my information to the court.
Understood.
I'll take in the stuff and she has all my statements. It's frustrating.
I understand, ma'am. My ruling.
But he can't get his stuff back.
Right, ma'am, I have muted you again. I understand that there's nothing further that the parties need from me. My ruling is as stated. Thank you.
It sounds like she's taken his stuff and hid it.
Thank you.
No, she probably didn't want to pay for storage.
The commissioner ordered the default and a writ of replevin. That was the final hearing for Mr. Bop's motion. But she also ordered Mandy to pay another $1,500 in attorney's fees. Mr. Bop's case is over now, but Mandy's motion soldiers on. There was another summary judgment hearing with Judge Evans, but I don't have that hearing. Mandy must have continued to play games with the court because we can see in Odyssey that he granted the summary judgment.
Ms. Winkles, can you hear me okay?
I can. I hope you can hear me. I'm having internet issues.
Yes, I can hear you just fine. And Mr. Bop, can you hear me all right? Okay, great. All right, so we're here today for presentation. I received a proposed order granting partial summary judgment, and I also received from Ms. Winkles the objections or concerns raised by Ms. Grounitz via email, so thank you for forwarding that to me. Have you had any contact with Ms. Grounitz this morning or recently about whether she's planning to attend today?
No, I have not.
Okay. All right, so Ms. Grounitz raised three issues. One, she believes that the commencement of the cohabitation should be March of 2018. The evidence said that the trial, and my finding was that it was mid-2018, so mid is June. So I'm going to leave it as June 2018. She also raised issues of the sauna and the 1969 Ford, that should be involved in the property distribution.
I'm here. I'm just going to be muted.
However, to my recollection, there was no evidence produced at trial regarding the sauna nor the Ford. So I'm not going to include the sauna nor the Ford in the distribution order. She raises a third issue as far as tools, some additional tools from 2018. I believe that they should have been included as separate property. The court ordered Mr. Bop's list of property. I think that was Exhibit F. So that remains unrebutted, and there wasn't any evidence to the contrary. And there is Ms. Grounitz now. So I'll let her in.
Huggies Fast Absorbing Core versus 3 Ps. Will it leak? 1 P.
All right, good morning, Ms. Grounitz. Can you hear me okay? This is Judge Evans.
Yes, Your Honor.
All right, good morning to you. On the line with us, we have Mr. Bop and Ms. Winkles. I had just, we started at 8:45, so I was just going over a few things, and so I'll rehearse everything that I said in your absence. So we're here today for a presentation for the order that grants partial summary judgment. I received a proposed order from Ms. Winkles, and I also received your concerns or objections to that order that Ms. Winkles forwarded to the court via basically a copy of your email. So just want to go through those objections and the concerns that you raised in your email. So the first item that I noted was that you felt that the cohabitation start date should be March of 2018. In the trial, the evidence that was produced was mid 2018 as the start date, and I think there's even some testimony related to June. Nonetheless, that's my ruling that it's June of 2018. That's the start date of the cohabitation. The next issue is the sauna and the 1969 Ford. That was an indication that was those two items were purchased in 2018, early 2018. At trial, I don't recall any evidence related to the sauna nor the 1969 Ford, and I just want to double check with Ms. Gronitz if it's your recollection that there was or was not any information related to that raised at trial or during the trial.
I don't believe those two items were brought up in trial.
Oh, she should not have her thing up there.
Okay, all right. So since the well, I say trial, I should say summary judgment motion. Since this order is based on what was produced during that hearing, I'm not going to make any adjustments to include the sauna nor the Ford in the ruling. So since there was nothing proposed during that hearing, I'm not including the sauna nor the Ford in my ruling. So then the third item that Ms. Gronitz raised were some tools on the Coal Creek residence related to those that they were purchased. So it sounds like that was a request to include those as Ms. Gronitz's separate property, or that they should somehow be included in the distribution of properties. So at the motion, I adopted Mr. Bob's list of property that he presented because there was no additional rebuttal evidence to those tools. So I'm leaving that as is, as the Exhibit F, basically is the listing of the property that I'm adopting. So one thing I wanted to just mention, Ms. Winkles, is that in your proposed order, it mentions Exhibit F. And I'm not sure if it was your intent to include and attach Exhibit F to the proposed order.
It was.
Okay. Is that something that you could forward to me so
Yes.
I can attach it?
Yes, it should have been attached. My apologies that it wasn't.
Okay. Great. I'll look forward to that. Will you be sending that via email?
Yes, we can send it via email, absolutely.
Okay. Great. So once I have that, I can file that, attach it to the order, sign up on the order, and then submit it for the clerk for filing. I want to double check with Ms. Gronitz. Ms. Gronitz, do you have any additional items that I may have missed in that email that you sent to Ms. Winkles?
I apologize. What do you mean, do I have any additional items to contest or to add or?
Yeah. Thank you for the opportunity to clarify that. So we're here for a presentation, basically a summary order of what the court ruled at the motion for partial summary judgment. So I have that proposed order, and I reviewed your email to Ms. Winkles, which I consider some of your objections or concerns related to that proposed order. So are there any other items that you feel that Ms. Winkles did not get right or did not include in the order for partial summary judgment?
I don't believe so. As I stated previously, I'm not contesting the items, and I want to make a note that the items that were on the tools on Exhibit F are now in Mr. Bob's possession. I'm needing to calculate my losses, so I am looking at what I would have had I not been cut out of this 5-year partnership. So, as far as the tools and the property go, we're just putting it on the record. He's got possession, he's going to maintain possession, and we're not arguing over the stuff. I don't want any of the stuff, I just need paid back. So,
Finding the right footwear for diabetes, lymphedema, or edema doesn't have to be complicated, especially when you don't have medical coverage. Available in peach, burgundy, and
Man.
black for women, and
Couldn't find the damn mouse again.
I believe that we're in good shape.
You can make your mouse cursor bigger.
I don't think there's anything for me to.
That's not the problem. It's just that it's on the other window.
Been contesting the objects to begin with, so.
Okay. All right. Well, thank you for that input, Ms. Gronitz. I'll once I receive the Exhibit F from Ms.
Also
Wiggins,
not
I'll
part of the
attach it to
problem.
The order that was proposed.
Get the
I'll
other
sign off
one.
on that order and submit it to the clerk for filing. So,
No, it's just that, okay, so I have two 32-inch monitors. Right, 32? They're both 32-inch, they're both curved. But when I go to the other window, like I'm doing now, the mouse is not at the same position, right? So like if I'm up here, if I'm at the top of my screen with my mouse and I go to the other monitor, it's not at the same like height. So that's why I keep like when I'm doing stuff on the second monitor, like when I had, because I had muted Discord and muted the my mic for the recording, that's where my mouse was left. So when I go to move my mouse back over to the screen, I'm not ready because it's not coming back at the bottom of my screen when it's at the bottom of the other screen. Does that make sense?
Alright.
Like if I have the mouse at the bottom of my other screen and I come over here, it's not at the bottom. It's higher.
Interesting.
So that's why I keep getting stuck with the mouse.
so I think that concludes our activities for this morning on the presentation docket. Ms. Winkles, any final items?
No, Your Honor, my apologies for that not being attached. We'll send that to you ASAP, and we'll include Ms. Gronitz on the email.
Thank you. Ms. Gronitz, any final items?
May I ask? I'm sorry.
Yeah, go ahead.
There's an affidavit of destruction I keep seeing on my case files, but I haven't seen that. Could I get, is that the same affidavits or are there multiple affidavits floating around? I'd like to request those. I've seen them online, but I haven't seen them in my, in the mail or.
So tell me what you're looking for.
The, when I go on my caseload, or, yeah, there's a counselor, there's an affidavit of destruction listed. And I don't have that in my files of information.
Okay, I think I know what you're talking about. On December 20th, there was a,
He's taking a moment. Or he's not taking a moment.
Done.
Is your moment finished?
Literally a moment.
What did you just do? Like go in a circle?
No, I flip a light on.
Yeah, you went in a circle. That's what I saw.
22nd, the document was filed. The title of it is Stipulation on Order for Return or Destruction of Exhibits. That's the document you're referring to.
Don't make me poke your eye out.
I don't know. I just, on 1108 and 1226 both, there's different affidavits of destruction on them. I'm seeing it. But if I could just request a copy of those, that'd be great.
Yeah, so what I would encourage you to do as an option, you could check with the clerk's office and they could help you with obtaining copies of that either through Odyssey or getting a copy from them. Because I do see the one order, there's a stipulation and order for return and destruction of exhibits that was filed on the 22nd of December, which says that it's stipulated between the parties. Oh wait, actually that 1222 looks like that's, sorry, let me get to the right case file. I was looking at a different one. I apologize. One moment.
Oops.
Oh. Okay. Yeah, the clerk was just sharing with me that there was, it looks like the clerk's office made efforts to contact Ms. Gronitz related to some exhibits. They were unsuccessful in getting contact from Ms. Gronitz, and so they indicated that if they didn't receive contact by a certain date, then they would be destroying those particular documents. So that's what you're talking about, correct, Ms. Gronitz?
If that's what you see, all I see is it says that there's an affidavit and then of destruction, and that's all I can.
Sounds self-explanatory to me.
That's what you're seeing. They have contacted me. There was
This lady makes my brain hurt.
cost number or case number on one of the files. So if that's what you believe it to be, that could be the case. I don't know if there's other depositions or.
Yeah.
That's something from the post office, and that would explain why I don't have it. So if that's what that means, I'll just know that that's what that means. But
yeah. And maybe what you could do is that I'm showing 3 documents. I did just a keyword search under for destruction. I pulled up 3. One is from November 8th. That's an affidavit related to an affidavit of destruction, and then there's a December 26th affidavit of destruction. And then there's also a second affidavit of destruction on December 26th. So what I would recommend is just you could call the clerk's office. They could explain what those documents are, and if you need a copy, they could arrange to get copies to you.
Great, thank you. I should have a courier available today. Okay, thank you for that information. I appreciate that.
Okay. All right, very good. All right, thanks. So with that, that ends our discussion of the presentation. So thanks everybody.
He's gotten a little bit better.
And safe travels if you're out and about.
Thank you, Your Honor.
But now we kind of see why she was so distracted.
They had a hearing to set a date for another special set with Judge Evans on January 10th, 2024, and a readiness hearing on February 13th. I don't have those hearings, but I do have the special set.
All right, so we're here this afternoon on Mr. Bob's motion for judgment related to separate property, and as that relates to the committed intimate relationship. I've read that motion, I've read the declaration and the exhibits of Ms. Winkles. I've reviewed the proposed order, and I also reviewed Ms. Gronitz's answer to the motion and counter. I've reviewed that response, which was a 3-page document. So if there's any other documents that the parties wanted me to review but I didn't, please let me know.
No, Your Honor, that was it. I guess I would just redirect Your Honor to the order entering summary judgment on the last motion, the motion for summary judgment, that order entering it, which is what this is related to.
Correct. I was double checking it. Either I printed that out or I thought it was attached to one of your exhibits, but that may not be the case. Okay. All right. Ms. Gronitz, any other documents that you were anticipating that I would review in preparation for today's docket?
I do apologize, Your Honor. You do not have other documents in front of you. I have been working on findings of fact because I'm trying to catch myself up to speed on the details that have been presented to court on this specific case versus our other cases. However, I'm still filling in that matrix, and you do not have it in front of you today, but there is a distinct dispute of material fact over these items, and I'm trying to identify and quantify what that dispute looks like. It's a valuation issue, not a possession issue. So short answer is no, you don't have other documents for me. I do apologize.
It's not a hobby.
Maybe she's being humbled by the fees.
So just to clarify, Ms. Grimes, you said you were working on basically the personal property, and you were working on assigning values to them?
Initially, this case was brought forth because the
plaintiff or petitioner, respondent were in a committed intimate relationship where both pooled resources into joint assets. Those joint assets are what are listed in Exhibit F. So there is mutual interest in those assets. The respondent has possession and use of those assets through the duration of this dissolution, and I won't be disputing possession of those assets. I'm simply needing replacement value out of our partnership to replace those assets because I need my business tools back, I need a vehicle back, I need all the things I bought over the last 5 years, I need a way to replace those items to continue my business. So until valuation of those items is assigned to this case, I'm willing to accept cash payment instead of disputing over the physical items.
They're his.
But there is a dispute in ownership because I bought and earned these items and I have investment value into them. I need investment value back out of them to make my balance sheet and my income statements work out for the next phase of life. So I am disputing ownership of the assets as far as valuation goes. Like I said, he has possession, he can maintain possession of the assets, but until we determine what the valuation and the dissolution value of the partnership is, then it seems premature to just assign him all the assets, all the income, everything from the relationship I get all the debt, and nothing to move forward with. So I need to balance it out.
Okay, yeah, I think I understand what you're saying. And then let me just maybe pose a clarifying question as it kind of relates to today's motion. In that December 29th, 2023 order that the court entered, it indicates that the property identified in Exhibit F was purchased by Mr. Bob prior to June 2018, but or after April 2023 is a separate property of Mr. Bob. And so there was that finding. And so you're talking about the evaluation of those items in Exhibit F?
Yes. Those items were donated to the business partnership as a consideration into the partnership in 2018 when we bought a piece of property and developed it together. So that was his interest into the partnership, was those pre-owned tools that he had to contribute. He brought the tools and materials, I brought the skills and the labor. So those were pooled resources into a joint venture in 2018. They were part of the relationship assets, even though he bought them prior. Now, he has a sentimental attachment because he had them before the relationship and he can maintain them. But all of those tools need replaced for my business to continue. So there's probably about $10,000 rough guesstimate of tools listed in Exhibit F that he would claim as separate property, but he donated to our joint business venture, the Coal Creek renovation, in 2018. And since that point, they have been mutual assets of our relationship until we separated.
Okay.
So yes, I can test ownership of those, even though they're separate property, because he used those as his consideration into our contract for the venture that we pooled our resources into.
Okay. I appreciate that explanation. Thank you. Just going to jot down one quick note. Okay, so now that we just established that there's no other documents to review in preparation for today's hearing, I guess it's time for the hearing for the purpose of which we're here today. So the motion was filed by Mr. Bob, so I'll hear first, please, from Ms. Winkles, then I'll hear from Ms. Gronitz thereafter.
Here you go, miss.
Yes, Your Honor. We have an order on entering the motion for summary judgment, granting that motion for summary judgment. That's where the decision was already made as to the characterization of the property purchased prior to 2018. In that motion for summary judgment hearing, property was identified on Exhibit F. That property, the court made a specific finding that that property was separate. When you purchase property, the nature of that property, unless there's transmutation, which there's not been any allegations of that. There weren't any on that motion for summary judgment. It doesn't change character. The character of property is whatever it was at the time you purchased it. But regardless of that, we already argued that. We had a hearing, 30 days have passed, there was no appeal, there was no motion for reconsideration. There was nothing of that effect. That order is a good order. It is a standing order before the court. The only thing we're here on today is not to relitigate this. It's already been litigated. The only thing we're here on is to make this a final judgment rather than and I say this word wrong every time and I practice and I still can't do it, interlocutory order of the motion, the order on motion for summary judgment just needs to be made final. And the reason it does, there's nothing that would delay that. We've passed that 30-day mark. Additionally, it's real property. There's mortgages that need to be paid. There's creditors and things like that. There is a reason to have this final order. Additionally, we're going to most likely a trial or settlement. And that is why it's so important. Ms. Gronitz has kind of made my case for me. If we keep arguing issues that have already been decided, and unless there's a final judgment, we're going to be going back in time and it's going to cost everybody a ton of money for something that was already decided by the court. Findings were already made. We need this final judgment on less than all claims so that everybody is aware of what we're actually litigating on at the time of trial or settlement, so the issues don't get confused and we can deal with 2018 to 2023 things that were purchased during that time and only that time, so that we can stay relevant, make the trial go forward. It's really judicial economy, financial resources, the parties, and just pure understanding. So we'd ask that you enter our judgment, our final judgment on less than all of the claims.
And specifically, you're asking that the 2829 Parkview Drive residence, the boathouse and the personal property is contained in Exhibit F be deemed separate property.
That's it, Your Honor. Just exactly what it said in that motion for that order on motion for summary judgment. Exactly that interlocutory order made final, and that's it. It should almost be word for word to the order on summary judgment.
All right. And then to Ms. Gronitz's comments earlier, where she was talking about the different values of the property in Exhibit F. If I were to accept your argument and say the property in Exhibit F is separate property, is there at trial, let's say, at trial, would Ms. Gronitz be free then to argue, yeah, it is separate property, but it had this value and it was used for business purposes, and that value should be taken into consideration if there for any type of division of dollars or property?
Well, if this were a dissolution, absolutely, separate property is always on the table.
Yeah.
Because this is a CIR, it's more of a gray area. They don't have the benefit of marriage, and that really, they are different. Even though we sometimes blur those lines, it is different living without marriage and living with marriage under the law. I'd say that she still has an argument. There is no spousal maintenance in a case of CIR, so that's going to be a problem. It sounds like what I'm hearing is that not so much of a CIR claim as something of a business agreement, some sort of going concern or something like that. So I guess that would be an argument that she can make, some sort of contractual one. But because it's a CIR, I think she would be precluded probably from trying to get value from separate property. But again, that was already decided. Findings were already made. That's not, I guess that's not what we're here for today, because those findings were already made on the summary judgment motion. But I think it sounds like her argument is more of a business argument. I think she's never precluded from making that. If she's claiming a contract, then she's, you know, and he put in this and she did this in exchange for that, I think that's always probably valid. If that makes sense. It was a long-winded way of saying yes, but.
I appreciate the response. Thank you. Anything else that you want to say at this point, Ms. Winkles?
No, I just, Your Honor, the problem is this case is constantly evolving and going backwards. My fear is that we're going to be in court litigating property that's probably worth very little. for the rest of time. And so I'm hoping that we can slim down the issues for trial, and that's what we're attempting to do today.
Thank you. Ms. Cronitz?
Yes, John?
Any additional argument or comment you'd like to present on the issue?
Yes, I had something to say. Sorry, let me just writing a couple things.
Okay.
Okay. I consider what council just said, and that's what I have to say. Okay.
She took so long, there was a commercial.
Are using Amazon to pick up, store, and deliver their products.
Oh, I didn't know that they pick it up.
Smell the roses, Julia.
I need to get my shit together.
Actually, I didn't know.
Earlier, you had mentioned we had been to court in December regarding these assets. We've been to court a number of times over this list of assets, and I put forth great effort to make sure he had possession. So I'm feeling a little bit like this court today. I don't believe bad faith is the right term. Again, I apologize. I come from an accounting, operations management, and construction arena. I may not use the correct legal terminology. So ultimately, last year at this time, I had a house, I had access to 3 vehicles, I had all my business tools in order, I was getting geared up to remodel our home, and I had heritage of 4 children. Okay. Today, while also maintaining my business property. A year later, I am considered homeless. I don't have a vehicle to get to work. I don't have business tools to go to work. And I am in fear of contact of any of my children because my ex-spouses will have me arrested if I contact them. So, in a CIR, or any type of business dissolution or CIR, the difference is love and affection and a long-term stable relationship with intention of, in my terms, a mutual retirement plan. I have business relationships with a lot of people. Mr. Bopp is the only person I made a retirement plan with over the last 5 years. So that's the difference in a business agreement versus a CIR, is I love this guy, and resources were pulled into a long
What?
Nothing.
term retirement portfolio. I started financial services at age 20. It's something I do. I help people build up their homes and their retirement. And I built a retirement with Mr. Bopp, and that looked one direction. Today, our directions have changed. His position has not changed much. He still has his car. He still has the house. He still has all the assets. He has his job, and he has access to his daughter. So, here again, we're arguing over property. I built a shed off the back of the property. It's a $40,000 shed. We haven't discussed my either payout or reclamation of said shed. It's on the property. If we assign Mr. Bopp ownership of Parkview, what happens to my investment? Part of our contract last year when I started construction is that he pays me for the job that I did, aka the hardwood floor remodel. He was supposed to pay me for the job of refinishing the hardwood floors before he began using them. It is my guesstimate after a year that he is using the floors that he has not paid for yet. It's standard contracting agreement. It's something he agreed to.
he failed to pay and yet is using the assets. How do I claim ownership of just the hardwood floors? You know? So I am seeking payment over my investment into that property, but I own the floors, I own the paint on the walls, I own all the elements that went into making that a house. So we can't split the house, you know? So I'm willing to cash out, but until there's a cash out value assigned that I can put onto my balance sheet because I'm in tax season. I have to file taxes. My quote, either CIR and or employer has not paid in 2 years. You know what that does to my balance sheet as a business? I can't get a loan because I can't claim an income because the guy that I've been working for the last 2 years hasn't chose to deposit money in any of my accounts for the work that I've done. I'm stuck until valuation is determined, and I either have a loss of the $100,000 that he said that he owed me last June. This issue hasn't changed one bit. In May of last year, he put in a protection order stage. I said he owed me $100,000. He said I was insane. He needed protection from me because I wanted to take out for my job. So the issue is still the same. I've done the math 3 different ways. I've done it CIR, I've done it business, I've done it as an employee. It's $100,000 difference on my balance sheet. I can't erase that gap. So either I'm so in court that I just lost $100,000 by trying to leave a relationship, or I get paid or whatever. But in order for me to prove to my investors that I had value the last 2 years and I actually did something with my time, and I can prove that I did something with my time, I can't prove payment for anything that I've done with these. Either of the 2 house remodels I've done with the respondents. I've remodeled 2 homes, and I don't have payment for either home that I've remodeled. That's a $100,000 deficit in my income statement. I need to address that. It's tax season. I would like to take care of this money issue. If we want to just settle on the money, we can settle this case. It's not an issue of assets or items. He can have everything from the relationship. I just need the ability to have my investors say, yeah, you're a good investment. We'll go ahead and approve your loan so I can move forward in life. And I need a way to get to work, and I need my business tools to do the job. So I'm happy to buy my own, but I need valuation and the money to do that to move forward. And that's ultimately all we're disputing is, what do I get paid for remodeling these 2 homes with this guy? We had an agreement on both of them. I did my part. I put in my skill and my labor.
I kind of slightly see like her point that she did work, and with the dissolution of her relationship, she's kind of lost everything because now she's lost a home, she's lost tools that, though they were purchased prior to the relationship, she had access to and made utilization of. Right. And now, because this relationship is over, it's like the things that she was using for her for work are no longer available.
Right.
And if the remodeling that she did was to the house that he lives in, she's not benefiting from that. It would be different if she still lived there.
Right.
Then it wouldn't necessarily be the need for her to have that. I'm assuming because there was a relationship, there wasn't that same need for that money back. It's no different than when you're in a relationship with someone and you give them money. As long as you're in a relationship with them, you don't care when you get the money back because you live together. What's yours is mine, what's mine is yours. But when you break up, I want my fucking money back. And no, you don't have however long you want to pay it back. I want it back now.
But see,
that's just kind of how that ends up being.
I don't see that being lawful for reasons. And I'm going to say why. An example would be, let's say I'm your boss and I went to remodel your kitchen, or you went to remodel my kitchen, or whatever the case may be. 5 years later, we get into a relationship, so on and so forth, right? 5 years later, you want the money that you spent on that kitchen? How?
Well, here's the thing. When you can be in a relationship with someone and also still have a form of an employee, employer, contractor type situation. Either way, the relationship aspect of it doesn't really matter. You still have to pay your employee or your contractor. I think where it's muddied is that when you're in a relationship with someone,
but normally
you're not. Wait, hold on. When you're in a relationship with someone, you're not clocking them as far as getting your money because you live with them.
Right.
So the expense, the necessity for the money for expenses is not as dire.
But the contract has a certain amount of time. The job has to be completed. Once the job is completed, the contract is void.
The contract might be void, but that doesn't mean you don't owe the money.
But let's say I paid it.
Well, then that's your problem. You still have to pay for the work.
Yeah, I paid it. It's gone. There's no.
Yes, but he didn't pay. Is the point? She did the work. She fulfilled the contract.
But she was in a relationship at that point.
It doesn't matter if you are commissioned to do work.
There's no contract though.
There can be a contract when you're in a relationship with someone.
But the job is done. What do you do?
It doesn't matter. It doesn't matter whether or not the job is done. The job can be done. That doesn't mean that you still don't owe the money. And the only thing that saves the person who's supposed to pay is that they're in a relationship. So the person who's waiting for that money may not be as pushy about getting their money because they live together. But once that relationship is over, anything that you owe me, you best believe I want it back. Because now we're not together. Now you don't get, you don't get a free ride. Now you don't get, sympathy. You owe me money. Give me my money. I don't care how you get your money. I don't care who you got to rob to get.
See, I disagree. I disagree because there's no contract for that. It's voided.
There is a contract. The contract is not voided when a job is done.
Yes, it is.
A contract
for a contractor, yes, it is.
We can look this up, because a contractor who does a job will not close off that contract until they're paid. But we can look it up. Remember, we got Google, right?
He paid it though.
He didn't. Otherwise, she wouldn't be asking for the money. We're gonna look it up. So the question is, what constitutes? Why you put Constitution? I said constitute. What constitutes the completion? Everything is put in competency. Completion of a contract. All right. Okay, you ready for this? I don't know if you're gonna like the answer. A contract is completed when all parties have fulfilled their obligations as defined in the contract, which includes completing all work, correcting any deficiencies, and satisfying any conditions for final payment. This often occurs at a specific point, such as when the work is accepted by the other party, the government issues a certificate of occupancy, or final payment is made. So, like I said, the contract is not void. The contract is not completed if you didn't get paid. Once the person is paid, then the contract is completed. Or in these words, once everything is fulfilled in the contract. And he's not disputing, and his attorney is not disputing that she did not complete the work. Nobody's argued against what she said. So he just hasn't paid her. I mean, like I said, a relationship might muddy those waters because the person who's waiting to be paid may not be as, give me my money, give me my money, give me my money. Because they live together. They figure they'll get their money when they get their money. But once the relationship's over, that freedom it goes away. You don't have whenever you want to give me my money back at that point. Now there's, sort of like a reasonable time. Because it's the same thing when you lend somebody money. You see when these small claims cases where, a person tells somebody, oh, I'll pay you back when I get my tax return. And then they get their tax return, or they don't get their tax return, and the person who's suing ends up getting nothing because either the person never filed their tax return, so there was no tax return, there was no monies, or, maybe they did file their tax return, but they didn't get awarded any money.
Right.
So you were reliant on a certain condition, and then that condition did not happen. So there's no money for you. And I think there's also, like, when it comes to paying somebody back, there's also, I think, like a reasonable time type situation too. Like, you can't borrow $100 from somebody and take 100 days to pay them back. Give them I'm sorry, not even 100 days, 100 weeks, where you borrow $100 and you give somebody $1 a week. Like, you can't do that. I mean, I'm sure people might try, but it's stupid.
I know some people that do that to companies. I gave you $1.
Well, I mean, because $1 is better than nothing. But if he contracted her to do what she did in that house, and in her doing that work, if she was supposed to get paid for it, then she's entitled to that money. She may not be entitled to the monetary value of the tools. She might be expected to buy her own tools, but she is entitled to I think, to be paid for the work that she completed, whether you're in a relationship or not. I don't think that. I mean, I can add that to the question. Does it matter if you're in a relationship? And see what it says. What constitutes the completion of a contract for work when you're in a committed... This thing does not like my finger. Committed relationship. Does that make the definition different? Okay, maybe not. The completion of a work contract for individuals in a committed relationship is defined by the specific terms outlined in a formal love contract or the original employment agreement. This completion depends on fulfilling the contract's clauses, such as completing all job duties, adhering to the agreed upon terms of professional conduct, and non-retaliation, and following company policies regarding relationships. Completion is achieved when both parties have met these obligations as agreed upon in writing. So it's the same thing. Even if you're in a relationship, the complete is the same concept. So, translation, if you're going to get in business with somebody that you're with, maybe it should be your husband and not somebody you're dating. And I kind of like the fact that she said that, that she enters into work contracts with all kinds of people, but this is the only person that she had a retirement plan with, which is what makes their, you know, their situation different.
Hmm.
That's probably one of the smartest things that she said throughout this whole thing,
Yeah.
in my opinion. But I think we need to let this run through because you're going to be running out of time here.
He offered assets as part of his consideration for what I did. Now he's trying to rescind his offer of those assets, like the expedition. He gifted that to me in 18, put me on the insurance in April, and claimed it stolen in May. I don't understand, but I don't want that car. I need a different car, though, you know? So I don't want the
Let me ask you a
expedition.
quick question.
Yeah.
As a professional surfer, I've been paid to wear clothing since I was a young kid. Seeing the negative impacts that we have.
Yeah, I appreciate your feedback and the information that you're sharing. More specifically, this is a motion related
See, I don't like this judge
to the
because he
December
doesn't speak
29th,
up.
23 order where the court made a finding of separate property as it relates to the Parkview address, the boathouse, and the
To me, he's
property in
mumbling. I
Exhibit
can't
F.
understand.
So I'm
Crap.
hoping you can address your comments to that issue. Ms. Winkles made an argument that order has been ordered. There is no motion for reconsideration, no appeal of that particular order. And so at this point, the court has made a ruling related to that property. And basically, her motion is to, for lack of a better term, kind of rubber stamp that and grant it as a partial summary judgment as it relates to those three categories of items: the residence, the boathouse, and the property in Exhibit F. So while the information you're sharing is obviously important, I'm hoping you can focus your comments on the issue that's before the court today, which is should there be an order establishing the real property at Parkview, the boathouse, and the property in Exhibit F as the separate property of Mr. Bob, and then move forward to a separate trial probably, or mediation, what have you, whether there is a committed intimate relationship and if there is to be any type of division of property or what have you. So I'm inclined at this point, because of that prior ruling, without an appeal, without a reconsideration motion, of granting the motion Ms. Winkles has brought, and then allowing the parties to work on other aspects of the case, whether it be through mediation or through trial, which would include the committed intimate relationship argument and potential separation or division of property and funds and the like. So I'm hoping you can address those issues.
Is it my turn?
Yeah, the question was posed to you.
Okay. So I'm looking at you're referring to the order granting defendant's motion for partial summary judgment. That's the order you're referring to?
Yes, dated December 29th, 2023.
Okay. As I said, I am not trying to separate assets. I am simply attempting to secure my interest in at some point getting paid out for what I've put in. So as far as Part 2 drives go, I have an interest in there. I'm happy to allow him, I believe he has to have a clean title to refinance, and if that's the case, fine, but I do have an interest in that property. How do we mark that? And then the 2000 Expedition, it was my vehicle. I'm happy to have that be his vehicle, but I do need a replacement vehicle because it was mine, and I don't have an alternate. The boathouse, I don't have any interest in. I'm happy to release that. So I'm not arguing allowing the order for him to have releasement of title. I'm nervous they won't honor my interest at a later point.
Right, that's what it sounds like is your concern. Your concern is that if the court finalizes this and says the separate property of the residence is Mr. Bob's, then you're concerned about your contribution to the value of that separate property and being reimbursed for any funds or labor expended.
Correct.
Okay. All right. Thank you for answering that question. I appreciate that. Let's, if we could, Ms. Winkles, do you have any additional items? I think I have a fairly clear idea of what the proper outcome is of today's hearing is.
I have no further argument, Your Honor.
Okay, Ms. Gronitz, I'll give you the last word. Any final comments you'd like to present?
I think what she said made sense, but nothing seems to really go in her favor.
I'm reading my notes. Discovery. We're still the discovery phase. No, I think that we discussed the necessary issues on my list.
Okay. All right, thank you. I appreciate the perspective and input of both parties.
My
I think
question is, well, if that was
issue-
true,
well, there's
why
two
wasn't
salient
it brought up
issues.
before?
One is that there was a December 29, 2023 ruling.
As far as like the property and stuff,
Yeah.
she did. She was even talking about it in the other case with the ex-husband about wanting to get paid. She keeps bringing it up, but you know, she kind of I think she was bringing it up in at times that wasn't
Wasn't relevant.
to the case that she was in that day. Like, you know, this is supposed to be about the relationship, but you know, she was bringing up, or even now she's bringing that up when that has nothing to do. Well, no, because the replevin was for property prior to the relationship. So I guess she is bringing it up accurately here, but because she wasn't doing what she was supposed to do on the discovery side of it, and the summary judgment motion being granted, and he acknowledged that her concern is that because that was granted, that she might not be able to present this concern in the future. That's all she's asking. You know, that because of the discovery situation, am I not going to be able to, you know, request this at a later time? Which is a valid concern. Though it is technically still her fault, even if it doesn't go in her favor,
Right.
because she should have did the discovery. And if she would have did the discovery and did everything in a timely manner,
She probably wouldn't have had this problem.
Yeah.
Nah.
So.
Good point.
Which made a determination of what the separate property involved here is based on the dates. The June 18th or June 2018 is a key date. The April 23, 2023 is a key date, and the court made a ruling based on those key dates. The court didn't make any determinations as far as a committed intimate relationship, didn't make any determinations as to contribution or labor expended or benefits granted. The court just made that determination about those particular items of property. So I'm going to grant the motion brought by Mr. Bopp via Ms. Winkles on the motion for judgment on less than all the claims that was presented. And I'll just double check with Ms. Gronitz. Did you receive the proposed order that Ms. Winkles submitted along with the motion? There's two of them. It looks like one is order on judgment for less than all claims or parties. That's where it basically says that the property, the Parkview Drive, the boathouse, personal property, and Exhibit F is separate property of Mr. Bopp. The other is the final judgment on motion for partial summary judgment that basically indicates the same. So while it's not subject to division, there's I think if there was a property asserted counterclaim of contribution or enhancement of value or labor not compensated, I think those probably still remain. So any concerns about those proposed orders from Ms. Winkles that she submitted?
I apologize, Your Honor. I don't have those in front of me, and I haven't recently reviewed them. I can't, so I'll have to. I don't have feedback about them because I haven't looked them over, or I don't have them to look.
Sure.
Sure.
So just looking over them, I looked at them previously. I'm just looking at them again. It basically reiterates that the Parkview address is separate property, as is the boathouse, as is the personal property in Exhibit F, and that he's entitled to a judgment affirming that property, separate property status. So I think the orders as presented, I'll sign off on both of those. Ms. Winkles, I have a photocopy of those that were submitted as proposed orders. Would you be in a position to send those to me via email, a clean copy, and CC Ms. Gronitz in that?
Absolutely.
Okay, that would be appreciated. Once I receive those, I'll sign off on those, and then the parties will be free to negotiate and mediate or set for trial or what have you. So I appreciate the input from the parties. I'll look forward to that email. So I think that concludes our hearing for today. So we'll be in adjournment.
Thank you, Your Honor.
It feels great when it's clean. The new Ocedar H2 Pro and its two...
So the order is set as written, and if I want to make an interjection, I have to do that separate?
Well,
or not that's not the right word, but...
Yeah. So sometimes what will happen, we'll have a hearing, and the court will make an oral ruling, and a proposed order at that time will not have been submitted. And so then the parties, based on the court's oral ruling, will prepare an order to match what the court orders. We're in a distinct situation here where a proposed order was submitted to all parties, including the court, and ostensibly was reviewed by all parties. And then a court has made a ruling that is basically in conformity with that proposed order. So in my view, that proposed order accurately portrays what the court ordered here today. And so a separate hearing to kind of ratify or affirm that order is not necessary, because I've done that here, in that I've reviewed the proposed order. I feel it's appropriate, and that you, Ms. Gronitz, had received a copy of that order prior to the hearing. And so there's an opportunity to review that, opportunity to be heard on that issue. So from my vantage point, further hearing is not necessary, because I have reviewed that order and I think it fairly captures what I wanted to say.
So in theory, I shouldn't have to come back to court about this specific list of items again, because it should be done, right? We should be done arguing over this list of items. We can move on to the next subject.
You know, from my vantage point, that the exhibit F that contains different items of property, that's the separate property of Mr. Bob. Where the parties decide to go or what's important to the parties, I'll leave that to each, and I won't make any prospective rulings on that.
Okay.
Good.
Well, it's been a while. We've been over these items a long time, and so if we could bring these to a close, I'm great with that. So.
Okay.
I appreciate your time today, Your Honor.
All right, very good. I appreciate the input from all parties. Thank you.
All right, that brings me to
It's definitely gotten better.
Gronitz and Bob matter.
Good grief, another change in judge.
Okay, we have Mr. Bob, we have Ms. Winkles, and who else did we have?
This is Mandy Gronitz, Your Honor.
Okay. All right, Ms. Winkles.
Yes, Your Honor. Just a little background. We served our first ROGs in this case on 9/27 of 2023. That meant they were due back on 10/24. We had a CR26I conference held on November 13th. We extended it to 1/17. We received a little bit on December 12th. We received a couple more on January 5th. I did another CR26I on 1/3, extending it to 1/17. Held another conference on 2/12, extending it to 3/4, trying to give as many chances as I can. We have received nothing essentially since 1/5. I even gave her access to a Dropbox file so that she could just load them up. I offered to give her a flash drive to put them on. I offered to stay open late. There is no more that I can do. I don't have residential address. I don't have employers. I don't have anything about her mental health history. I have lots of reserved with no proper objection. I am missing about, I believe it's out of all of the interrogatories, I am missing 68% of them, over half, and the ones that I'm missing are the ones that are vital to this case, namely what community assets she's claiming, what community debts she states she has, what her income was during that time, anything about a ring, anything about a committed intimate relationship. Essentially every single thing that I have waited, almost, I don't know, 5 more months. So it's been almost 7 months now waiting for this stuff. I can't move it forward to trial. We're done. We submitted all of our discovery, every single answer. We provided it, we mailed it. We even had, I believe, a courier was going out there with it, even though it's huge. And we submitted it in Dropbox for her. She claimed she couldn't access it anymore. I set up another one. She claimed she had access to that. I set up another one. At this point, I'm throwing my hands up because I don't think I've ever been quite this nice and friendly and accommodating to anybody in discovery, and I can't do anything. My client's just waiting. This will never go to trial. When we call her, she says she's making a spreadsheet or she's doing something of that nature. She's consolidating it. I don't need what she consolidates. What I need are the actual documents that come from the bank, the retirement, the employer, those things. So I'd ask that you find her, that you compel her, that you assess attorney fees in this case, because that seemed to be the only thing that worked in our other cases, that we set a review for 2 weeks, and that if she doesn't turn it in by then, you strike her pleadings, and I'm hoping that will spur her on to actually get us the documentation that we need. I don't even know what her current employer's address is. I know absolutely nothing that is useful. All the questions she did answer are the ones that are somewhat useful, but they're not useful in me making a spreadsheet of assets and debt so we can finally dissolve whatever relationship they had, be it a CIR, or be it friends, or be it whatever it was. I can't move it to a trial. It's just going to continue to languish.
My honest review on this natural remedies book after having it for a month. Look at this blood sugar page.
All right, Ms. Gronitz?
Yes.
Anything you'd like to say?
Good morning. Yes, I do have some things to say. I intended to bring up a lot of issues. However, I have had a chance to overview my breakdown of the project at hand. This case has been agreeably one of the most daunting cases I've ever had to work on. My background is finance, accounting, and contracting. That's where I excel, and
the judge doesn't care.
Last year has been an attempt to navigate the court system.
At this point.
It is not my professional.
Well, this judge has no patience, so
I've had to do a breakdown of
that, and I know that.
2024 and determine where my time is most valuable, and that is actually making magic for my clients, people who want to pay me.
Everybody else just let her talk, but I don't know.
So I have this case will need professional assistance. And I've delegated the elements of this, or sorry, distributed the elements of this case to the proper professionals so that Ms. Winkles can get her authenticated reports that she needs and her court compliance reports that she needs to actually carry forward on this case. So, as per se, I'm accustomed to mediation. That isn't going to be an option. I've offered resolve without any damage to Mr. Bob's credit or credibility to date, but I'm faced with financial reporting due April 15th is tax reporting. This is my employer for the last 2 years. I don't know my income because we haven't had a chance to actually discuss it. So I have to put in my financial statements to the professional financial auditing team, and they can help me determine what that income is, and then I can get that report to Ms. Winkle.
She is bonkers.
And that's been submitted. I am filing an extension for my taxes by 6 months to figure out what it is I'm claiming for an employee that is versus the DNR interest in reimbursement. I haven't disputed any of the assets, and he has all the assets, and he has access to all the assets. You can go get whatever he wants, whatever he wants, and if he's on the property, he wants something, go get it. Go find it. When I get a chance to tackle that project, I will happily return whatever I have, but what he wants. That's not on my priority list right now, because I have clients waiting in queue who want my attention, and I have to offload all the other, anything I can delegate. So the first one is finances, because that's the holdup. Second one is legal counsel. My firms have not been court compliant because I have not wanted to counter respond in any damaging way. The reports I am now faced and forced to have to submit because of the position this issue has brought me into will be damaging or could be damaging, and those will be done by professionals who I don't mess it up. That's not my arena. I hand that over to the legal team to address, and they are waiting. I'm awaiting a response on who's going to take lead on this case.
He's confused the shit out of me.
I have submitted discovery. It's been used to threaten me and intimidate me back. I have a legal dispute, and it's going to need professional attention. That's in the works. This case keeps coming forward by counsel as a dispute about assets or a dispute about money even. I'm in a position where I claimed an income for 2022 I didn't earn. So
Stop.
Just 3 more sentences. 3 more statements. Please let me finish.
Stop.
Winkle. This is about family law. This is about my children.
Unless you want to go on right now and go to jail, stop. I asked you to stop. I expect you to stop. I've allowed you to have
Okay. Saw that coming.
All right. I have asked you to stop when I asked.
Judge Hahn does not put up with much crap, so I don't think Mandy's going to be able to drag this out much longer.
You to stop. I expect you to stop. I get when people are on Zoom that somehow they think that the court rules don't apply. They do. I've allowed you to go on about things unrelated to the motion before this court. This is only about discovery. It's not about settlement. It's not about what he can come and get. It's about none of those things. So I'm done hearing things that are not relevant to what we are here about here today. If you want to say a couple sentences that relate to what we're here about today, then I'll let you say it. But I'm not going to have you go on and on.
We called it. This judge is no nonsense.
She always has.
She's about. Yeah, but she's about maybe the only one of the ones that just does not do that.
In regard to the discovery, only the discovery.
My discovery is delinquent due to the fact I've dispersed it to professional teams. I'm awaiting their reports to give to Winkle. I'm asking the court to give the time for the financial team to report back to me what the issue is that Winkle's trying to address is the income. She's seeking this information. I am trying to get it to her.
Build a website you love with Wix.
Again, no.
For your words,
Ms. Winkles?
Yes, I'm not sure what expert she's hired or why. Bank statements don't need an expert. retirement, you call up a phone number, employer, you write it down. All of these documents can be given by anybody. And she's had 8 months, 9 months to go get them. I've subpoenaed who I can, and I'll continue to, whenever I find out, oh, she might have worked here, I'll continue to subpoena at great cost to my client. But the fact is, I don't need her expert report. That's the whole point of it, is we get the background documents and we hire our own expert. And then they can decide what is there and what is not. The fact is she's not compliant. And she's going to continually drag her feet. I've had 3 CIRs giving her plenty of time. And why did she hire, let's just say this person has all of her tax documents and she can't give them to me because that's one of the things I requested. I'm not sure why she can't go on the IRS website and get it. It takes 5 minutes. But aside from that, our first CIR was back in November. And then we had another one in January and another one in February. And by the end of it, it was almost as if her dog ate her homework. Every time there was a different excuse. I couldn't go here, I couldn't get this document, this happened. At this point, I think that it's excuses and excuses. It doesn't make any sense. You can send a child into the bank to get bank statements. So I'd ask that Your Honor find that she has not materially answered these, that assess an attorney fee amount of $1,500. And if we could put it on review, and if she doesn't get them to me in 2 weeks, that her pleadings will be stricken. Because at this point, Mr. Bobbs just keeps paying me to show up here and with a new excuse, and she has a new excuse every single time. Thank you.
So I reviewed the files and record and have heard what I've heard today. And based on the files and record, the court does find a 26I. And if you don't know what that is, that's Civil Rule 26I was set and the due date was extended. Additional extensions were made. There was some discovery provided, but none of the missing discovery as of now. Therefore, the court orders the compliance with the request for discovery. It does not require teams of people to put together the documents as indicated by Ms. Winkles. The discovery is to be no later. I'm going to put it on the 23rd, April 23rd, and with full and complete answers, or be subject to sanctions of possibly striking the petitioner's pleading or not allow the petitioner to testify regarding any information contained in the unanswered interrogatory.
I'm sorry, that is another part of it too. If you don't provide discovery and you don't, I guess in a sense, submit to like the deposition, which she did do, when a case goes to trial, you can't present documents or evidence or anything that was not already previously provided in discovery. So you can't come to court with new information at the end. Basically, you have to get everything.
Right.
Yeah, but I'm just explaining that for people that may not that don't know that.
Okay.
Like,
yeah.
If you don't provide it in discovery, you can't use it at trial.
No.
And that's where she's basically fucking herself over. And if they strike her, what she has provided, then she ain't got nothing to say at trial, because she screwed herself.
The court does grant the order of $500 in attorney's fees for the necessity of having to bring today's motion. That is to be paid within 90 days of today's date.
And presentation, can we do that first order on the 23rd?
We can.
Okay, perfect.
All right, that concludes this matter.
Thank you, Your Honor.
Thank you, Your Honor. That concludes this hearing.
I'm assuming that Ms. Gronitz has no objection. She's here today with a continuance of 2 weeks. She submitted discovery. It was a review. It's Gronitz v. Bob 23-3-00344-08. I just want the chance to be able to go through that and then contact her. We did receive a bunch of stuff.
So there was also a presentation of order I don't know, I don't have an order that I've seen.
You should have an order, but it came a while ago, so we'll go ahead and send another one. It was just the order from the last hearing.
All right, if you could cover on there and just the explanation of present and that kind of thing would be good.
Absolutely, it will do.
All right, and with that, do we have Ms. Gronitz?
Yes, Your Honor, I'm here.
Anything you wanted to say?
Actually, my financial auditors are requesting 60 days to perform their audit. Ms. Winkles is certainly welcome to the 2 weeks, but I honestly believe that if this doesn't get resolved in the 2 weeks, the auditors are going to need 60 days. We have a $30,000 deficit in accounting. So I would love to work with council and find that gap and get this figured out, because I can't give her the income statement she's waiting for until this gets resolved.
And I don't know what I have, so I just asked to set it over and we can discuss it then.
Okay, so it needs to be set over to May 14. So I'll go ahead and set it to May 14, and then maybe figure out from there what, I'm not sure what the topic is to do with it.
That works for me.
So we'll set it over to the 14th and go from there.
Thank you, Your Honor.
9 a.m.
9 a.m. Are there any other agreed continuances? Agreed continuances? Not hearing any.
Your Honor, this is Amanda.
Do you have an agreed continuance?
I believe council and I are in agreement that we need additional time on this case.
Okay, what case are you talking about?
233-003-4408.
Can you just tell me the names? Obviously, Grounitz and, here we go, Grounitz and Bob. 23-3-0344-08. Ms. Winkles, are you on here? Oh, yes.
I am, Your Honor. I don't mind setting this over, to be honest with Your Honor. We just got the discovery a couple of days ago. We have gone through it, but I do plan on doing a motion to exclude certain testimony based on your last ruling. In that case, if we could get a 2-week set over, that would work with me. That way we can hear the whole thing at the same time.
All right, Ms. Grounitz, are you okay with that? It would be set over to May 28.
Yes, Your Honor.
Okay. All right, so I will go ahead and continue that matter over to May 28. And that will be at 9 a.m.
Thank you, Your Honor.
Last but not least.
Okay.
I think we have 13 or 12.
So let's.
There's 13, but there was double numbered, so.
Can you hear me, Your Honor?
Okay, thank you.
Could you let me in on the phone so I have better audio, please? 6829.
I hear you just fine.
I can't. Okay.
From a young age, I told myself I wouldn't be caught dead in a toxic or abusive relationship.
All right, Ms. Winkles, go ahead.
Yes, Your Honor. We're here, if Your Honor remembers, we've been here multiple times on discovery issues, multiple times. We've had, essentially at the last hearing, Your Honor stated that if everything wasn't turned in by the 14th, that would be it, that Your Honor would not allow any more evidence or any testimony at trial about those missing items. We submitted exactly what was missing. We did receive minor documents, but 90% of what we requested is still outstanding. Ms. Grounitz keeps saying she's going to get us more, she's going to get us more. Your Honor put a drop dead date. That has not been met. I'm asking, because of the fact that there is so much missing and only very little has been provided, I'd ask Your Honor for an order today that states that anything that wasn't given before that drop dead date of the 14th cannot be brought up in testimony, and I will file today a motion to actually exclude this specific evidence that we're talking about, so we don't have to waste the court's time today going through each individual item. But you'll see that February 2nd letter that we attached, 90% of that is still missing. So I just asked for an order that states that Ms. Gronitz cannot provide any further documentation or testimony on anything that was not given prior to the 14th.
Ms. Gronitz?
Oh, excuse me, Your Honor. When I reviewed counsel's submission, I believe she submitted an interrogatory packet of 33 pages. She has since that time received other interrogatory packages up in the 100 and some pages. She has received already all of the evidence necessary for this case that she's seen everything that I have to present on this case. What we're missing is information from her side. I'm missing her information.
Hey, that's not what's before me today at all.
Well,
that's two.
If what is before you an issue of whether or not there's additional evidence to be added, the issue I'm having is with counsel's own submissions not matching the problem. So she's arguing or will be arguing her own submissions. So she doesn't really need my information to argue against herself. Because the information she submitted to court and the information she submitted to me doesn't match the financial statements that are going under audit.
You can't
so the audit doesn't match her court reports. Then we have a different issue at hand there. So she's not waiting on information to me to match her own reports and statements. That's unfortunately the next step. I've had my information audited. I'm going to have to request an IRS audit on Mr. Bob's books because we can't come to an agreement on what's been paid by Mr. Bob or not. And that's where the holdup is. I'm filing a domestic. This is a CIR. This is about property and assets. And I've already relinquished my interest in the assets, but I'm still looking to recoup my income for my value on those assets.
That's a good point.
And that
That
value
is
can't
something
be determined when we have a conflicting civil claim, wage claim, and both of those issues are not matching the statements, and I can't get counsel to agree on values for either one. So they're contingent upon each other. I have two cases contingent upon each other, and I need a third party to come in and audit the information because the information that's presented to court doesn't match the statements. I don't know where else to go from there. I've made a request for the contract of the parties that's in Mr. Bob's possession, or he can retain it via email. Just has to email Daryl Adams, get the contract from November 21st, and provide proof of payment for the wage, the 1099s that he put into the IRS, and he can match his IRS submissions to proof of payments. That gives me a starting point on the civil claim, and then the balance remaining goes on this domestic claim. So that's where I stand. I can't give her any more information because I have no more information to use until this audit takes place. And
yes, this is just a really roundabout way of saying I'm not going to give it to you. And the fact is that I'm not asking for her to do any work or audit. I'm asking for bank statements. I'm asking for proof of agreements between the parties in writing. I'm asking for any contracts that were jointly signed by the parties. I'm asking for any bank statements or life insurance policies. I'm asking for things, tangible things that I can put my hands on, documents, photographs, things like that. I'm not asking for Ms. Gronitz to go through anything. She knows that. We've been here 6 or 7 times in this case alone and 6 or 7 times in the last case. I'm asking for the same items. They're not forthcoming. I can't set a trial unless I know what she's going to present. She refuses to give it to us. She keeps saying, you're waiting for my auditor. Well, this case has been in play, and these have been requested since September. I'm not sure why she can't have had that done, but I don't need her to audit it. I need the documents, and then we'll have our expert do it, and her expert can do it, and that's great. She hasn't even disclosed an expert, so I don't know any of this. I'd ask that essentially anything that wasn't given prior to the 14th be excluded, and acknowledging that I will be filing a motion to exclude specific evidence because it's too long to go through today. And I will give Your Honor a giant packet, unfortunately, of all the stuff that has been provided. Very little of it is useful. Most of it is like things from high school that she had, things about her mother, things that her children drew. None of that I need. I need very specific items. Ms. Gronitz knows this. If she's smart enough to handle most of this and to do audits, she's smart enough to answer the interrogatories and provide the documents that I've requested. So I'd ask Your Honor to exclude her testimony and any further document submissions from her.
Ms. Gronitz, you have continually said that you can't provide what has been requested because you need to audit. You need an audit. You need an audit. That is not what this is about. This is about turning over hard documents that you have in your possession or control, and that has not occurred. You continue on this route, well, I need to do an audit. No, you do not. You need to have turned over the documents as requested. So with that, I will grant your requested relief, Ms. Winkles. Get me an order and I'll sign off on it.
All right, thank you.
Is there an email agreement on this case? But I believe that might be our gap in information, Your Honor, because I've emailed this information. She has 1,200 documents in her possession. Per zip file drive, I have 40 requests for production folders she's been sent.
I don't know what to tell you at this point. Ms. Winkles, an officer of the court, is saying that she's not received it. So if you emailed it, then you're going to have to file proof of that to Ms. Winkles. But that's it for today.
Thank you, Your Honor.
They had a hearing on June 5th to set the date for their trial. The date was set for the week of October 7th.
Finding the right footwear for diabetes, lymphedema, or edema doesn't have to be complicated, especially when you don't have medical coverage.
All right, number 7 and 8, 23-3-00344-08, Gronitz and Bach matter.
That matter is ready, Your Honor, and we've received no reply to our new motion, and I believe the order is appropriate given all the other motions to compel.
Did you send over, and we do have Mr. Bob present, Ms. Winkles, did you send over orders for me?
Yes, Your Honor, we filed the proposed with the cover sheet, and we sent over the originals for Your Honor's signature. And that was a couple of weeks ago, though. I would have been, we've had those done for a while, so they might be floating around. We can send you another one today. I can have my legal assistant send that this morning. There's been quite a lot of things that I think it's because of training, is what I've been told. Quite a lot of things haven't quite made it into Odyssey, but that they have them in the clerk's office. But I'm not sure if this might have been one of them. It was a couple of weeks ago, like I stated.
I don't have anything, and the clerk seems to be indicating she doesn't have anything.
Okay, we'll have another copy sent over to the court, and we'll file another proposed today. Ms. Gronitz did receive copies of that proposed as well, because they were done at the same time as the motion hearing was actually set.
So I need some clarification, Ms. Winkles. I have on number 7, it says motion hearing. Number 8 says motion hearing to exclude evidence produced beyond discovery deadline and order to show cause.
Yes, so the order to show, the order to show cause is, I'm not sure where that came from, but what it was is, this is our fourth compel hearing that we had. So that was the compel was just a review set over. We still have received no information. The motion to exclude evidence, if Your Honor remembers at the last hearing, Your Honor stated that you were going to exclude evidence if it wasn't turned in, but because it was such a huge amount of evidence, I wanted there to be a separate motion so I could actually provide Your Honor, and this is the sheer amount of information that I submitted to the court was quite a lot. I wanted to supply that information prior to and give Ms. Grants the ability to obviously provide that information should she have it. It's listed out every single thing that's missing. It's like a 5-page order because of that. So those are the only two things. It would just be the review of the order compelling, the fourth one, and then a separate order excluding specific evidence, so that there's no question about what still had not been provided.
Okay, and I just want to double check, Ms. Gronitz?
Yes, Your Honor.
Okay. So, if you have video, if you could go ahead and turn the video on, please.
I don't have video capabilities, I apologize.
Okay. All right, so with that, Ms. Gronitz, at this point, the court doesn't feel like it has any choice but to grant the request of Ms. Winkles based on the limited information, plus you didn't do a reply, so I can't really hear any argument either. So that's where we're at this point. Okay.
We have court in October. I'm not sure why we're coming to address this again. Ms. Winkles understands that this is being modified due to the auditors. Last time we attended courts requested I had the auditors get involved and submit a report to court that is tied to this case. And that's what's been taking place. So why is, there was a lot of information delivered to Winkles. I'm just catching up to speed on the 1,200 pages that she sent me in regards to this case, and recognizing the deficiencies in my report to what she's claiming she's received. So there's a trend, I need to go through and audit my report to match her requests. But up until receiving this motion, I believed she had far more information than she reveals to court to have received, specifically the descriptions of the evidence. So those were separately described, and
none of this is relevant because she didn't reply. She didn't provide a response to the motion.
And that report also needs to get.
They're just letting her talk.
I've been operating out of state, and I have to secure a courier to actually get that report submitted into the court system, which I've done, and they're available next week.
Sorry, I was talking to the provider. What did you say?
I'm not exactly sure what she's requesting on this.
They're letting her talk at this point because none of the thing that she's saying is relevant.
I have up to 4 terabytes of portable
They
storage.
can't.
Which means
She didn't provide a response, so none of what she's saying matters.
This entire motion be stricken, given it's completely out of compliance with the discovery protocol under the schedule that we previously set. I've been telling her exactly what's been going on in discovery, and she hits me with this 4 months early. Trial's not till October. Now, there is information that isn't going to get added to this case, and I'm going to be withdrawing or modifying the financial documents that are applied to this case. And I would like the opportunity to change those valuations without recourse, because this case has now been broken up into several smaller cases. So we're only dealing with the asset portfolio valuation difference of the parties in this case, a list of personal property and who purchased those items. I haven't received any information of purchases or payments made by defendant. I do have his financial statement, so I can go ahead and address my financial issues. My financial issues are the reason that we're bringing court for me. I need my financial issues addressed. I've been issued 1099.
Your Honor, I'm going to object. This is not properly before the court.
Ms. Gronitz?
It is extremely relevant.
Stop.
Stop.
So, first off, you didn't do a written reply, which is what's required. You didn't do it. Secondly, I don't know what you're talking about as far as the requiring an auditor's report. Maybe Ms. Winkles knows what you're talking about, but I don't. So I don't know what you're talking about there, but there are rules that need to be followed and they have not been followed. So whether or not your trial isn't until October is, if you haven't followed the discovery rules, which is what we're here for, then that's on you. So with that, Ms. Winkles, anything?
Just briefly, I'm not sure what this auditor's thing is. That was never required by the court. I actually submitted everything she submitted to us. I did that. That's why I renoted this, just in case this argument was going to come up, to show that the deficiencies are there. I've written out the deficiencies. I've been very, very clear. I listed them in numbered format on the motion and the order, so Ms. Granath would have time in that 21 days to respond and give me them. She did not do that, so I'd ask that the order be entered today.
So the court has seen this case over and over again, and the failure of Ms. Granath to provide what is required, not to create. Discovery is not about creating records. It's about providing the records that you have. And that doesn't seem to be understood. So with that, Ms. Winkles, I will sign off on your order.
And we'll have that submitted to Your Honor this afternoon. Thank you.
This matter's done for today.
On October 1st, they had their readiness hearing, and on October 11th, they started their trial. The trial was continued for a second day to October 31st. Judge Evans issued a ruling denying any committed intimate relationship or any contractual claims. So I guess he didn't believe Mr. Bopp was her employer either.
Oh, shit. Oh my God.
Because
That's
she wasn't-
crazy.
They had a
Because
hearing
she
on
wasn't
March
able to
21st, 2020.
Finish what you're saying.
Oh, just, and I'm assuming she got nothing. Because she couldn't finish. Right?
Yeah, that's what I was trying to hear. See if I rewind a little bit. Hold on.
The trial was continued for a second day to October 31st.
Okay.
Judge Evans issued a...
Okay, so basically the order is it denied that they were in a committed intimate relationship and denied that there was any contract. So that's basically says
She got nothing.
yeah, they weren't in a relationship that required the split of assets, and there was no contract for whatever work she claims was done. And you know why that is? There could have been a contract, right? Maybe verbal to her, but she never provided anything in writing.
Right.
And things have to be, certain things like that have to be in writing.
Yep.
So I kind of saw that coming. Because if you had a written contract with someone to do work, even if you're in a relationship, you get things in writing.
Mm-hmm.
So clearly, because she never provided it, it may not have ever existed. And as far as the committed intimate relationship part, maybe she was just a fuck buddy.
Poor guy. God damn.
I mean, the fact that he had to go through almost a year and a half of litigation, because it started in 2023, and it clearly, which we can see by the dates here, the first hearing we saw was September 6th, but it looks like they went until July 2024. And it was even more after that because the trial was in October of 2024. So over a year, almost a year and a half. Like, I don't know.
I'm sorry,
to me,
but
that's crazy.
Absolute crap.
And that's why they said too, the money that he spent on this litigation exceeded the value of the items that he was trying to get back.
Yeah.
And she's the one based on what it says up here, she's the one who motioned to end a committed intimate relationship. So it was also probably, it was on her to prove that there was a relationship to begin with. So she literally, I hope he sues her ass for all them fees. All right, let's see what else they have to say so we can, like, end
The
this.
ruling denying any committed intimate relationship or any contractual claims. So I guess he didn't believe Mr. Bopp was her employer either. They had a hearing on March 31st, 2025, where Judge Evans signed the final orders and a judgment. And speaking of that judgment, Mandy was ordered to pay Mr. Bopp nearly $30,000 in what I assume are attorney's fees.
30
In April, Mandy tried to file
Well, the attorney was saying back after the third hearing that, you know, it had cost him like $25,000. Holy crap. Hold on.
documents, and she was denied because the case is over.
So she still tried
Attorney Winkles also withdrew in April, again because the case is over. Despite that, in June, Mandy tried to file more documents and was denied again. That was the last entry for the committed intimate relationship case.
I'm not the type to
Wow,
sue.
a
That is
commercial?
something we hear all the time. That's because you're envisioning suing another person.
Remember how I mentioned there was a third case for a protection order? They don't stream those, but I have the screenshots. Mr. Bopp was the one who motioned for a protection order. It took them 4 hearings, but Mr. Bopp was granted a protective order. I think we've all figured out why by this point. So the case should have been done, right? Mandy started filing motions and documents, demanding advanced lawyer fees and costs, just like she tried in the other cases. Not only was her motion denied, but Mr. Bopp countered her motion with a motion of his own to restrict abusive litigation. After several hearings, his motion was granted. Not only was the motion granted, but he was also awarded a judgment of $4,395 in attorney's fees for having to deal with all her filings. In August of 2024, Mr. Bopp motioned the court to have the restraining order extended, and although it took them 6 hearings to get proper service, in the end his extension was granted. That was the last time they were in court for the protection order case. In the end, Mandy has 5 judgments against her in 3 different cases with Mr. Bopp, totaling a whopping $45,328, although none of them show as being paid. I'm not sure she has the ability to pay a judgment, but she may have assets that Mr. Bopp can go after. She did mention owning property. I think the biggest irony here is that she's the one who filed the CIR claim, which is the case for the largest judgment against her at nearly $30,000. If she hadn't been so determined to get what he owed her, or been so difficult about the discovery process, it never would have been that bad. She did all of this to herself by refusing to listen or respond appropriately, and all she's done is cost herself thousands of dollars, and she's lost access to her children. I really hope she looks for some treatment or therapy, because it's obvious she desperately needs it. Thank you for watching.
Oh.
Hold on a second.
Wow.
All right, I just I ended my recording. So yeah, that was a lot.
God.
That was
all right, guys. I'm gonna end for today. I'll see you guys all in the next one.